today's stakeholder engagement of the Constitution Review Committee. We have had a series of engagements. I think this is the fourth week of such engagements on various thematic and cross-thematic areas of the Constitution. We started off a few weeks ago talking about land and natural resources, and then we followed with a day on local government and decentralization, public services and enterprises. The next day, independent constitutional bodies in the Council of State. And then last week, then political parties. Then last week, we took on the legislature, the executive, and then ended the week on the judiciary. This week, we started off yesterday with a conversation around economic governance, looking at a wide range of issues affecting the economy, the fiscal aspects, the monetary aspects, many other issues stemming out of mostly Chapter 13 of the Constitution and other provisions, including the National Development Planning Commission. So today's engagement is focused on rights, the provisions on the chapter of the Constitution dealing with rights, and gender, youth, and inclusion. Of course, in the course of the conversations we've had previous to today, some of these issues that we are touching on today have been discussed, in discussions around elections and political parties. We discussed issues of inclusion. There were proposals to enhance inclusion of various minority and vulnerable and marginalized and excluded groups, even including proposals around proportional representation to allow for smaller parties to gain representation, proposals around internal party democracy to make our political parties more inclusive, including proposals around gender. So we've picked up some of these issues along the way, but we thought it was still important to dedicate at least a day to focus on this area. Later in the conversation, I think from next week, we'll be talking about anti-corruption. Some of these issues will come up again. So I think what I'm trying to suggest is that we're not just going to be talking about youth or gender or rights today. We've been talking about it along the way. We had, actually during the discussion on the judiciary, there was an interesting presentation around rights and the way the courts have been enforcing it. And so some of the issues in that chapter have already been encountered. Nonetheless, we are glad that you are here today to assist the committee to focus on this subject, which is, of course, very important to us and to the process that we are embarking upon. We have a number of organizations that have submitted memoranda to the committee on this subject, and some individuals as well. So if you're here and you haven't, or your organization hasn't yet made a written submission, the window is still open, and we would encourage you to actually give us a written submission in addition to whatever it is that you would like to talk about here in person. So thank you for coming. My name is Kwesi Prempeh. I'm the chair of the committee. To my immediate right is Justice Sophia Adinyira, a former Supreme Court Justice who is a member of the committee. And to my extreme right is Professor Kwame Kakari, also a member of the committee. I think we would just have you guys go around and have the mic go around so you can each introduce yourselves, and then we'll commence the day's proceedings. So I see my sister Comfort is at the other end, so you can start the round of introductions, and then we will.
Thank you very much, Prof. Thank you for the honors tax the committee has, and we are grateful for the opportunity to make representations here today. My name is Comfort Okran. I'm with the Springboard Roadshow Foundation. I'm the executive director. We've been in the economy for the past 18 years, and we've had the opportunity to interact with a lot of young people, especially young women and persons with disability. Thank you.
My name is Saloma Panya. I'm the head of research monitoring evaluation at the Springboard Roadshow Foundation, and it's my pleasure to be here today.
My name is Jesse Ejapon. I work as the communications consultant for the Springboard Roadshow Foundation, and I'm excited to be here.
My name is Nana Ejakumedife II. I'm the paramount queen mother for Asante Mampong traditional area and the occupant of the Silver Stool of Ashanti Kingdom. I'm grateful to be here.
Thank you. My name is Theodora Williams Anti. I work with the Foundation for Security and Development in Africa. We convened the Ghana Youth Manifesto, and so I'm representing the group. Thank you.
My name is Christopher Wisdom-Fene, the National Coordinator for the Ghana Youth Manifesto Coalition. Thank you.
My name is Georgina Graves Kobold. I am an associate with Boateng Ado and Associates and Nkesia and Associates. Thank you.
Good morning. I'm Hiba Abdul Nasser, a legal research assistant, CRC.
My name is Patience Asabagna, legal research assistant, CRC.
I'm Kwesi Mperja, also legal research assistant with the CRC.
Good morning. Kwajo Appiah-Jetua, Associate Professor of Law, University of Ghana, and Regional Director, Africa Coalition for Academic Freedom. Thank you.
My name is Seth Kofi. I'm on the Democracy Hub.
My name is Vera Gloria Lewis. I'm with Democracy Hub. Thank you.
My name is Shadrach Amwa. I'm the member of the Democracy Hub.
My name is Nafiu Mohammed, a member of the Democratic Hub.
My name is Nogbeji Kelvin, the member of Democracy Hub.
My name is Rosemary Sankutin. I work with Abantu for Development, and I'm also a steering committee member of the Network for Women's Rights in Ghana.
My name is Pauline Vandipalan. I am the deputy convener for the Network for Women's Rights in Ghana.
Good morning, everybody. My name is Hamida Harrison. I'm with the delegation of Network for Women's Rights, Netright.
Good morning, everyone. My name is Shilamin Capremo. I'm also a member of Netright, but I'm also the convener for the Affirmative Action Law Coalition.
Good morning. My name is Chris Apelate. I'm here with Democracy Hub.
Good morning. My name is Loinda Messi, and I am with the Democracy Hub.
Good morning. I'm Nadine Swa, and I'm with Democracy Hub.
Good morning. Ibrahim Lukman. I'm with Democracy Hub.
Good morning. I am Ketchoffs Atengle. I'm with Democracy Hub.
Good morning. My name is Oliver Bakavomao. I'm a community mobilizer with Democracy Hub.
Good morning, everyone. My name is Gerardo de Lima. I'm with Democracy Hub. Sorry. Good morning, everyone. The name is Geraldo de Lima. I'm with Democracy Hub. I'm with Democracy Hub. The name is Geraldo de Lima.
Okay. All right. So thank you once again for making time to be here this morning. So the Constitution devotes an entire chapter before it begins to talk about the organs of the state. It talks about the fundamental human rights and freedoms. You know, in other constitutions, it would be called the Bill of Rights. And I think it is significant that that chapter is placed ahead of the chapters on the executive, the legislature, and the judiciary. I think for me, the placement of the chapter on fundamental human rights and freedoms, as well as the dietary principles of state policy and the chapter on representation of the people ahead of the organs of states suggests to me that the real emphasis is on the people, on citizens, right? Because it's citizens who bear rights. Governments don't have rights, they have power. So when a constitution makes a deliberate decision to put the citizens' rights first and citizens' representation first ahead of the executive, the legislature, and the judiciary, I think there's some signaling there that this is priority and this is important. There is primacy that is granted to the people. But how has this been realized in fact, right? So for us, for our review purposes, our interest is in the extent to which these very nice words in the text have translated into improvements in our welfare, improvements in our freedoms, improvements in our dignity, and whether or not this offers us an opportunity to improve upon what it is that we have, right? And I think that, you know, without having to do a survey around the table, I believe that most of you are here because you think that there is more that can and must be done, not only to improve upon the text, but also to ensure that what it is that has been reduced to text actually reflects in the everyday lives of the people to whom the text speaks. Right? So this is why we have invited you here to assist the committee in the work that has been assigned us. The issues here are cross-cutting. They touch on many different things. So I'm sure that we will have an opportunity here not just to talk about chapter 5 or chapter 7 or any of these things, but to raise the issues broadly, so that if you think that the appropriate place for this to find expression is in the chapter on 20 or chapter 23 or some, it doesn't matter. All of these issues pop up here and there. So if the relevant place is for us to focus is in political parties or in the public services or in any of these places, please feel free to suggest that. We are very interested in not just in identifying the problem, but in offering us very concrete proposals and recommendations so that we will be better assisted in the work that is before us. We usually start off these sessions with a presentation that anchors the conversation, usually one that touches on multiple strands of the issue and sets the tone for the day. If you don't have such a presentation, no big deal. Sometimes things can be very specific, but I think that on the balance, I think there is enough in terms of the diverse representation here. I believe that we can actually, by the end of the day, hit on all of these various issues. My instructions here say that Ms. Pauline van der Pallon, or Pallan, from Netright, is the one who will set the tone for our conversation this morning. But I think that there are many more people who will have an opportunity to speak today. Ms. Patterson, welcome. So we have been joined by Amnesty International. So
thank you, Prof, for giving us the opportunity. Before I go to the specifics of our memorandum, I'd just like to introduce those of the group here who don't know Netright, about who Netright is. So the Network for Women's Rights in Ghana, Netright, is a network of civil society organizations and individuals working together to bring a gender equity and equality perspective to national processes and advocate policy reforms which strengthen women's human rights. We campaign for women's equal rights. We draw attention to violation of those rights and create spaces for debate, discussion, and the clearer articulation of gender equity in national life. We are currently made up of 190 organizations and over 300 individual members across the length and breadth of the country. And why we are here. As women's rights organizations and gender justice networks, we believe and support the need to enhance the 1992 Constitution's ability to strengthen citizens' effective participation in governance and improved government responsiveness and accountability for its mandate. For this purpose, we believe that women's rights concerns should be recognized as vital issues that should be comprehensively appraised and addressed. Also, women should have the opportunity to participate fully in the process for reviewing the 1992 Constitution. Therefore, in September 2010, Netright led women's groups to engage the then Constitutional Review Commission at a joint forum, and we sent comprehensive proposals for the reform of the Constitution when that process was taking place. We were invited to a constitutional conference where various proposals that we made were reviewed, but we recognized, or we came to light, that when it came to the implementation of those demands, they were not incorporated into the matrix of demands that were being considered by the various syndicate groups. We are therefore resubmitting this memo to this CRC as our proposal for minimum amendments and additions that are needed to strengthen the human rights and gender equality provisions in our 1992 Constitution. Netright's interest in ensuring a gender-sensitive constitution stems from several but related angles. These include that the recognition of women's rights are human rights, which should be given all the attention and seriousness required to ensure that these rights are not infringed upon by anyone. Ghana's commitments to international instruments, conventions, as well as norms and current trends makes it mandatory for the government to ensure that the Constitution takes on board provisions of instruments such as the CEDAW. And we also contend that there is a need to recognize women's rights, women's worth beyond their reproductive roles, and to redefine our roles as strategic partners while recognizing the importance of gender equality and women's empowerment for poverty reduction and national development. The lack of institutional arrangements, such as the Gender Equality Commission to oversee the implementation of the gender equality agenda, is something that we raise. We recognize that there are some useful gender provisions in the Constitution. For example, Article 17, in which gender is mentioned in the anti-discrimination clauses, and Article 22, which speaks about property rights of spouses, although we are still waiting for the Parliament to put into place legislation that on the property rights of spouses. But we contend that there are a number of limitations in our Constitution on gender issues. The first of this is language. There is an invisibility of women because of the use of the he pronoun. And we argue that it is no longer acceptable that he refers to she as well. And there are a number of articles within the Constitution that speak to this. This is captured in our memorandum. And we also contend that there is a discriminatory provision in the Constitution which needs to be addressed. And this is in Article 7 on in terms of citizenship. There are a number of inadequate and weak provisions that we would like to draw the Commission's attention to, and these include Article 17(3) and Article 17(4). And we are contending that the constitutional review proposals need to take into account gender equality and non-discrimination, women's rights. Some of the specifics that we propose, I'd like to state. For instance, in Article 7, where persons are entitled to be registered as citizens of Ghana, Article 7(6) states that in the case of a man seeking registration, it only applies if the applicant permanently resides in Ghana. But we are proposing that the language be changed to in the case of a person seeking registration, so that it applies to both men and women. On Article 17 and on equality and freedom for discrimination, we are proposing language that says a person should not be discriminated against directly or indirectly on grounds of sex, gender, race, color, ethnic origin, religion, creed, civil, political, social, cultural, or economic status, and importantly, disability or age on any other ground. We believe that by adding directly and indirectly, we are keeping in line with our CEDAW obligations. Under Article 17(3), we are proposing that we amend the language on discrimination to reflect that discrimination will mean any distinction, exclusion, or restriction made on the basis of sex, gender, race, color, ethnic origin, religion, creed, disability, age, social, cultural, civil, political, economic status, or any other ground which has the effect of impairing or nullifying the recognition, contribution, participation, enjoyment, or exercise of human rights and fundamental freedoms in the political, economic, social, cultural, civil, or any other field. Under Article 27 on women's rights, we want to expand that. And we have a number of provisions there that we are proposing. The first will be that women and men have the right to equal treatment, including the right to equal opportunities in civil, political, economic, social, and cultural spheres. The second is that the state shall prohibit direct and indirect discrimination against women in all its forms and pursue vigorously by all appropriate means a policy of eliminating discrimination against women and promoting gender equality in the civil, political, economic, social, and cultural spheres. We are also reaffirming our call that the state should put in place affirmative action programs and measures aimed at accelerating de facto equality between men and women, and this shall not be considered discrimination as defined in the present Constitution, and shall in no way entail as a consequence the maintenance of unequal or separate standards. We are happy that we've passed an affirmative action law, but we are also reaffirming the need to adopt legislative, administrative, and other measures, including sanctions where appropriate, to redress any disadvantage suffered by individuals or groups because of past or present discrimination. We are calling on our state to take measures to modify or abolish existing laws, customs, or traditions and practices which discriminate against women. And there are a number of them if we take into account some of the things that are going on. And we are calling for measures to ensure that no more than 60% of members of public boards, the executive branch of government, and elective bodies be members of the same gender. We are calling for, in Article 27A, the establishment of a Ghana National Commission on Gender Equity. And we outline the functions of the commission to be, first, promote respect for and the attainment and protection and development of gender equality and equity in public and private institutions and in all spheres of life. Secondly, to facilitate the implementation of the Affirmative Action Law and all other gender equality policies and programs. Third, to monitor, investigate, and report on the observance of gender equality and equity in all spheres of life. Fourth, to receive and investigate complaints about gender discrimination and take steps to secure appropriate redress where gender discrimination is established. And finally, on its own initiative, to investigate gender discrimination and make recommendations to improve the functioning of state institutions in this regard. In sum, Netright is calling for an amendment to the Constitution in which references to only male pronouns and nouns should be corrected to include female pronouns and pronouns, where possible the word person substituted for this. The word sex should be listed along gender as a separate category in provisions which list grounds of discrimination, and this will help us to recognize the possibility of discrimination on account of biological differences between men and women. We are calling for the provisions in Article 17.4 to be expanded to include discrimination in the area of political representation, and there are extensive changes proposed for Article 27, as I have already enumerated. And so these are the provisions or the proposals that Netright is making to the Commission. Our colleague Sheila from the Affirmative Action Coalition is here to add.
Thank you very much, Chair. So as a follow-up to the proposals that Netright has brought, we would also like to draw attention to Chapter 10, particularly Article 93 of the Constitution, which talks about who has a right to, enter the legislature. So our proposal is that, with reference to Article 93.
Article 93?
93 of the Constitution. We are saying that there's a need to include provisions in the Constitution that will facilitate an increase in the number of women in Parliament. And this particular proposal is made based on the background to the passage of the Affirmative Action Law. There are a few provisions in the bill which were taken out because they said you can't really compel political parties, parliaments to ensure inclusiveness because Articles 93 and 94 makes provision for who has a right to enter the legislature, and there's no provision on inclusion. So what we are saying is that, with regard to 93.1, I'll just read a portion of it. It says, there shall be a Parliament of Ghana, which shall consist of not less than 140, currently it's 276. Then 2 says, subject to the provisions of this Constitution, the legislative power of Ghana shall be vested in Parliament and shall be exercised in accordance with this Constitution. We are proposing that an additional subclause should be inserted to provide a gender-specific quota for Parliament, ensuring that there's a minimum representation of women in Parliament. So we are suggesting that there should be a new Article 93.3, which should read as follows. At least 30% of the members of Parliament of Ghana shall be women. The reason is that without a constitutional quota for Ghana's Parliament, our current first past the post electoral system does not favor women's representation due to our patriarchal background, etc., in which we live. And countries which have increased women's representation in their legislature could only do so using constitutional quotas. And this proposed amendment will promote a minimum quota. Because in the history of Ghana, the highest we've ever had of women's representation, even though women have always outnumbered men in our population census, is 18.2%, which happened in 1965. Currently, we only have 14.4%. So we are saying there should be actual inclusion need for inclusiveness. And that is what MPs, during the plenary session, that was one of the proposals that they made. They said that without that constitutional amendments, the likelihood that we'll see an increase in the numbers of women using the current affirmative action gender equity law is very slim. So we need this as a matter of priority. Again, when it comes to local government, an additional proposal we have is in Article 242. This is in Chapter 20. So we are saying that there's a need also for the increase in the number of women in local governance, within the local governance system. If you look at 242, it looks at composition of district assemblies. And it says that a district assembly shall consist of the following, shall consist of the following members. One person is from each local government electoral area within the district, elected by universal adult suffrage. The member of parliament from the constituency that falls within the area of authority of the district assembly, as members without the right to vote, the district chief executive, other members. So our proposed amendment is that we propose that an additional subclause is inserted to provide a gender-specific quota for local governments, ensuring that there's a minimum representation of 30% of women in local governments. And so we are proposing that Article 242 should have an E added, which will say at least 30% of the members of the district assembly shall be women. The reason is that also, without a constitutional quota for local governments, due to the way affairs pass the post system when it comes to elections, the likelihood that we'll have an increase in the number of women is very low. In the 2023 general elections, it reveals that only 4% of those who were elected were actually women, even though, as I said, women outnumber men in the general population. We are aware that there's a policy now, there's a cabinet directive, I think from the 1998 cabinet directive, which says that the president, when it's appointing members to, when it comes to appointment of members to the district assembly, can do at least 30%. It's not enough because it's not been really strictly enforced. And therefore, there's a need for specific provisions in the constitution, which would make it mandatory as well. In addition, we are saying that in the preamble, we're also taking you a little in the beginning. In the preamble to the Constitution, we suggest that there should be an omnibus provision to be included in the preamble, which delineates a fundamental principle of the Constitution, indicating that there's a need for gender inclusiveness. So we propose that a clause is added saying, building a state governed by the equality of all Ghanaians and between men and women, which is affirmed by women occupying at least 30% of positions in the decision-making organ. So we think that if this is in the preamble, it will then reflect in the other sides of the Constitution. We give a rationale indicating that women's political participation in Ghana, as reflected in Africa's Barometer of 2021, revealed that we have in Ghana, it's very, very low. So we think that we need specific provisions to be able to address this. Again, we are saying that again in chapter 7, I think Article 43, 45, which says how the electoral system. There may also be a need for some amendments to ensure that this constitutional body, within the clauses dealing with their mandates. One would be to ensure gender inclusiveness when it comes to political parties and how they choose people to represent them. We think that we don't have specific recommendations in terms of text as to what should be included, but we have a general recommendation that there should be the need for gender inclusiveness in the work that they do. The same with the National Commission for Civic Education in Chapter 19, which is particularly Articles 231, 233, which sets up the NCCE and their mandate, which should include also education when it comes to gender inclusiveness. Netright has already mentioned the Gender Equality Commission, because currently in the Affirmative Action Gender Equity Act of 2024, Act 1121, the body that is responsible for ensuring implementation is called the Gender Equity Committee, which is based within the Ministry of Gender, Children and Social Protection. Our concern is that because of the mandate of this particular ministry, which has the mandate for gender as well as children and social protection, they may not have the time to really monitor implementation of ensuring gender inclusiveness in all the public sector as well as in the private sector. So we also support the proposal by our mother organization, which is Netright, that we need to have a gender equality commission set up within the constitution so that they will have the mandate to ensure that we have gender inclusiveness in all sectors of government and within the private sector as well. Thank you very much for the opportunity.
Thank you. Thank you very much for the presentation, those two presentations that come with very specific for the committee. Did I understand you, Pauline, to be saying that this is the same submission that you made in 2011, or has it been?
It has been amended.
It's been amended to
slightly
include,
to include some of the other issues that were not there in 2022.
All right, so we'll take one more presentation, and then we will take these two, well, three, but two in one for gender, and then we will take one presentation from Oliver, or should I have Ms. Partington do it? Is that what you are signaling me? Okay, so who starts? You, okay, good.
Hello, good morning, everyone. Great, good morning, everyone. My name is Genevieve Partington. I'm the Country Director for Amnesty International Ghana, and we're here to present also our memo to the Constitutional Review Committee. I'd like to start by introducing who we are. Amnesty International Ghana has been in existence for 50 years plus in Ghana. We are a membership-based organization, over 6,000 members in Ghana, who believe in the protection of human rights for everyone, regardless of sex, age, gender, race, ethnicity, disability, etc. And some of our areas that you are very aware of that we work on are the death penalty, prisoner rights, freedom of expression and civic space, women's rights, and equality and non-discrimination. So just a brief, because we have 15 minutes according to the agenda, and we set up an expert committee that involved expert lawyers in human rights and constitutional law, along with some of senior management of Amnesty International Ghana. And we went through specific articles. I will just present how we presented the memo to CRC, basically stating the areas that we would like to see an amendment on, but also looking at the current state of the law and also previous recommendations that were made, even if the recommendations were not necessarily seen in the previous CRC or white paper. Amnesty International Ghana, we still wanted to go ahead and make specific recommendations. So the first amendment or proposal we would like to bring up is, of course, the abolition of the death penalty. So that is just to say that it should be a life imprisonment instead of death. This is something that was brought up earlier with the previous CRC, and I believe that that amendment was kept. So we would like to push on for that amendment. We would also like to look at rights of children specifically, which is the age of maturity for persons with disability. Sorry, our document is like 44 pages, but it's quite detailed. So over here, our recommendation For the CRC report, there was the white paper, there was no position exactly on the matter, but the recommendation is that for the purposes of this article, the age of maturity shall not extinguish the obligation of maintenance, care, protection in respect of a person with a severe physical or mental disability who remains incapable of independent living or decision making. The state shall, in partnership with families, ensure that appropriate support services are made available to alleviate the burden of lifelong care, including financial assistance, healthcare services, respite care, and accessible housing for persons with disabilities and their families. Another recommendation would be on equality and freedom from discrimination. The current state of the law looks at Article 12.2, which guarantees the entitlement to fundamental rights and freedoms for every person, irrespective of race, place of origin, political opinion, color, religion, creed, or gender. And we also look at Article 17.1 and .2 of it. The recommendations, it was proposed that Article 17.2 should be amended to read as, a person shall not be discriminated against directly or indirectly on grounds of sex, gender, color, ethnic origin, religion, creed, civil, political, social, cultural, or economic status, disability or age, or any other ground. Some of the recommendations that Amnesty is making under this article is it is both practical and necessary to incorporate a broader and inclusive category, such as other vulnerable status, in the non-discrimination clause. This approach ensures that the Constitution remains adaptable and responsive to new and unforeseen grounds of marginalization. It reflects a commitment to safeguarding the rights and dignity of all persons, particularly those who may not fall within the traditional or historically recognized categories, but nonetheless experience systemic exclusion or disadvantage. Another recommendation was to task the NCC to ensure public education and awareness campaigns to promote equality, diversity, and inclusion. Another area we would like to see recommendations, amendments, is the right to fair trial. Access to fair trial and effective justice in Ghana remains a significant challenge, we must all agree. And individuals accused of crimes often face prolonged pre-trial detention due to systemic delays in the justice process and inefficiencies in criminal investigations by the police. There is no clear constitutional guarantee for free legal representation for persons who cannot afford a lawyer. This gap disproportionately affects indigent and vulnerable individuals, undermining their right to a fair trial and equality before the law. So that is looking specifically at Article 19 of the Constitution, which states a person charged with a criminal offense shall be given a fair trial hearing within a reasonable time by a court. However, it provides no specific time frames within which a person should be tried after being charged. So our recommendation is to amend Article 19(2)(f) to read, a person charged with a criminal offense shall be permitted to defend himself in person, themselves, since Netright has brought up the issue of, pronouns, through legal assistance of their own choosing, or if they do not have sufficient means to pay for legal assistance, to be given it free when the interests of justice so require. Another amendment is to 19(1) to establish clear timelines for the conduct of trials. So it should read, a person charged with a criminal offense shall be given a fair trial hearing within a reasonable time by a court. Parliament shall enact legislation establishing clear timelines to be applied to each stage of criminal trials to ensure compliance with the right to be tried within a reasonable time. And then, of course, one last recommendation for that would be the establish the Legal Aid Commission as an independent constitutional body funded from the Consolidated Fund on equal footing with other constitutional bodies such as SHRAJ. Parliament should be mandated to enact legislation within 12 months to give effect to the Commission's independence and operationalize its expanded mandate, including introducing mandatory legal aid provision for vulnerable groups, including women, children, persons with disability, and indigent persons in both criminal and civil matters. The next issue would be women's rights and gender equality, including gender quotas, which I believe Netright covered. However, I will just go through it briefly. We also wanted to tackle Article 17 and also Article 36.6, which is the Directive Principles of State Policy. It directs the states to take all necessary steps to integrate women into the mainstream of Ghana's economic development and ensure reasonable regional and gender balance in recruitment for public offices. However, there is no constitutional requirement for gender quotas or affirmative action in elective or appointive positions. Article 36.6 is aspirational and non-justiciable, lacking clear enforcement mechanisms or targets. There is no constitutional or statutory requirement for political parties to promote gender-balanced candidate selection or leadership. So the recommendation, which is also something CRC recommended previously, was the 30% gender quota. So we are just looking at the gender parity principle, which is similar to the Kenyan Constitution, to amend Article 36.6 to read, the states shall take legislative and other measures to implement the principle that not more than 2/3 of the members of all elective and appointed bodies shall be of the same gender. This formulation establishes a clear constitutional obligation for both appointive and elective bodies without setting a fixed minimum quota, while requiring proactive steps to ensure gender balance. We're also proposing to introduce a constitutional requirement for political parties to comply with the 2/3 gender rule in their candidate nomination processes. So a proposed provision would be political parties shall ensure that their nominations for elective offices comply with the principle that no more than 2/3 of candidates shall be of the same gender. Right. Oliver, would you like to take over? I was hoping you would anyway. So the next one is property rights of spouses. So there's a lack of clear and comprehensive legal framework governing the property rights of spouses in Ghana, which has led to widespread injustice and economic insecurity, particularly for women, despite constitutional recognition of spousal property rights under Article 22. Parliament has failed to enact the necessary legislation to regulate these rights more than 3 decades later. As a result, the determination of property rights upon divorce and death of a spouse is inconsistent, often left to judicial discretion, and influenced by customary practices that, of course, disadvantage women. What is our recommendation? As the government white paper did not state a particular position, we are recommending that the Constitution should be amended to explicitly recognize and guarantee property rights of spouses, including the equitable distribution of marital property upon divorce or the death of a spouse. We are also recommending that we introduce a presumption of joint ownership of property acquired during marriage, regardless of whose name is on the title or who paid for the property. Parliament should be mandated to enact comprehensive legislation within a specified time frame, example 6 months, to give effect to the constitutional guarantee regulating spousal property rights in a manner consistent with principles of equality, fairness, and non-discrimination. The law should cover both civil and customary marriages and recognize the rights of spouses in informal and cohabitating relationships where equitable contributions can be demonstrated. We're also recommending that the Constitution provides for effective judicial remedies to enforce spousal property rights, including access to legal aid and simplified court procedures for vulnerable persons. Again, we've redrafted, we've done a proposed amendment. It is quite long, so I'll skip that. The next area is economic, social, and cultural rights. The Constitution recognizes economic, social, and cultural rights, including rights to education, health, shelter, food, and work, only as part of the directive principles of state policy. These rights are generally considered aspirational and non-justiciable, meaning they cannot be directly enforced in courts. This weakens the accountability of the state in delivering on these essential human rights and perpetuates inequality, poverty, and social exclusion, particularly among marginalized and vulnerable populations. What is our recommendation? Amnesty International is recommending that the Constitution should expressly recognize economic, social, and cultural rights as fundamental human rights with the same legal status and enforceability as civil and political rights. The rights to education, health, housing, food, water, work, and social protection should be made immediately justiciable, allowing individuals to seek redress in courts when these rights are violated or unfulfilled. The Constitution should impose a clear obligation on the states to progressively realize ESCR using maximum available resources in accordance to Article 2 of the ISESCR. There are other recommendations, but this kind of summarizes it. Next one. So sorry. Access to justice and legal aid. There is a systemic lack of access. The systemic lack of access undermines the rights to a fair trial, equality before the law, and effective remedy. Rights guaranteed under our Constitution and international human rights instruments. The inability to access legal aid perpetuates injustice, denies victims of human rights abuses redress, and compromises the rule of law. So this is looking at Section 10, 1 of the Legal Aid Scheme Act, which is Article 294 of the Constitution. And Amnesty is recommending, again, which is something we've already spoken about, that the Legal Aid Commission should be established as an independent constitutional body. We are also recommending a mandatory pro bono scheme should be instituted as part of professional obligations for all practicing lawyers, overseen by the General Legal Counsel and enforced by the Legal Aid Commission. Now I come to a very important issue, which is sentencing of pregnant and nursing mothers. The current legal framework in Ghana does not provide adequate protection for the rights and welfare of pregnant women and nursing mothers who are accused or convicted of crimes. There are no clear constitutional or legislative safeguards that consider their special circumstances during sentencing, imprisonment, or detention. As a result, pregnant women and nursing mothers are subjected to custodial sentences that affect often expose them and their children to harsh prison conditions, infringing upon their rights to health, dignity, and family life. I would like to say that the previous CRC found that there's already a provision for the conversion of the death and custodial sentences of pregnant women who have committed non-capital offenses to non-custodial sentence under an amendment of the Criminal and Other Offenses Act in 2002. The white paper was silent on the issue, and the CRCC was also silent on the issue. However, Amnesty is proposing that it be amended. We need to amend the directive principles of state policy to include Rule 64 of the Bangkok Rules, officially the United Nations Rules for the Treatment of Women Prisoners and Non-Custodial Measures for Women Offenders, to the effect that non-custodial sentences for pregnant women and women with dependent children shall be preferred where possible and appropriate, with custodial sentences being considered when the offense is serious or violent, or the woman represents a continuing danger, and after taking into account the best interests of the child or children, while ensuring that the appropriate provision has been made for the care of such children. The next point is rights of persons with disability. Despite Ghana's ratification of the United Nations Convention on the Rights of Persons with Disability, the Constitution lacks comprehensive provisions to protect and promote the rights of persons with disability. The legal gap perpetuates systemic discrimination and exclusion of persons with disabilities from accessing education, healthcare, employment, public services, and political participation. A few things. Article 43, for example, guarantees voting rights but does not mandate disability-inclusive voting measures, for example. Previous recommendations have been made to, for example, expand non-discrimination clause to include disability, review the Constitution to change references to disabled persons to persons with disability. And Amnesty is recommending that Article 17 of the Constitution to explicitly prohibit discrimination on the grounds of disability in the manner above suggested, and introduce a constitutional provision in Chapter 6 guaranteeing the right to accessibility, mandating both public and private entities to ensure that infrastructure, transport, information, and services are accessible to all PWDs. I am very passionate about this clause because my son is a wheelchair user and it's very, very difficult to get around in Accra. Another proposition, freedom of expression and media rights, Chapter 12 of the Constitution. Freedom of expression and freedom of the press are explicitly guaranteed under Ghana's 1992 Constitution. However, in practice, several issues undermine these freedoms, particularly for journalists and media practitioners who report on sensitive or critical issues. Journalists and media houses often face political pressure, intimidation, harassment, and in some cases, physical violence. Media regulatory bodies such as the National Media Commission lack full independence and enforcement powers to protect media freedom effectively. So the current law, which is Article 21, protects freedom of speech and expression, including freedom of the press and other media. Some of the recommendations we are making are enhance the independence of the National Media Commission. This is very important. So that means we need to amend Article 167 and Article 168 to ensure the National Media Commission is insulated from partisan influence. We need to empower the NMC with enforcement authority and guarantee freedom of expression in the digital sphere. Strengthen protections for journalists and media practitioners. Commission on Human Rights and Administrative Justice. I'll go straight to the recommendations, which guarantee adequate funding and financial autonomy through the Independent Constitutional Bodies Fund, make SHRAJ decisions binding subject to judicial review, appoint special commissioners for vulnerable groups. So these are some of the recommendations we are making in terms of the Commission on Human Rights and Administrative Justice. I'm almost done. 2 more points. Right to health. The Constitution provides limited protection under Article 30, rights of the sick, which focuses narrowly on persons unable to support themselves due to infirmity. It does not guarantee an enforceable right to health for all persons, including access to healthcare services, mental health services, emergency care, and protections against discrimination in health. Mental health rights are almost entirely overlooked in our Constitution. While the Mental Health Act of 2012, Act 846, establishes statutory protections, constitutional silence on mental health facilitates discrimination, forced institutionalization, and neglect of mental health services. So as I said, there are a number of laws covering mental health and right to health. National Health Insurance Act, Article 30, rights of the sick. However, again, there is no constitutional recognition of the right to mental health care. So, Amnesty International is recommending replacing Article 30, rights of the sick, with a comprehensive right to health provision. Also, in Chapter 6, further this right can be fleshed out to guarantee universal right to health care. Every person shall have the right to the highest attainable standard of physical and mental health. The state shall ensure the availability, accessibility, acceptability, and quality of healthcare services for all persons as an integral part of the national healthcare system. Mental health rights. Persons with mental health conditions shall have the same legal protections as persons with physical disabilities. No person shall be subjected to forced institutionalization or medical treatment without informed consent, except where a competent court of law determines that the person poses an imminent or serious risk to themselves. There are other recommendations, which I will skip. Lastly, I believe, there's also right to education. Okay, almost there. Paternity and maternity leave. What is currently in the Constitution is in Article 27, which provides special care shall be accorded to mothers during a reasonable period before and after birth, and during those periods, working mothers shall be accorded paid leave. This provision is very vague and does not specify the duration or enforceability of leave entitlements. The Labor Act 2003, Act 651, Section 57(1), entitles female employees to a minimum of 12 weeks maternity leave with full pay. The law does not extend any statutory paternity leave to fathers. So, of course, we are recommending that we amend the heading of Article 27 from women's rights to gender rights to reflect the inclusive protection of all caregivers, including fathers. Amend Article 27(1) to reflect CRCC's recommendation adopting for instead of during, ensuring clarity and better framing of parental rights in general. So incorporate workplace childcare facilities with inclusive language that acknowledges caregiving roles for both mothers and fathers, remove gender stereotyping language, and promote equal caregiving responsibilities between parents. Right to education.
Done? You said last
Almost.
Yeah.
So we have
But
right to
if you have
education.
already done the written submission, unless it's
Yes.
something that's radically new.
I would still like, so there are two more. Yeah, I think we need to go there. So let me skip to, because right to education, I think it's clear, but I would like to skip and go to my last point, which is the inclusion of queen mothers in the House of Chiefs. The traditional governance system in Ghana, as formally recognized by the Constitution and the Chieftaincy Act, is predominantly male-dominated. Queen mothers, who historically play significant roles in leadership, advisory functions, and social development within their communities, are in practice excluded from formal representation in the national and regional House of Chiefs. This exclusion undermines gender equality in traditional leadership and prevents the House of Chiefs from benefiting from insights and contributions to female traditional leaders. We all know we do make good decisions, and sometimes our advice is best. The absence of queen mothers in these houses limits women's representation in formal traditional governance and contradicts the principle of gender equality enshrined in the 1992 Constitution. Amnesty International Ghana is proposing that the definition of chief under Article 277 be operationalized by ensuring queen mothers' representation in all chieftaincy institutions. We would like that Article 271 is amended, renamed the National House of Chiefs to the National House of Chiefs and Queen Mothers. And review all constitutional provisions where the national and regional houses of chiefs are referenced and updates to include queen mothers. Yes, and I will end here. Thank you very much for your attention. It was very important that I speak on certain issues. So thank you so much, Professor.
Thank you very much for this very comprehensive contribution to the conversation. We do have some time. On the original plan, we were supposed to take a break for coffee, but let's probably stretch that to 12 so that we can take on the issues that have been laid on the table or on our plate, and then just try and engage some of the issues, maybe looking for clarification and others. So the protocol usually, the committee members will follow up the presentation by asking a few questions, and then after that we will invite the audience also to pose some questions if they have any. So I can start. There are a number of issues. So on the issue of representation in the legislative body, both national and local, the proposal is to set a minimum of 30%. Was it 30 or 50? 30. So the minimum is 30. What I did not get is the mechanism by which we achieve that, right? So it's an elective body. An appointed body probably easier to do because then the obligation is on the appointer to comply with the minimum quota. But if it's an elective body, there has to be some mechanism by which we achieve that goal, right? Or by which we meet that threshold. But I don't see a companion proposal of an electoral system change or an obligation on Parliament to enact, for example, legislation that will create such a mechanism. It's probably easier to do in the Constitution. There have been some proposals around proportional representation on a party list basis and all of that. Do you guys have clarity on any of those kinds of mechanisms, whether at the local or national level?
Thank you very much, Mr. Chairman and members of the CRC. So for the proposal we are making is that once it is in the Constitution, then legislative response would have to follow. We would then need some law to ensure that this happens. Yes, ideally, if the proposals for proportional representation is accepted, that would make it very easy to have it implemented. But in a country like Sierra Leone, I think in 2022, their background was a similar legislation like we do have. They managed to come up with some proposals for some kind of a party list, so that for every appointment, a list had to be provided. They also had the first past the post system of elections like we do have, but they modified their electoral laws to ensure that there was some form of an element of proportional representation within that particular, their political party law. So I think that we can learn lessons from how other countries have done it. Like I said, the latest of which is Sierra Leone, to see how they managed to do it. And I believe that once we have the constitutional provision, then we can push for appropriate legislation, meaning the Electoral Commission Act would have to be modified to ensure that this is done. I think that in our presentation, we also mentioned the need to look at the Electoral Commission itself. Once this at least 2/3 or 30% representation thing is at both the national level and at the local government level is accepted, it would lead to consequential amendments to existing legislation to ensure that this happens. Of course, once it's also done, then it will be easier to then amend the Affirmative Action Gender Equity Act, particularly Section 20, of which deals with political parties. Currently, the section I'm talking about, Section 20 in the Affirmative Action Gender Equity Act, indicates that political parties are also supposed to comply with the indicators at the back of the law, which is by the year 2026, they should have achieved 30% representation. Then it says that by 2028, you should have achieved 35%, and by 2034, it should be 50%. We are saying let's look at 30, because that's the minimum the UN requires for representation. And the thing is, in the law is now, as it is now, there are no sanctions. It just says in their manifestos, etc., they should make sure that this is done. In their representation within their party structure itself, it should be done. When it comes to nominations, etc., there are a few strategies at the back of the law in the schedules. But we believe that once this is done, then it will be easy to go back to this law to amend it, and then there'll be the need for other consequential amendments to the political party legislation and other things to let it happen. So the mechanics itself, we didn't put in our proposal, but we believe that once the principle is there, that there's a need for inclusiveness, then necessarily to lead to other consequential amendments to existing legislation or even some new legislation to make sure that this happens.
Yeah, I think from our experience, stating the principle alone, even in the Constitution, obviously is not enough, right? Because it's, especially if you're looking at getting this through an elective process, no court will declare an election unconstitutional simply because it did not produce 30% minimum women, right? So unless there's a violation of a particular process that must be followed, so I think that it's helpful to have a companion process that you believe would help us achieve the goal. You've referenced Sierra Leone, now we can take a look at it, but if you could actually supplement your written submission with some very clear recommendation on the mechanics, that would be helpful, because without that companion process, the goal will be hanging, and I doubt that a court would necessarily throw out an election simply because it did not produce a minimum of 30% women.
Thank you very much. We've taken the cue, and I'm sure we'll bring an additional proposal. But my colleague would also respond.
I just wanted to acknowledge the work that is being done by the Constitutional Review Committee and add a little bit to what my colleague has just said in reference to the mechanism that could be used. I think that studies have shown that in countries where there is a semblance of equal representation of women and men in legislatures, the mechanism or the system that has been most effective has been the proportional representation system. And therefore, if this process is really looking at transformational change, then we as representatives of women's organizations, gender equality and inclusion, will align ourselves to the recommendation that has been made in reference to proportional representation as the frame of reference for enhancing equal representation. Having said that, there are also, under the proportional representation system, there are different ways of ensuring that women actually filter through the electoral system so that the numbers that we are looking for or the representation that we are looking for actually filters through into the system. So it all depends on the political will and how far we would really want to go with this constitutional review process. But we align ourselves with the proportional representation mechanism. Thank you.
Yeah. Well, as far as we are concerned, we are not limited in our mandate to nothing is off the table. I think it eventually becomes a matter of the political process, what it is that can be realized politically. Of course, at some point in the process, we have to have a roadmap on how to achieve all of these proposals. Many of the things we are talking about today are entrenched. Right? The chapter on the Bill of Rights, on the fundamental human rights, everything there is entrenched. So that is part of the constraint we have to deal with politically in terms of how you put all of this together into and post the question to a referendum. That is not the only portion of the Constitution that is entrenched. Almost the entire chapter on the executive is entrenched. So there are a lot of proposals that are coming that would like to see major changes made to parts of the Constitution that are entrenched. And so it's a matter of how you process that and present it to a referendum. If you have 30 proposals on fundamental human rights, and you have 20 proposals on the executive, and you have 15 proposals on the judiciary, the question is exactly how are we going to formulate that? And I think that's part of the challenge where at some point, we may have to, call some of you to come back and advise us exactly how we process that kind of change. Maybe this is why Oliver thinks we should just throw the whole constitution out and start a new one. Because, in fact, mechanically how you process this is something that we have to think about at some point. For Amnesty, the question about this presumption. So you say we should amend Article 22, which has to do with the property rights of spouses, to establish or to create a presumption of joint ownership of property acquired during marriage. Would this, when you say presumption, you mean it to be rebuttable, or is it conclusive? It's a presumption, but then you go to court, and it's good that you have a presumption to start with, but is it a presumption that can be rebutted with evidence to the contrary, or how are you thinking about this?
Since I'm wearing two hats here, I'm part of the Amnesty team as well. Perhaps I can speak a little to this. I think that the thinking of Amnesty on this is a way to crystallize some of the jurisprudence that is emanating from the courts on this, knowing that there's still the danger that it can be reversed through legislation, that perhaps that would crystallize it better. But also you have to allow room that peculiar circumstances would arise that doesn't necessarily fit the narrative. Persons could be legally married, but would have perhaps not lived together or combined assets or done anything towards that. That there should still be some room that allows for the presumption to be rebutted, as you have said. The question that remains for us is whether that then gives the courts a nod to determine, how high the burden of rebutting the presumption looks like and what that, but at least would have consolidated again and then moved on from there going forward, we think.
I mean, given the broad international presence of Amnesty, I think it would be helpful to the committee. So on some of the proposals that you make, let's say on the mental health issue, we have a big mental health problem in Ghana. So far, of course, I would add street children. Nobody has mentioned that yet. I would like to have some reaction on that. But do you know of any of the jurisdictions where you operate where that has done well on this matter of mental health? At the minimum, to obligate the states not to just look on as people with obvious mental health problems, just roam the streets, naked. I mean, is there at the very minimum, if you can't attain, all of the stuff that we're asking for, at the minimum, do you know of a jurisdiction that has been successful using, legislative or other means to get the states to respond to this particular mental health issue? And, not just to round up people and institutionalize them, but at the very least, to make sure that when you are put on notice very clearly that this is a mental health issue, that there is some state action that responds to it, and that we don't have this problem of just people with obvious mental health issues just being left, to roam the streets. Sometimes they pose a danger to themselves and to the public, and all of that. If there is a jurisdiction where Amnesty works, where they have been successful in doing this, maybe the model that was used could be helpful for our purposes. Then to think about the street children problem, right? It's not been, it's clearly a complex human rights problem as well. I was wondering if either of your organizations, whether it's Netright or whether it's Amnesty, has looked at that issue, and whether or not there is a way to help us think about it in terms of trying to sort out that problem. And then I think that would be probably my last. So on this Gender Equality Commission, right? So, we are, as a committee, among the very first things we did was to establish a set of principles that would guide our work. And, one of them was to avoid the proliferation of states' bodies. We know that you can create these institutions and then they will not be funded, right? So the state will just pay their salaries and then you just sit there. There are many of those commissions that have already been established, and they are going through that now. So there is Shraj, right? It may not be working optimally. It does. Human rights is the first of its mandates. Is there a way that Shraj could be reconfigured so that it could give focused attention or priority to the issues of gender equality? So, for example, if we said in the Constitution that Shraj shall have, a certain number of divisions, the following divisions, and that one of them, maybe anti-corruption is one strand, but another would be human rights and gender equality. Now, if you have it in the Constitution and you assign a commissioner to it, that would be one way of giving dedicated attention within the structure to the issue, right? And then, of course, Shraj is already there, it's funded, it's going, so you can at least be assured that there is some funding for it to deliver on its mandate. But my fear is that if you create another body, especially when you don't have a funding mechanism to support it, then it's very easy for them to, it's very easy for those who appropriate money to just turn it into another NCC that's there. It's not giving money beyond its recurrent expenditure or even just salaries, and then just sitting there and not doing work, right? So are there alternative ways of achieving the same mainstreaming of gender, the same focused, dedicated attention to gender equality issues without creating a new body in the Constitution that may suffer the fate of other bodies that have been created but have not been funded? The legal aid issue, again, a legal aid commission is also proposed similarly. How is it to be funded? Do you have some ideas on, I like the idea about pro bono, a law passed by Parliament, that would include requiring the legal profession to offer a certain amount of pro bono legal services, part of the way you can fund the legal aid commission. But if you had a legal aid commission, do you also have a way of funding it? I don't know. Those who violate, human rights, should we be finding them and putting the fees in a fund? Should we be, if we can find a way to fund some of these obligations, or create a companion fund that helps us to do that, I think it would be helpful. I like one of the proposals about rights of children with disabilities, that the age of majority shall not extinguish the obligation of the state to do something. It sounds a very attractive formulation. How do you operationalize it? Because it's one thing to put something in the Constitution, and then it's another to, sometimes for these kinds of obligations, if it's further fleshed out in legislation with clear, obligations or duty bearers identified, who is it that must do this, who is that, because part of the thing about the Constitution is that if you say the state must do that, right? But who is it that must do it, right? And sometimes that makes enforcement difficult if you can't just name a particular entity that you go to and say, it's your obligation to make sure that this is done, and you are neglecting to perform that obligation. And usually statutes can do that with more specificity, right? So even where there's an obligation on the state and on the Constitution, it's helpful if you have a statute that takes that rule or principle and then assigns it the obligation to a particular duty bearer. So maybe if you could also help us with, in terms of your thinking around this, how do you think it would be operationalized so that there's a clear duty on somebody who can be held accountable? Thank you. Our justice has a long history of working on children's issues especially, but of course having spent a whole lifetime on the bench on others. But I know that he has a big passion for children's rights issues, so you guys are in trouble here.
Usually when we talk about new rights like economic, social, and political rights, the answer is look at Article 33.5, which says that the rights, duties, declarations, and guarantees relating to the fundamental human rights and freedoms specifically mentioned in this chapter shall not be regarded as excluding others not specifically mentioned, which are considered to be inherent in a democracy and intended to secure the freedom and dignity of man. So The problem with this is that although it guarantees that any new rights like economic rights, social rights, which now is becoming a problem everywhere. People need land to build, want to move out of slum areas. Perhaps if they rely on this clause and you go and meet a judge who is not open-minded, you may not be able to persuade a person. So I feel that perhaps to simplify matters, we should add to this clause that where, let's say, Ghana signs any UN convention or something in relation to this, automatically it has to be enforced. Once Ghana signs it, it doesn't even have to include it in local laws, so that automatically it is applicable. And then another way too is that we look at existing enactments like Children's Act, Juvenile Act, and see areas where we can tighten, and then look at the enforcement and then sanctions for non-compliance. Another area too I want to say something about this question of paternity leave. We have considered it in certain institutions when they are revising their conditions of service. So the problem was that we are in a polygamous society. So if a man has 3 wives and he can go on maternity leave more than the woman who is working in that establishment. So when the issue comes out, it is dropped. Because even if you say the man should register one of the wives, it's also a problem. And it's the same problem which crosses out with this spousal rights. We are a potentially polygamous society. So how many wives will be entitled to a property acquired during a marriage? And most of the time, it is only one who is staying with the couple. So is the other 3 coming to share in this matrimonial property left by the husband? And then also this presumption of joint ownership. Well, sometimes when evidence is always applied in the cases, because one of the spouses will lead evidence to show that she or he contributed. And now we move from monetary contribution. And even ancient, earlier cases on succession, the contribution may not be monetary. Let's say the woman will be in the house cooking for the laborers, and it's considered as a contribution. But nowadays, since women are now working, they can even prove that they contributed monetarily. But the problem is the registration of the property in whose name. And the problem always comes out during divorce and distribution after death. So we have to educate our women and our men too that when you are going to register a property, at least if it is for you alone, you should make sure that the other spouse is aware. But it's a problem. I'm just talking theoretically, but. And then this proportionate representation in governance. I will use the word governance broadly. In fact, it has been, I think, some of us are thinking that perhaps in this case of the legislature, that like the district assembly, if we come to a consensus that should be by election, then that's an area where we can start immediately. That one, perhaps by legislation, that the elections, it should be on proportional basis. And perhaps the political parties, we have to tell them that if you are going to participate, at least your candidates should include this percentage of women. That would be another way. Then before, later, perhaps the main legislature, that too can be applied. But what about this affirmative action bill you passed? Because you mentioned some section relating to political parties. As it is, it hasn't been put into practice. Do you think the positions are too weak? And if there are no sanctions against political parties, can't you put that there? Because it will be easier than waiting for constitutional amendment. Because most of these are entrenched and it takes a long process, and then you can't, we are going to almost amend every section, and it will take, most of them are entrenched. And normally you cannot take more than one issue to a referendum. And it will take many years before we can amend everything. So perhaps this assembly elections can be one which can go, if you have the consensus, which can go, and we can start from there for women representation. And then, okay, about non-custodial sentences for the pregnant and lactation women. It has been a problem because sometimes, due to the nature of the offense, you cannot let the woman go home. And then you try to look for a family to take the child, but nobody is willing to come forward. I faced that problem before, so the only alternative was to reduce the sentence. But looking at the nature of the offense, even it was unfair to the complainant to reduce the sentence so that the woman will not remain long there. So we have to look at a way of solving that. And I think if this thing, it can be amended and put in the criminal procedure code easily. An amendment there instead of putting it in the constitution. So putting it in the so most of the things you are recommending today, perhaps you must look at the criminal procedure code, Accords Act, and then various acts like Children's Act and the rest, and do an amendment which will be easier and faster. So this is my take for the moment.
Thank you all for your very important and in some ways eye-opening contributions, and I must say also comprehensive contributions. I have a number of comments and questions. One of them, I think, Justice has dealt with it, but it has to do with the sentencing of women. What struck me was that in the proposals presented, I didn't hear anything concerning what to do with a child or children who are victims of, say, a violent single mother. What do you do with them? But I think what her ladyship has educated us on might be useful. Also, the thing about political parties and gender quota. My question is, how do we enforce it? And what sanctions if the parties do not comply? There has been here a proposal for the establishment of a political party regulatory body where it should be placed. As the chairman has said, you don't want to inundate our situation with too many institutions because we know what that means. So how do we enforce that, knowing that political parties would almost always have the easy way out? I remember that one NDC women's organizer once said on a radio program that if you left the political parties alone, they might even make a man the women's organizer. So we have a problem there. The proposal to make economic, social, and cultural rights justiciable, do you mean to look at those sections that are easily made so, or are you talking of taking all what the Constitution says and making them justiciable? In other words, there are some cultural things that can only be implemented, enforced by education, and so on and so forth. Now, for instance, take, just as an example, Article Article 39, Article 39, 2 and 3. The state shall ensure that appropriate customary and cultural values are adapted and developed as an integral part of the growing needs of the society as a whole, and in particular that traditional practices which are injurious to the health and well-being of the person are abolished. The second part about injurious traditional practices, I think, is easy to put into law and to enforce. But ensuring the appropriate customary and cultural values, how do you enforce something like that by law? The state shall foster, 3, the state shall foster the development of Ghanaian languages and pride in Ghanaian culture. It's here, but our schools don't teach our language anymore, our languages anymore. We don't use the language for anything. I'm an advocate that it is used in Parliament, it is used better, properly in our courts, and so on and so forth, in our public space, but who is to do that? If this can only be done by government, if it is not done, who are you going to take to the court? So I think that proposal, you probably need to tweet it and help us. On including queen mothers in the houses of chiefs, I think it's a very laudable, to me, it's a very, very important proposition. However, what would you want to achieve by sending queen mothers to the houses of chiefs? What do the houses of chiefs do that sending queen mothers there would improve in our governance system, in the role of chieftaincy, in all the different things they are supposed to be doing? Because we just don't want to put women in all places simply because we want women there. There must be some value addition to promoting women's participation in other, unless, of course, one is cynical to say that, there was a report of a woman who was corrupt. He said, yeah, I mean, if there's going to be corruption, women too should be involved. But is that why we would promote, women's participation in the public space? And the National Media Commission's powers of enforcement, you said, to enhance their independence. Perhaps you need to elaborate that, because as far as I'm concerned, it is quite independent. Its problem is the second part you said, that it should be given some powers to regulate media content better, so that we can have a better media environment for a society like ours. The first newspaper was established in 1822, but look at the standard of journalism in our country. It's largely because there's no proper democratic regulation of media. So every kind of thing goes on television and so on and so forth. So it will be helpful also to assist us with that. Mr. Chairman, my last point is, in all of the different things that have been proposed concerning gender and so on, I would like to know from our friends, to what extent has the establishment of the Women's or Gender Ministry been? How useful has it been, or otherwise, in promoting or advancing positive gender development? Because I don't know whether it's because it's a governmental institution or what. Much of what you have put out here, vicariously, is a critique of the establishment of that ministry. So I don't know. What do you think? Has it been that useful? If not, what can be done to improve it? Or must we get rid of a ministry and go back to the National Council of Women and Development or something like that? In other words, since there's been some proposition about institutionalization of some of these things, what would be the more effective and proper institutional framework for promoting all these rights, gender rights that we are talking about? Thank you. Okay, so maybe two comments following up on Professor Kwamkakari's. One on the chieftaincy issue. Maybe, and I'm sure, not maybe, I'm sure that Nana Hema will assist us in due course when she makes her contribution. As I understand it, the regional and national houses of chiefs are creatures of law, state law. They do not exist outside of the constitution or legislation, because in our traditional setups, we don't have regional houses of chiefs or national houses of chiefs. These things come from the colonial period, provincial councils, joint provincial councils, and then after independence, we made them part of our national constitutional architecture. So to the extent that they are creatures of the state and not something that exists independent of the state, I'm sure that the state is within its powers to prescribe the nature of its membership, the nature of its mandate, and all of that, at least at the regional and national levels. I do not know about the local traditional councils at the local level, whether they too are creatures of state law or whether they exist under custom, separate from state law. But I think to the extent that the regional and national ones exist as a matter of state law, I believe that how they are constituted and what functions they play, what roles they play, what powers they have, matters that are within the remit of constitutional regulation. So, and of course, they do have some roles in the Constitution, adjudicatory roles, some other advisory and the like. So I think, there is something that can be done there. My interest, which you can answer later on, is one in how it connects downward to the traditional council at the local level, right? If you have regional and national houses of chiefs, and those ones have to be have to include queen mothers, how does that play out at the traditional council? I don't know whether every traditional council in the land has that kind of custom or system, whether queen mothers are actually universally a Ghanaian thing, or whether queen mothers are, culture specific in terms of, ethno-regional cultures and stuff like that. So, maybe some nuances around that, I think you could help us with some insights on that. On economic and social rights, I think, to make the proposal more complete, I mean, the obligation on the state to do these things, usually when you leave it hanging and you leave it for courts to enforce them, common law courts have had difficulty enforcing economic and social rights because of the fact that they, of course, always involve a budgetary obligation. But maybe you could look at how South Africa has done it. Because normally the obligation translates into an obligation, one, on the legislative arm to pass a law that makes that obligation realizable, and then two, for the executive to follow up with an administrative structure that implements that. So, before South Africa, actually, there was, it was a highly contested issue in legal scholarship, and especially even in some of the advanced constitutional cultures did not have a way of handling social and economic rights. So they said it's not justiciable, it's nice, but you can't do it. Until the South Africa Constitutional Court came in with this interesting formulation where someone had gone to the court standing on a right to housing. And the court says, well, yeah, you have a right to housing, but it doesn't mean if you're homeless and you appear before us, we can command the state to give you a house. But we can command the state, based on that right to housing, to enact a framework, legislation, and then to translate it into executive action, administrative action, action plans, budgets, and those kinds of things, so that you can actually realize it. But it's not a portable right where you go and then you can be given a house each. But the state must have a low-income housing scheme, something like that, right? It must pass a law that makes it possible to have a low-income housing program that must be funded through a budget, that must be, so that there are ways in which this can be made actionable. So maybe you could look at how the South Africans have done it. It's not directly, it was in the Constitution only as a right to housing or something, but if you can find also, of course, we too can find it, but if we can find the way to make it implementable in this way, then it's easier, and then it saves the courts the trouble of trying to find a way to either dodge the question or do that. So I think that's one model you could look at in order to advise us on how we actually implement it, if that is a right that's going to be in the Constitution. What we should do is take,
Following your intervention now, just a small comment about the Queen Mother's roles. The Queen Mother's roles, even traditionally, have been what you might call a backseat. However, the Asante Hima sitting in Manchia has a very pronounced and a very socially progressive role. She has a court, and the Asante Hima's court is for domestic affairs, children, and what we call domestic relations and so on. That's what she did. The Asante Hima's court deals with her own courtiers and traditional judges and so on, handling these very important social questions. Perhaps the role of Queen Mothers may be better defined to include aspects of this role. And it doesn't even have to be put into law. It can be a convention that Queen Mothers do. Or if Queen Mothers are to go into those houses, they may go in there with particular agenda of improving chieftaincy when it comes to some of these social and cultural questions. Because I believe that if Queen Mothers went there, knowing women and their capacity to influence positive things, it's possible that with a clearly defined social cultural agenda, they may make these houses of chiefs more visibly progressive and productive in our lives.
I think this issue of queen mothers needs to be clearly articulated, because we know that in some areas, at least in the Fanti areas, there are some places where the chiefs are women. And I think the National House of Chiefs years back said they have no suggestion. If the woman is a chief, then it can be in the Regional House of Chiefs. And if he's nominated or elected to go to the to go to the National House of Chiefs, no problem. That was when the debate started. And then there was also suggestions that what about creating a separate house for them in the Regional and National House of Chiefs. So I think we need better clarification now as the condition now. Whether all queen mothers want to be in the Regional House of Chiefs, and then are they paramount queen mothers for them to go to National House of Chiefs? Because there's limitation there. You have to be a paramount chief before you can go to the National House of Chiefs. So perhaps going to the Regional House of Chiefs would be easier, but are they paramount chiefs? So that's the problem. So they have to articulate it more clearly in terms of the Chieftaincy Act, as the definition goes. Who is a chief? So if you fall into the definition in the Chieftaincy Act, then you have every right to be a member of that Regional House of Chiefs. So I don't know. Nana Hima perhaps may help us.
Sure.
As you indicated, yes.
I think I mean, to the extent that these things are, the way they are currently defined, obviously, you have to be a paramount chief, right? So that is the foundation. Now, you don't have to have it that way, right? So the difficulty is if you start off by saying that only chiefs who are paramount chiefs can then go on to the next tier as regional houses of chiefs and then to the national. If that is the only way one gets there, then of course that is, the pool of women among paramount chiefs is, 0 to just a few, right? So it makes it difficult. But if you are doing affirmative action in other places, if you are doing it in the legislature because women cannot get elected there on their own, and you are willing to countenance to tolerate the idea of a quota outside of the normal, electoral process, then I don't see why the idea cannot be applied across the board. But it's a matter of just, how you redefine the membership, and I think that maybe the Queen Mothers themselves have to have some clarity, much better clarity than we do, on exactly how they intend to make that work. What is the specific proposal? If Queen Mothers are to be included, are they at the traditional council? Maybe that's easy. Maybe that's easy. Are they regional houses of chiefs? Would every region, I don't think I've seen, I don't know the Queen Mothers in every region. I don't know, And then from there to the national. How that is really the issue. So, I think we have what we have because that is how we started it. From the provisional councils during the colonial days to the joint provisional councils, we became the regional House of Chiefs. That's how we started it. And the British defined it a particular way, and we have continued it. So if there is a way you think we have to redefine it, then I think that part of the onus is on the proponents to give us a real roadmap how we do it. But I think the idea itself, the principle itself, is if it's a creature of the state can decide that this is how we define it. It's like the Council of State. If I create a Council of State, I can decide who sits on it. And so this is similarly something that is not ordained by any tradition. It's actually a creature of state. But if you want a membership to be expanded beyond the male chiefs, then there has to be some criteria that you define to assist how we get the women to be on it and all of that.
Mr. Chair, I have a short...
Attorney General wants to assist us.
On another matter, on the spousal issue. I find in the New Lands Act, Section 38, 3 and 4, that attempts have been made to recognize the interest of spouses in land acquisition. 3, in the conveyance for valuable consideration of an interest in land that is jointly acquired during the marriage, the spouses shall be deemed to be parties to the conveyance. Unless a contrary intention is expressed to the conveyance, then in 4, where contrary to subsection 3, a conveyance is made to only one spouse, that spouse shall be presumed to be holding the land or interest in the land in trust for the spouses unless a contrary intention is expressed in the conveyance. So an attempt has been made to cover that in the Land Act 1036.
Yeah, Sheila.
Hello. Okay. Thank you very much, Mr. Chair. I think a few issues have been raised with regard to some of the proposals that we made, so I will just touch on some of them, and then also maybe, make a few comments on some of the other issues that I'm a little familiar with. So I think that it's been indicated that one of the principles that the CRC, which is doing a lot of work, has indicated is they want to try to avoid establishing many institutions. When it comes to the Gender Equality Committee, we think that we would like to plead that this is an institution which is very important. And we don't think that any of the existing commissions like STRAJ can take up that mandate. STRAJ already has a very big mandate looking at human rights issues very broadly, a bit of administrative justice, etc. We think that we really needed this Gender Equality Committee a commission to be set up if we really want to make a difference and get more inclusiveness in Ghana. We are not scoring well when it comes to the measurements in many, many places. So we would plead that the committee should make an exception to this and really go ahead to make a proposal for the setting up of this Gender Equality Committee. I know that a comment has been made by Professor Nkakari that is the women's ministry that was set up not effective enough. For me, my view is that if the Ministry of Women, Children and Social Protection, if it was originally set up just to look at gender equity issues, I'm sure it would have been a very effective body and it could easily have taken on this easily. Yes, even the current law makes it their mandate to see to implementation of this law. I'm sure they would try their best. But we think that if there was a commission, it would really help. Currently, their mandate is very heavy. Children, social protection, these are very equally weighty things. So it kind of weighs them down. It makes it difficult for them to focus very well on the issues to do with gender equity. On the spousal property issue, I would just like to mention that it's an issue one of the groups I've been working with, I've also worked with for some time. There's a bill. There's actually been a bill since 2008. It's gone to Parliament in and out. I think the last time it went was in 2013. And the bill is very comprehensive and actually raises the presumption that properties acquired in the course of a marriage is supposed to be jointly acquired property unless you can come up with evidence to show that it's not. The bill also makes special provision for people in polygamous marriages. There's a whole section which looks at, the assumption too is that people who are in polygamous marriages, the men it's polygyny. They don't marry all the women at the same time. So they come in at different times. So the idea is that there should be a process for documenting who comes in first, what was acquired when that person came in, and then who comes in subsequently. So I think that draft bill, and we can furnish you with a copy of the bill, it has a lot of provisions which takes care of issues of polygamy, etc., etc. I think a suggestion has been made, whether we think that the affirmative action, the current law is not strong enough. Sometimes when you're struggling to get a law passed, you try to take what you can get so that later on you can strengthen it instead of not having it at all. So yes, I agree that there are some parts of the law that are not as strong as we would have liked it to be. And we believe that if some of the constitutional proposals that we are making are accepted, it would help and to enable it to become much stronger. Yes, it's a law which hasn't even started working. It only came into effect in September 2024. The structures are still being put in place. The Gender Equity Committee hasn't been set up yet. We were with the minister last week. It's now going to be set up. So we are yet to see how effectively it will be. But we are kind of looking into the future and thinking that if certain things are done, because of a few shortcomings we saw when it was being designed, maybe it will help to make it stronger and enable us to get to where we have, would like to be. We know that in Ghana, we've had a history. I think in 1960, the Representation of the People's Act was passed by the then president to enable women to have some kind of special seats where they competed amongst themselves. Maybe we could make a case for that to come again. That's a special measure because the UN, I think the CEDAW committee indicates that you can come up with special measures just to get the numbers of women up, because the patriarchal system in which we live is such that it makes it very difficult for women to be able to get to the into power and decision-making positions. Then another one I wanted to comment about was the legal aid issue. I think that the Legal Aid Commission Act has been passed in 2018. So it's not the scheme that we are using anymore. There's a Legal Aid Commission Act of 2018. I think it was, I think it's Act 977 or something, sorry. There's actually a law. So the idea would be to see how well this will fit into, I know there's a proposal to make it a constitutional requirement. I think it's the Legal Aid Commission Act 2018, Act 977. So there's already a commission in place, but as to whether it has the constitutional backing which the proposal is being made, maybe we'll stand behind the proposal as well. And then my last point, which one? Yes. Yeah. I think that my lady also made a point when looking at, I think, at Article 33 of the Constitution on possibly pushing for us for maybe a possible, that maybe one of the things we should be looking at is if there's a provision in the Constitution where once Ghana signs any international instrument, convention, or treaty, then it applies in here. I think if my understanding is right, I think for those who are lecturers in international law, there's this, Ghana is a dualist state, so we insist on getting the legislation made. I mean, once they ratify the law, we need to have it domesticated first. So I don't know whether we can actually push to get that change made to let those provisions apply. I think that would be a very major change, and it would be very helpful to us if we're able to achieve it. I don't know whether within this constitutional review process it is possible to get that. If it's possible, I think that would be very, very useful for us. And then I'd also like to add one last thing about the Queen Mother's position, because also with one of the groups I worked with some time ago, we were pushing for the inclusion of Queen Mothers in the regional as well as the National House of Chiefs. At the Traditional Council, I know they're already there. It is when they move up, because there's an ally. Usually before you can qualify to go to the Regional House of Chiefs, the National House has to approve a certain legislative instrument with your particular name indicated. And I think for a long, they were not including the women. But I remember that before 2016, because under Dr. Dana, at the time he was Minister for Chieftaincy, they passed a few allies to allow, I think, a few women from some of the regions to go. It wasn't enough. But room was created, the allies were passed, and they were supposed to have gone to the regional houses. I don't know how the implementation, I think it became, the issue is, I understand from the House, they said, when they come, where are they going to sit? If you've been to the National House of Chiefs before, it's a square room, and they have chairs and tables with names on each table. So I did a little bit of work with the National House of Chiefs, and when I kept asking them, when are they letting the women come? They said, when they come to the house, where are they going to sit? So they said we're waiting for their new building to be completed. Then maybe there will be a bigger room where provision will be made. But as has already been indicated, Article 277 is very clear. It defines chief to include a woman who is also properly appointed. And for me, my understanding is that the paramount queen mothers who had the right, at a point when they were trying to make a case for a second house, it was indicated that the Constitution didn't make provision for that. It's just one house, which is the state institution which has been set up, so they had to find a way. So I think maybe if you can kindly, those who are involved in the process can find out what the ministry responsible for chieftaincy did around 2016 to see what documentation was done to push the women there, because the law itself doesn't bar them. It's just the convention and the fact that they are not preparing the allies to enable enough women to also go to the regional house. And it's only from the regional house that you can go to the national house. Thank you very much.
Hello, can I respond to it, please?
On that
Thank you, Laura.
On legal aid, you mentioned pro bono. Well, at the moment, it's compulsory for lawyers to do pro bono. And that is one of the criteria for renewing your license every year. It was passed by the General Legal Council, so it's already there. No, but it is something that the Ghana Bar Association cannot, say they should revoke it, because it is one of their duties to provide pro bono. So it has been legislated that without that, if there's no proof of that, your license will not be renewed. So it's already there. And I don't know whether they have included it in the Legal Aid Act. I don't know. It has to be there.
Mr. Chairman, I wanted to respond to Lawyer Sheila. No.
Can I, maybe if I can add to Sheila's submission, and then maybe you can come in. I don't know if the chair will permit that.
We have 5 minutes to go, then we break for coffee break. Then we'll yeah, so if you can, actually we can break now for coffee and we'll come back and then we take...
Chairman, can I just make a little submission?
Well, how can
just
I say
a minute.
No to the...
then I can answer yours later. Oh, thank you very much. When we heard we are going to have a constitutional review, for us Queen Mothers, it was like a blessing in disguise for us. Talking about the membership of the Traditional Council, it's only the paramount Queen Mother who's a member of the Traditional Council. And we should understand that even on that level, during the, at the Traditional Council level, it's only the paramount Queen Mother, but there are also divisional Queen Mothers as well. But when you look through the Act, the 2008 Act 759, it says the membership of the houses is supposed to be 5 paramount chiefs from each region. And where there's less than 5 paramount, it has to be a divisional chief. The Act is very vague on Queen Mothers. There's a lot for us to talk about. I think we've discussed that already. If you look through the Act very well, it's a 33-page with only one name that says Queen Mother. But when we sit here and we assumed that there's we talk about affirmative action and all we think about is women, participating in politics and other workplaces, and I think we're having a problem. Gender equality should cut across. It doesn't matter which institution you represent. For me, as a traditional ruler, I've been the Queen Mother for 25 years, and I know what I'm talking about. If you're not in the institution, it's a different ballgame. It's not that we want to go to the Regional House of Chiefs and the National. What are we going to do there? What impact are they even making there? I want to see the National House of Chiefs personally being a second chamber. But the whole issue is, since we have the opportunity of having a constitutional review, then I think the Act should be looked at it well. I think gender is being very silent as far as women is concerned. This Act is not gender sensitive at all. Let me give you a typical example. Before you become a traditional ruler, or a paramount chief or a paramount Queen Mother, irrespective of what your gender is, you go through a form. You go through a CD form to be gazetted, to have your name in the national bulletin. Whether you're a male or a female, you go through the same process. The same money, the same chaos, everything. But when you are selected, or when you have your bulletin number, and you become a paramount chief. You become a paramount chief because you need that kind of recognition. To be able to sit in your traditional area as a paramount chief to go about your normal duties. You need that recognition to be able to align administer land transactions. You need this thing to be able to, get across with your royalties from the administrator of stool lands. Whereas we are all either a male or a female. But for us Queen mothers, we go through the same process, and at the end of the day, whatever we get out of it, we don't use it for anything. You talk about gender equality. When there's a Queen mother and a chief, and the Queen mother is supposed to be a counterpart of the male chief, and we don't experience that, there's a lot for us to talk about. Sir, I don't really know your name. I wanted to answer your question, but it depends on which way you're looking at. If a Queen mother is from a patrilineal inheritance system, that's a different ballgame. But if you are in the matrilineal inheritance system, that you make laws, you have the right to select, nominate, and install a chief, then it means you have a duty. If you are from a patrilineal inheritance system, then you might be a ceremonial Queen mother. That is a different ballgame. But for us who have proper courts, every paramount Queen mother in an account system, the ones I know, have a proper court. It's not only Nana Santehima. It's every paramount Queen mother. That sits, and we have our courts, we have our judges that, make sure we do arbitrations in our own systems. But that is not enough. If a chief is doing that, there's a lot of things in the Chieftaincy Act. One thing, lawyer, I was going to fight you later. I realize the affirmative action, all you think about is putting women in parliament to make decisions. No, please, can I finish? Please. That's all what I've seen. I might be wrong. But your first point as a woman and as a Ghanaian is your identity, which is your traditions and culture. And you left that very important aspect out. Please, can I finish? So at the end of the day, if I'm being stripped of my identity as a woman and for gender equality on that level, then where are we going? So I think we should all come down and make sure this thing is done as women. We shouldn't concentrate on politics. When did politics come? Our traditions and our cultures have been in existence for years. And you cannot strive as a woman without you knowing your identity. So if I'm a Queen mother and I'm being stripped of my identity, and you are blessed to be a lawyer in that level to be able to push this affirmative action, then you have to be on our side. Let's sit down with Queen mothers, excuse my language, who knows one or two about the Chieftaincy Act, who can really push. It's not anybody. If somebody is ceremonial Queen mother, the person doesn't have that right to talk as what I'm talking about, because I know the pains I'm feeling. How can you be ruled for 25 years and the law that says you are a counterpart to your male counterpart, but you don't have that right? As the man said, what are Queen mothers going to do at the regional house? Are we not human? If we are pushing for a woman to be a member of parliament, why are we not pushing for a Queen mother to also stand on the same level as a chief? Then we have failed as a country. Gender equality, we shouldn't be sitting here talking about it, whilst the very form of our identity have been stripped from our traditional level. I'll leave that for now. I have my quota later.
Good. I know you have the floor when we come back from break, but
so,
yes.
Are we going on?
There are some pastries there. There is coffee, juice, whatever, tea. presentation, and then if Nana Hima is back, she will also get to make her presentation before we break for lunch. That's it. After that, then we devote it to the whole. Energy. No, say well, you can wait. If we don't keep you last, you will not outweigh it. Professor Apiagietria will also make it's Buenas as well. Oh, sorry. Hello, hello, hello. The boys should go back to their seat. Okay, so we will have another round of maybe a couple of presentations, quick ones. Then we will spend the time between now and 2:30 discussing those presentations. We'll break for lunch, and then we'll come back and then take the presentations on the youth and then the Democracy Hub after lunch. So, Professor Kwajo Apiagietria, you have the floor.
Okay. Prof, thank you very much. I have some few comments, some of which have already been mentioned by the previous presenters. So I will not touch on those points again. But the first thing I wanted to let us pay attention to is the provisions on emergency powers. If we go to Article 3110, as we know, first of all, if we go to Article 4 of the International Covenant on Civil and Political Rights, it recognizes that in periods of emergency, certain rights can be suspended, but there are others that we cannot derogate from. But if you look at Article 3110 of our Constitution, it doesn't give room for derogation. It doesn't recognize, what it says principally is that any rights can be suspended during a period of emergency, which violates the provisions that we have agreed to under Article 4 of the ICCPR. So it's important. So far, our constitution is the only one I've seen in the African context where there's such a provision where in the period of emergency, all rights can be suspended. And so we need to pay attention to Article 3110. Among those rights, we have the right to life, torture, slavery, servitude. All those rights are not to be suspended during a period of emergency. Then Article 21(1). It's a very awkward provision as I describe it, in the sense that it mixes up a number of freedoms, and the first comment on it is that those freedoms don't have limitations, but we know that there are limitations to many or the majority of freedoms that we have. And so, for example, if we look at, if I may read a few of them quickly. 21. All persons shall have the right to freedom of speech and expression, which shall include freedom of the press and other media. There is no limitation to that. Freedom of thought, conscience, and belief, which shall include academic freedom, and so on and so forth. When you go down, the only limitations you see, which can be prescribed by a court, refers to movement, freedom of movement largely. And so that is one area that I think we should look at. Then within that same article 21, the freedoms there are also not properly put together, because freedom of thought, conscience, and belief is connected to freedom of religion, but they are separated here. And when you talk about academic freedom, freedom of thought, conscience, and belief, it is not connected to academic freedom. It's rather freedom of expression, which is connected to academic freedom. So I think that is one area that we also need to look at. Then freedom of association, freedom of assembly. Okay, so freedom of information, for example, is also connected to freedom of speech and expression. So those ones can also be put together. And freedom of association, the way it is framed here, sometimes it should be connected to participation. And so that is a few comments I have with respect to Article 21(1). Then when we go to the discrimination section, Article 17, that has been commented on by, I think, the first speaker. But what I see left out is whether the grounds for discrimination, whether we should use sex or gender. I think sex fits better than gender. And we should also add, we know that I noticed that the list of grounds for discrimination has been extended. And I agree with that proposition by the first speaker. But I think it should end with "and other status," so that we will give room for others that may not be directly recognized now, but may become necessary later on. Then, if we look at 17.2 and 17.3, the grounds for discrimination are also different. For example, 17.2 talks about gender, race, color, and so on. But if you go to 17.3, it talks about race, place of origin, political opinions, and others, which are not in 17.2. And again, I agree with the view that the definition of discriminate here should also be extended. And it should, for example, refer to the purpose or effect of the discrimination nullifying or impairing the recognition, enjoyment, or exercise on an equal footing of human rights and fundamental freedoms in the political, economic, social, cultural, or any other field of public life, which is what we find in the ICCPR, for example. Then I also want to comment on the few economic, social, and cultural rights which are found under the rights and freedoms. That is Article 5, Chapter 5. When we talk about right to work and right to education, they are mentioned there, but it is not right to work specifically and right to education specifically which are recognized. So if you look at, for example, the right to work, it says everyone has the right to work under satisfactory, safe, and healthy conditions. So it is not specifically recognized the right to work, but connecting it to certain conditions. The same with right to education. So it talks about sorry, I can't locate it right away. But there's also that issue there. It connects it to, it limits it to provision of certain resources or the freedom to enjoy that freedom, education. So I think we need to be clear as to how we are recognizing these rights, economic, social, and cultural rights. And as the chair rightly pointed out, it is not necessary to say that when you need that right, you go to the court and the court will grant it to you. But it will be subject to some particular tests, including the progressive realization test. So, but we should be clear that we are recognizing these rights instead of doing it in an indirect manner. The next point, I have two more points and I will be done. The application of international law within the domestic setting. As we know, if you go to our sources of law under Article 11, is it 11? The rights that are recognized there, I'm sorry, the sources of law that are recognized there, it doesn't include international law. And if you want to know where international law is as part of our laws, we have to go to Article 75, 1 and 2, where when the laws are passed, when we either sign or even ratify a treaty, it has to come to Parliament for ratification or endorsement or through a resolution or an act of Parliament. So then we can then say that if we go to sources of laws, our international laws are embedded in acts of Parliament or other laws made by military regimes and so on. But there are a number of laws. In fact, the international treaties, the treaties that we have either signed or ratified are more than what we have actually made as part of our acts of Parliament. And so the question then is, where do these laws hang? In that sense, we have ratified them. They are binding on us, at least at the international level, but we don't see them as part of our local laws. So I think it's important that we bring clarity to this point. In some constitutions, like the Kenyan one, South African, they specifically recognize international law as part of our laws, so that even where the process of domesticating them as a dualist state we are supposed to do, those sources will still be recognized. And a lot of them include human rights treaties, which in some jurisdictions we don't need to, or they've come to the point that even dualist states that you don't need to domesticate them before you can apply them within the domestic setting. But our Supreme Court has been quite conservative in this regard by going by the strict dualist approach, which does not recognize application of human rights treaties until they have been domesticated into our local laws. And within the same vein, we also notice that the treaties that we domesticate, sometimes we do pick and choose. We don't adopt or incorporate the whole treaty into as part of our local laws. There are a few examples where the wholesale incorporation is done. For example, I think one of the laws on citizenship and immigration and a few others. So I think that so long as Ghana has not made any reservation to the treaty when we were ratifying it or signing it, then it means that we agreed that we are going to adopt that treaty as a whole. And therefore, even if Parliament should make a law, then the law should adopt the whole treaty and attach it as an annex to that particular act of Parliament. My last point with respect to charge. When we go to Article 33.5 of the Constitution, it gives some important powers to the courts to be able to somehow weave around the dualist position to recognize certain human rights treaties that Ghana may not have even signed or ratified. But of course, the courts have not made very good use of this provision. And my question is, can SRAJ also apply such a law? And I think on the face of it, it is no. And so my proposition is that it should be extended to SRAJ's powers so that they can also adopt that progressive approach of using international laws, particularly human rights treaties that we have not signed and ratified and domesticated, but the courts, in this case, SHRAJ, can also use it to promote human rights in the country. And in that same vein with SHRAJ, I also want to propose that, until the Richard Anani case, SHRAJ could listen even to the news or read newspapers and so on and decide that there's been a human rights violation, therefore it can take that action, can take an action to remedy that human rights violation. But Richard Anani came to limit ability of SHRAJ to do this. I think if we clarify that in our constitution, we give that power to SHRAJ, it can make its work more robust and it will be able to better promote human rights instead of waiting for victims to bring actions before they can take these matters up. And sorry, I think I saw one last point here. This is with regard to the pro bono issue that my lady raised, which has also been raised by other colleagues. I think that in some jurisdictions, especially in the US, they have compulsory clinical legal education. Over here, our law faculties, it's not compulsory. And the next step is that in some of these clinical legal education programs, the law allows students in some limited ways to go to courts and help and do adjudication in courts. And I think this approach will help deal with access to justice issues that we currently face in the country. And they can work together with whether with SHRAJ, whether with what do you call it, the Legal Education Commission, and so on. Thank you very much. I'm done.
Thank you. So just so we make sure that everybody who is here gets heard, and also that we cover the various parts of the conversation. So I think the morning session was mostly devoted to general fundamental human rights, including the presentation by Professor Apiajetia, and then the gender side. I think maybe the more useful way to do this is to exhaust those two, and then when we come from lunch, we take on the issue of youth representation, and then also I think Oliver about constitutional enforcement. It's nice to do all of these things, but exactly how do we go beyond the text and the words in the text to make sure that this actually is meaningful? So if we're able to use the time, it's about 1 now. Usually we go to lunch around 2:30. If we can be efficient, then we can take Nana Dufie Afrakoma's intervention so that we have the full scope of the gender presentations are all one together. We can discuss that. And actually, there may be room for another one before we break for lunch. Then when we come back, we can exhaust the schedule for the day. So we can have reactions to Professor Piagetia's presentation, which I think is linked to the Amnesty International presentation earlier in the morning. If there are no reactions to that, then we can take one more presentation from the Mampohima, and then we can have discussions on that as well.
Okay, so I would like to first, thank you so much. I would like to first react to the legal aid, access to justice issue. So a comment was made earlier that it's already compulsory for the lawyers to do pro bono before their licenses are renewed. which is not so. That is not what is happening. We proposed it. I remember the last time we had the meeting in Kofodia, we were proposing that and pushing for it. But they made us know that it will be difficult to make it that compulsory. Because to be able to augment the work of the legal aid, that is the right way to go. We have a lot of lawyers. If we are able to ensure that every lawyer, before you renew your license, must prove that at least you've handled one pro bono case, it will lessen the burden on legal aid. But unfortunately, it has not been accepted yet. What was rather accepted was the fact that every lawyer must prove that there's been some level of legal education within that year. But for this, it's not. I can confidently speak to it. Up until now, we don't have that. So that is a major challenge, that if we have a way to put that in the, recommend that in the Constitution, it would be able to help. And also, to our Queen Mother, it was rather unfortunate that the chieftaincy aspect, I realized Auntie Sheila was a little bit under attack. I worked on it in 2021, 2022, and I can confidently say the entire draft, I drafted it before I went to AG's office. It was there. It was captured, chieftaincy, because these are things we all love. So as she was trying to correct you, it was fully captured. But you know, when it got to Parliament, last year we were trying to push for it. They took a lot of things out of it. And for me, the Affirmative Action Act we currently have does not reflect what we actually wanted. But we wanted a step. And then after we get the first step, then we can proceed to do more. But what you said is correct. We need women at the National House of Chiefs. If we say that what are women going there to do, it is wrong. Because women have a lot to do. Women make a lot of this, especially when it comes to the Queen Mothers. They make a lot of decisions traditionally. When it comes to storytelling, history of our tradition, it is women. And for us to have a National House of Chiefs and we don't have women, it's already discriminatory. We need women there. Women make decisions. Why are we pushing for women to go to Parliament and we don't see the need to push for women to go to National House of Chiefs? And I was so happy when Prof stated that National House of Chiefs is not even an actual traditional cultural thing. It is a constitutional thing. It is through the colonial masters and all of that that we adopted it. So it must reflect that truly we are not discriminatory and we have women who come in to support in making very important decisions that affect women and children. We've said it time without number that when it comes to issues that affect women, we don't want only men making those decisions for us because they don't have the experience that we have to be able to understand what we need done for us. And my third point will be on the parental leave. Anytime we bring about the parental leave for fathers, we usually get two excuses. One is, oh, we live in a polygamous society. And the second is that some of the fathers will be irresponsible. My response to that is, in as much as we live in a very polygamous state, what can happen is other countries are practicing it. I think Zimbabwe, even Africa, I don't want to go to Africa. We have Zimbabwe or one other country that practices it. It is a quota. So if you know that in a year as a father, you have 30 days paternal leave. If you have 15 wives or 20 wives, no one cares. All we know is that you have 30 days in the year for parental leave. And that parental leave, before you take it, you must show proof that this wife of yours has delivered. And that is why when it comes to paternity leave, unlike maternity leave, for maternity leave, usually we can leave the office a week before delivery or 2 weeks before delivery, and it's allowed. But for paternity leave, if you check, the woman must deliver, and you come and show proof before you are granted. So if you have 30 days and you have 10 wives, you know that when every wife delivers, you have 3 days. So that those who have one wives can use all the 30 days to support. We shouldn't say because we live in a polygamous state, culture, we can't have the parental. This is the way to go about it. Let's take some of the best practices and implement that. Thank you.
So it's like a disincentive to being polygamous. Because if you have more, then you have fewer days. Yeah. Okay. I mean, on the, I think there's I wanted to react to something that oh, okay. Now that's good. So I think that just called my attention to Article 277 that defines a chief, and it's defined to include Queen Mother. So maybe that's a good starting point for the conversation, because the Constitution defines chief to include Queen Mother. We'll see what whatever that means. But then, after her main presentation, we can after the next presentation we can come back to that issue. One other thing I think you made was about the definition of the equality clause, right? You wanted us to include age. How exactly do you include age as one of the grounds upon which you may not discriminate when, of course, discrimination can be, you can have rational discrimination where you cannot subject a child by virtue of age to certain things, right? Rationally, you cannot. And then you have retirement ages, you have all kinds of things that are based on age. So exactly, I think it will be difficult unless proviso in that provision was to include age among the grounds in Article, I think, 17. Because of the difficulties around the treatment of children, the treatment of persons who are not adults, we discriminate against people who are below a certain age because they can't vote, all of those things, right? So we need to figure out how exactly you include age. If you want to say that we may not discriminate against persons based on yes, there are some grounds of discrimination based on age that are not permissible, but we must find a different way to say it than to put it in the general equality clause of Article 17, because that would be problematic in terms of just trying to apply it as a generic clause. Maybe you may have a sub-clause and you probably do something like that there. But I think it will be difficult. So I think, I don't know if there are any other responses. Otherwise, we'll move to the next, we'll make to the next presentation.
Yes, thank you very much.
Please introduce yourself before you.
Yes, please. My name is Theodora Williams-Anti, and I'm here with the Youth Manifesto Coalition. But I just want to add my voice to the gender discussion and also stress and plead for the Gender Equality Commission, which we have discussed earlier, even though you are very careful about establishing more institutions. I think that we've had a gender ministry, and Prof rightly asked if the gender ministry have served us right. It's a yes and a no. If you look at where we've come from and where we are, you see that the gender equality aspect of the Ministry of Gender has not really been realized. And so it will be very, very important to have a kind of a body that is solely dedicated to that if we really want to be proactive and move forward as a nation, so that we don't come back 10 years and still be talking about some of these things. It's important that we dedicate some kind of a body to push the gender equality agenda. And so I just wanted to add my voice to that conversation, that the commission should, the committee or the commission should please really look at that and make sure that we have a gender equality commission or some kind of a body that will push the women or gender equality agenda. Thank you.
Thank you. So we yield the floor to Anahima to make her presentation.
Prof, I wanted to quickly react to Professor Apiaje's presentation.
Sure, okay.
I mean, on the emergency powers clause that you mentioned, I think that we are aligned on that. The challenge we have even now is that there's emergency Powers Act, which allows, when you see the situation of Boko, a minister can just keep Boko perpetually under curfew, and there's no, the constitutional ways in which you seek parliamentary validation of all of that have been now circumvented. So there's a need to redefine that perhaps a bit more carefully, so that it's not abused. And I know that Prof and I were joined on the Imposition of Restrictions Act legislation challenge before the Supreme Court, which the Supreme Court upheld, but there are constitutional defects that need to be looked at. On the human rights provision and the limitations part, I think we are not agreed though on that. Because his suggestion about some of the rights which have no restrictions, and suggesting that perhaps we should look at that because it's not clear where the restrictions are on those rights, because those rights are not absolute. In fact, in practice, the laws, the human rights are observed in their restrictions more than in the content of what they are when we go before the courts. That even for those rights, for instance, when you take the freedom of assembly, which when you go under 21, most of the restrictions there are under movement. The movement restrictions are now being applied to those who doesn't require it to be applied to. So the danger is almost even present. An omnibus provision in 12.1, which subjects the entirety of the restrictions as they exist. So I'm more apprehensive about further restrictions from what exists when the difficulty is, in fact, setting out clear criteria by which those restrictions apply to existing rights. Thank you.
Since you raised the issue of movement, assembly and movement, I would like to ask Prof. Tua and Nana here, you may also help us. There's been a tendency for certain traditional authorities to ban individuals they do not like, for whatever reason, not to come into my territory. How do we deal with that? Because the danger is that if such a person takes on themselves that, listen, the Constitution gives me the right to go anywhere in Ghana, I'm a Ghanaian, the likelihood is that the authority there could organize people to harm the individual or do anything to that individual. How do we handle such a problem? It's something that's been going on, and I think we need to address it.
Thank you, Prof. Quickly say that, as we know, the Constitution, in recognizing rights, subjects the laws to the rights that we're supposed to enjoy, unless that particular rights that the Constitution granted us or guaranteed for us, it's also recognized within customary law. But the conflicts, then the rights that we enjoy constitutionally and under international law will prevail. And so if a chief or any traditional authority would impose restrictions on movements, it will go against our rights as citizens or even as residents of the country. And so that is the way the court will approach it. So there are a number of these decisions made by traditional authorities which can be declared as unconstitutional or illegal. Thank you. And on the question of Oliver, I totally agree with you, but I think that probably that is why we have this problem where the courts and the police and so on take the law into their own hands in with regard to the restrictions and limitations we're talking about. So if it is clearly stated that these are the limitations, then everybody will know that these are the limitations, and therefore, if there's a violation, it can clearly be identified and dealt with. We can easily point to where the fault is coming from, instead of leaving it as it is, where those limitations are not properly stated. Thank you.
Okay, thank you, Prof. My name is Atman Prempe, and I want to contribute to the right, Article 28 of our Constitution. It has the children's right, but I know very well that at the time the 1992 Constitution was drafted, we did not have the prevalence of the digital space. Now there is the rising issues on cyberbullying and online abuse. especially to the children or against the children. And for that matter, if this committee also look at maybe the review of the Article 28, because they talk about abuse, but it did not explicitly state the kind of abuse or the exploitation. So I am suggesting respectfully that if we review in the 1992 Constitution. Thank you, Prof.
Thank you. Prof. Akari, I mean, this issue you raised about the growing power of traditional authority Yeah. No, I mean, I think it's a tough issue. I mean, because of the social legitimacy that chiefs have, even when they step out of line in terms of the Constitution, they have this capacity to mobilize, local opinion in their favor. And by the time, the person who is the target of their fiat or command has already probably found himself a lawyer, they already has lost his right, But I think that it also shows that our republic, the sovereign republic, is actually quite negligent because this is properly the sphere of the state, right? And even the state cannot do it by just word of mouth. The state has to do it by law, right? If the state wants to restrict your right, there's a way to do it under 21.4. There must be a law. The law must do this. The law must do that. But this whole business of chiefs just issuing fiats, and then their subjects or the community just then makes sure that you comply or else. I mean, it's a big problem, and I'm not sure how exactly we treat it. The fact that the laws of Ghana include customary law does not mean that every chief's word is customary law. There's a proper way by which we identify what is customary law. Customary law is not whatever a chief says, but somehow we have if a chief says something, it is customary law. And, of course, there cannot be, right? There has to be a way of identifying what is customary law in a particular context. But it's a huge problem that I think the state is being very irresponsible in not protecting its citizens when these things happen. Chiefs flog people in the front of palaces and all of those things. They don't have the power to do that. I mean, they just know where they are getting the power to do it, but they're doing it. And the political class is afraid. They're afraid to say anything, so they leave the citizen at the mercy of, the local authority or the community, and that's a big risk, So maybe, I don't know, maybe Oliver, we're talking about how you protect the rights and how you enforce it. These are some of the challenges, You have something on the books as a right, but when it comes to enforcing or protecting it, the system just leaves you exposed. And I think these are some of the challenges that, I don't know if the constitutional process itself, review process, cures it, because by any reasonable reading of the Constitution, that is not already, it's not permissible. But it's happening. And how do we get the state to stand up and say that, I've had occasion to report some of these things, for example, to an attorney general. I said, look, did you read this story? Your own state attorney actually in that particular local area was saying something reported in the papers that seemed to support what the chief did. But is that what you told your state attorney? I mean, that this is acceptable. So that's weird. We'll deal with this guy. But nothing happened. So these things happen. I mean, one doesn't know exactly how to handle it. And you're at the mercy of a community, Somebody comes with an investment. I want to do goat. A chief says, you can't do goat in my jurisdiction. How? You can't do goat rearing in my jurisdiction, saying, what customary law is that? I mean, I don't understand. Like here, we don't do goat rearing. Really? In a place in Ghana where by law you can't do goat rearing? I mean, if you are doing it in your house, then you can say that, no, you can't do it in your house. But if you have a farm where you are rearing goat, The people having, some guys' investment was shut down because the chief said we don't do gold rearing here. And people are like, oh, but customary law. How is that customary law? So these abuses are adding up. One doesn't know exactly what to do about them. But I think, some of these issues may be the kind of issues we raise at the National House of Chiefs level or the Regional House of Chiefs level, but it will require state intervention to raise these issues. We have a Ministry of Chieftaincy. Maybe that's where the minister must. But sometimes even the minister will go and support the thing that is happening at the local level. So you don't know where to turn, and it becomes a bit difficult. On the limitation clauses, our limitation clause in 21(4) is probably one of the. In terms of how it's written, it's probably one of the worst I've seen in a modern constitution. Seriously, it's not well written. It's, you look at, for example, the comparable provision in, say, the Kenyan constitution or even the South African, and the way it's written, it's probably why we have ended up thinking of the restriction as more important than the right itself, because it doesn't look like a limitation clause. It reads as if it's really the main source of the thing. And I don't know if we can do it, but I think, there are better ways of writing a limitation clause that recognizes that gives primacy to the right, and really makes it very clear that what we are restricting is the extent to which the right can be limited, right? So that it's very clear that the limitation clause itself is the one we are trying to restrict, that you can't use this limitation to go this far and it has to stop here. But the way we've written it, it almost makes it look like, oh, it's the and go that far. Well, it's the restriction that to being constructed in a way that makes that very clear. More modern limitation clauses are quite much clearer in that respect. So the Kenyan one, for example, reads much better when you look at it from that angle. But I'm sure that you will handle those ones in your comment. So let's give the floor to Nana Hima to make her presentation, and then we will return to it.
Thank you. The Constitution, Article 277 says a chief is also a queen mother. We are not denying that. That's exactly why we are here today. We want it enforced. Very simple. Let me take you back to the Chieftaincy Act. The Chieftaincy Act 208, Article 759, is a 33-page act. It only says queen mother, the word queen and mother in only one sentence or just one word. It only appears in Article 57 of the Act. That is the only time you see a queen mother. Defined well. I will read that. It says a chief is a person who hails from the appropriate family and lineage that has been validly nominated, selected, nominated, and installed or schemed or installed as a chief or queen mother in accordance with the relevant customs, laws, and usage of the particular area. So that's the only time you hear that. But I wanted to ask the judge that if it says at 277 that a queen mother or a chief is also a queen mother, then it means there's a problem somewhere else. When you go back to the same act, when you even go back to the category of chiefs, it says Asantehene, that's one, and the paramount chiefs. Second is divisional chief, third is subdivisional chiefs, the Dikro, and other chiefs that is recognized by the National House of Chiefs. There's no way that says queen mother. I'm not done. When you go to registration of chiefs, if a chief is being gazetted, you go through the same process as a queen mother being gazetted. It's the same process. But when you come down, your role as a female occupant of a stool is denied because you have no access in giving out lands. You have no access to your, what shall I even say, to your royalties. Let me give you a typical example. If a male stool is vacant for 20 years, the royalties that government gives you, which is your own money from your land, is kept till a new chief comes. Are you talking about gender equality here? So who am I? Am I a queen mother or I'm a chief? Which go through the same recognition for government to recognize me as a traditional ruler or as a queen mother. Number 2, if a stool is vacant, the next in line of the traditional council is a principal member. Secondly, who am I? What's this thing called? The acting president of the traditional council is never a woman. It's always a man who is not even part of the family. Depending on the hierarchy of the area, it can be the Kontihini or the Akwamihini, but mostly in Ashanti is the Akwamihini, who is normally the second in command, or depends. If it's a traditional area, maybe your left or your right wing, depending on how your customary laws pertain in your particular area. The next question, who am I? When you come to land title, let's assume I'm a paramount queen mother, I have my own land, which when you come to Mampo, there's an area that says, oh, this is the queen mother's land, which I have no right still. I have no right to even lease that land out. Unless, if I even have to do a lease, it has to go back to my uncle for my uncle to sign. Secondly, who am I? So the interpretation goes on and on and on and on. If a female stool, if a male stool is vacant, it becomes automatically the next person in line in the traditional council is a principal member, not the queen mother. But if the constitution is saying, at Article 277 is saying a chief is also a queen mother, then I bear to differ. I am not a queen mother, neither am I a chief. I don't know what my role is. I wanted to take this on to get an interpretation from the Supreme Court on who the occupant of the stool is. Let me give you a typical example. The royalties that comes to the traditional council, 10% goes to the administrator of stool lands, then it builds up back to 100. 55% goes to the assembly. 20% of that money goes to the running of the traditional council. That one I don't have a problem because I know very well it's being audited by the Auditor General, so I don't have a problem. 25% goes to the maintenance of the stool. Secondly, who am I? What do I do? And am I not the occupant of the stool? That 25% goes to the chief for his regalia and other stuff, but it only goes to the chief, not any part of the queen mother. So I'm here today, although we put up a paper to say that the act needs to be a little bit gender sensitive. That's all we are looking for. We might not get it all, but at least if we won't get gender equality, we want gender participation. So I rest my case on that. I hope at the end of the conversation, I'll see Auntie Sheila and a few lawyers to help us put up a proper paper for the committee. And I think this is our only opportunity we can get. This is the only shot we can get as queen mothers for our voices to be heard. When I met Prof, I told you that you're going to be the National House of Chiefs, where the laws are being made by men and to protect men, whilst we are not members. For me, I'm not of the view of going to the regional house. I want the act that protects queen mothers or the chiefs to be gender sensitive. Me going there, what am I going to do? They gave an example, they gave an excuse that when there were just 10 regions, that they can't accommodate us. Where are we going to sit? But when we added 6 more regions, 6 times 5 is 30. They gave them space to sit. So we should be aware that it's not where we're going to sit, it's that they don't need us there. As Prof said, what are we going to do there? We're not going to do anything. We want equality. If we won't get equality, give us participation. Let me be able to get access to the money, which I'm entitled to. In the olden days, I didn't have to be bothered to know where my boundaries are as an Akan woman and as a traditional ruler, because my chief will take care of me and take care of the wife. But now, whether we like it or not, modern kind of family system are set in. So the chiefs are only taking care of their children. And where lies me and the family that owns the stool? So these are things, it's very critical. If you don't look at things like this, it means we are stripping off our identity, especially from us where we come from, the matrilineal inheritance. So whether we like it or not, is a little bit sensitive. I know whatever paper we put up, and for whatever paper we put up in the near future and give it to you as the constitutional review, when you go to when you go back to the National House Chiefs, they'll kick it out. Auntie, for your information, I didn't even know that, because I assumed that is the end result I saw. And for the affirmative action, I thought we were not included. And it was a bit difficult, because I realized it was women who were pushing it, but the women, they are not really where their identity starts. They stopped, analyzing that start. So eventually he told me, but still, it's still not enough. For me as an outsider, the affirmative action doesn't say anything about what I do. And my level of expertise is chieftaincy. I can't go and talk about gender things where I don't know. So I'm saying, whether we like it or not, you don't help us so that we are, our identity as traditional rulers and as queen mothers from the matrilineal system group is not stripped off. Thank you very much.
Thank you. Thank you very much. Thank you. So this is of good education for myself. So it appears to me that what you're saying, if essentially, is that the intervention of the state in chieftaincy affairs, let's say from the colonial period to today, has actually made the status of queen mothers worse than if the state did not exist. Yes. Right? Because at the local level, where tradition is observed, there is a very particular role for you, and you know your role, and everybody knows your role. But then once the state intervened in this business and started creating these houses of chiefs that excluded you, then basically you are beginning to lose the status that by tradition would have been accorded you. Now, so let's look at how that works out in terms of a possible remedy. So 277 seems to start you off on in a good place, because it says queen mothers are also chiefs in the definition. Now, there are many different ways of doing affirmative action, right? One of them, sometimes there's reserved seats for women. So, for example, you go to the certain parliaments where it's first past the post, and it's not easy to do it in through the normal legislative process. Kenya and other places say, okay, there are reserved seats, and then they find a way for the women to compete for those seats, or you create, a mechanism for that to happen. Now, if there was a house of queen mothers separate from the house of chiefs, would that be one way to go? Let me give you an example of why that option should not be off the table, right? So the state creates a number of institutions and gets to appoint all manner of people onto those institutions, right? One of them is District Assembly, Council of State, Lands Commission, Regional Lands Commission. It is up to the states. These are all state entities, right? It's up to the state to determine who sits on those things. Now, it is easier in the way I see it, because then the chieftaincy matters are not involved at all. You can have, if there was a national or whatever house of queen mothers at whatever level, it's probably easier to say, there shall be a nominee chosen by the National House of Queen Mothers. Because if you throw in back the National House of Chiefs, they will take all the positions, the men positions, right? So if you have your own Queen Mother's house, then you could say, X number of persons nominated by the Queen Mothers sit in the assembly, sit in the regional house, or sit in the Lands Commission, or sit somewhere. What I'm suggesting is that sometimes when you get, given the traditions that are formed around this office and this particular institution we are talking about, if all you're trying to get is a seat at the table, you could still get there, and or like they say, you can be at the seat and still be on the menu. You can get there, but still not really matter a whole lot. While sometimes if you got your own institution from which government can pick nominees to certain influential bodies that make decisions, that may be one way to go, right? So I just want to get your thoughts on whether you have thought through different options of getting to the representational goal, right? And whether you have weighed the different options and seen what strategically might work best to get, because I think maybe even politically there may be very much less resistance to the idea of creating your own body and then separating it from the men, and then getting roles that are attached to those new officers, than to say, okay, you are all in the National House of Chiefs. I think because of the long history that has gone on with this institution, there may be a lot more difficulty politically around that. And of course, you know, this is a political process. The political class, who are the gatekeepers of this process, to make these amendments and to accept these proposals. But even if you gave them two options, assuming that we said, okay, this is a proposal, but if you don't like this, this is option B, how do you like that as an option?
Forming a National House of Queen Mothers, that one is not where I stand. I bear to differ on that, because the previous administration started putting something together by the minister, but I don't think the minister did a good job, because he didn't even include more Queen Mothers on the table. So I have my own reservation on that. It's not really important. And secondly, Ghana, the Ghana Parliament, they are only there to make laws. I don't see a parliament for women and parliament for men. So the same thing applies to the National House of Chiefs. Whatever their responsibility or their duties are, I think as so long as we are in the same institution, that's where we belong. I personally, as I said earlier on in my submissions, I personally don't want to be at the regional house or either in the national house. It won't make any damn difference. But if the opportunity comes for us to be at the national house, the regional house, it's okay. At the end of the day, there's the same Queen Mothers who will fight for their stools and their skins along the line, and you have to come and defend it at the traditional council level through the judiciary system and through the national regional house of chiefs through the judiciary system. And it's still a men's-based occupation or committee. So it's still the same. If we're able to, one or two people gets the opportunity of sitting there, it will be nice, because it will come, listen from a woman's point of view, you can really make your cases head right. But my argument is, all we want is an enforcement of the law, Article 277, that says a chief is also a Queen Mother. It's the enforcement that we want. We will know very well it's not going to be an easy task, but dodging what the Act says to have a House of Queen Mothers won't solve the problem. If we have a House of Queen Mothers, who is going to supersede the other? And it's the same act that we're going to work on. We are brought back to square one. So if we are talking about gender equality in Ghana and we have the opportunity of having a constitutional review, let's put in something that says, as I said, even if it's not gender equality, it's gender participation. At least let our voices be heard there. We are not asking for much for the start. But all we are saying is that this is a good opportunity for every Queen Mother in Ghana, that our voices needs to be heard. All we are looking for is gender sensitivity in the Act and making sure whatever is at Act 277 prevails. That's all we are saying. We don't want anything else. Going to the House, what are they doing there that we are going to do? The only thing they do there is maybe they have these other, what's this thing called, committees for research for your Gazette and other stuff. I mean, they have their own cases that they do, which unfortunately there's no woman there. So if a woman's case goes there, I mean, I don't know what they do there anyway. I've never been there, so I don't know. So that's all we're saying.
No, but I want a bit of clarity, because 277 is there, right? You have 277.
Enforcement.
Yes, and yet, well, but definition, right? It just defines chief. Then 271 comes to constitute the National House of Chiefs, and then says, the House of Chiefs of each region shall elect as members of the National House of Chiefs 5 paramount chiefs. So now the chiefs is qualified, right? It's no longer just 277. It's now qualified. It has to be a paramount chief. Now, and that, right? So chief is
Queen Mother,
includes Queen Mother.
It doesn't.
And well, no. In 277.
In practical, I'm not having a banter with you, because I'm not the one saying it. I'm only saying in practical life, it doesn't.
Is it, and I'm trying to get to the source of the problem. Is the source of the problem the fact that there are very few paramount chiefs who are women?
No. Every paramount chief, especially in the matrilineal system of inheritance, has a Queen Mother.
Oh, so you are a paramount Queen Mother yourself from Mampong?
Yes.
And the law recognizes that you are a paramount queen mother?
Yes, and I've been gazetted. And I have the recognition as the same as my chief. I paid the same money as my chief.
I see. Okay.
But my chief is the only person who is signing lands. I'm not having a problem with it. So long as, no, I'm not even having a problem with whatever goes on. But I'm only saying these are things we have to, in our era, try to make it right for the next generation. Because, as I said earlier on, in the olden days, before this constitution came, we never had a problem with, lands and alienation and sharing or all these things. Because in customary law, we're prevailing. And the customary law says that as far as you're an Akan or you're from a matrilineal inheritance, so you're being taken care of. So all those times, these matters were not there. But now, whether we like it or not, because of the constitution and modern kind of system of family, or as I would say it, bourgeois things, we are having the chiefs recognizing their wife and their children as family, which they are not. Me, my uncle's child is not my family. I don't know the person from anywhere. He's my uncle's family somewhere else. I don't know them. You're an Ashanti man. Your children are not your family. You don't know from any of them from anywhere. They are just your friends. You should understand that it's your nephew and your nieces who are your family. And that's one thing we are refusing to know. So long as modernity sets in, we don't have a choice than to make things right. That's the reason why we are pushing for this. That the only way our voices can be heard for the next generation is to make sure the enforcement is done. So that if you decide to call your children, whom you don't know from anywhere, as your family, I don't have a problem. But at least the lines are drawn. Thank you.
We will be very greatly assisted by a written submission that fleshes out the issues. But I think I'm getting you now, small. So if you have a written submission with the assistance of the lawyers, your lawyers, and all of that, that would be greatly helpful, because I thought only 277 was the basis, because then the men can come and say, okay, if that's your problem, we are going to amend 277 to take out queen mothers, right? That makes it easier for them, right? Then they'll say, okay, if we have made a mistake in saying that a chief includes queen mother, then we are just going to amend that provision and take out queen mother. Then the problem is solved. But the problem is deeper than that, right? So it's not a definitional problem. You are saying that your customary law privileges and rights have been diminished over time by virtue of these institutions that the state has created. And that is an interesting angle to come from.
Prof. Chair, I would just like to say a little to support my mother, the Queen Mother. I think that there's a lot of work has been done on this issue by Professor Irene Odote. Over the years, she has a body of research which is done, showing that, at least that position of Queen Mother, at a point, they said you didn't have them in all the 10 regions at that time. So that is why they couldn't come to the house. She did research. She found out that they were also in the northern parts of Ghana. They had different labels, etc. So at a point, they passed a law to allow all Queen Mothers to be getting some allowances. Once that was done, it's a very small allowance. So it's recognized that they are everywhere. So I also support what she's saying, which is that Article 277 is very clear. That chief is defined to include a female who is also appointed. And as she's indicated, wherever there's a paramount chief, there's also a paramount Queen Mother. The issue is with the traditions, with the customary law, and how these things roll out. We all know that, Professor Piaget mentioned Article 11 of the Constitution, which talks about the customary law of the various communities, which are part of the sources of law in Ghana. I also know for a fact that the Ministry of the Ghana National House of Chiefs, together with the then Ministry of Chieftaincy, also started some research on, they call it lines of succession. So they have some data out there. The problem is, as she's indicated, how modernity has changed what benefits they used to get. And I know that the consensus among the paramount Queen Mothers is that it will not be worthwhile to have a separate house, but within the provisions of the Constitution now, in terms of the responsibilities of the chiefs under the houses of chiefs, under the National House of Chiefs, both at the regional as well as the national level, whatever they want to be able to have a say. I know Nana Hima is saying that maybe she may not necessarily want to go there, but they want to go there if you want to be able to have a say in what happens at the peak, at the apex body, which is the National House of Chiefs. It doesn't matter. They need to be there. And so the whole thing, because one of the other thing she also mentioned, I think she read from another law, which wasn't clearly articulated. It is the Chieftaincy Act of 2008, Act 759, which rolls out the provisions of the Constitution on their role. I think it also repeats, within that law, it repeats the same definition of who a chief is. The problem is with the de facto ability they have to also enjoy the rights. And, at a point when we were working with Auntie Irene, it was, how do we get them into these various houses so that they can enjoy the rights that, other chiefs are also benefiting? And I think she indicated that at the traditional level, they are there. Paramount Queen Mothers are there. The divisional Queen Mothers are there. It's when they climb to the next level. So I don't know. I don't think they want to change the definition of chief, 277. That is far from it. They are saying that the Constitution itself defines chief very clearly in a very sort of gender inclusive matter. And I think that as far as affirmative action is concerned, we are saying that we want both men and women at the seats where decisions are taken. That is why in the original drafts of the bill, gender equality law, they were there. And there are provisions that anytime a chief is required, both male and female should be selected. But we were told at a point that cabinet said, remove everything to do with the chieftaincy out of the law. The Chieftaincy Act will deal with that. So that's what was done before the law was approved. And like I said, we tried to put it in there, but it didn't work out. So I think that it's how Article 277 is rolled out in the other institutions the state has set up. That is the key issue. So I'm just adding to what she's saying, and we'll help to articulate this issue. Thank you.
Sign the lease. It's only an example I'm giving. If I need the recognition of the state to be a queen mother, whatever my chief is doing, don't you think I'm also, at least obliged to do it? Especially when even my stool is vacant. I'm not even talking about when the male stool is not vacant. When the male stool is vacant, how come a principal member of the Traditional Council steps in as the acting president? Whilst me, as a royal, I brought my stool from Adanzia to Mampong. And that person, where is that person coming from? The person takes over. And we know that this caretakers or the acting president gives us a lot of problems, especially when we want to install a new chief. When you're talking about line of succession, it all boils up to all these things. Because Ashanti, we don't have a proper line of succession because for one or two reasons. Other places, other gates, they do. And it's okay. But Auntie, as you said, when they started including queen mothers in the other places, it started when Professor Mills, may his soul rest in peace, started giving queen mothers 80 Ghana cedis as allowance. And other regions said they will not allow the matrilineal system of inheritance that queen mothers to enjoy. So they also decided to install queen mothers without any defined rules. So that one is not something we'll talk about it today. So when you go to other places, their religion, their customary laws forbid women to be on the front line. So these queen mothers, because of 80 cities that you install, what are they doing? They have no rules of engagement, but they are there. But I only speak on behalf of the matrilineal inheritance because we have a defined rule. I'm not being biased, but that's what I know. Because I don't know much about what they do, it's very difficult to talk about it, and I don't want to be biased. So it's not like we want to ask to go into the regional houses. It's just a step. It will be good, because at the end of the day, it's the same cases, they deal there. Apart from if you're going for a research committee on your gazette or other stuff, this is the same thing. It's a judiciary committee, it's the same thing. But they have matters that most of the matters that goes to the judiciary committees of the Traditional Council and the Regional House of Chiefs in the caste system or the matrilineal inheritance system are affected by women. And the women are the custodians of the traditions of their respective traditional areas. These are the women who will come and try to argue their cases out in front of 7 men. Please, we can do better than this as a country. Thank you.
Okay, yes. So for 277, as we all agreed, defines chief to include queen mothers. As Auntie Sheila said, the major thing we've been trying to do is to include the queen mothers because they really want it. You just want to be able to sign the lease. but others want to be part of the major decision-making body. So what we are looking at proposing is that Article 271 says that is the coalition of the National House of Chiefs. It says that every region must appoint or bring 5. So what we want to propose is the 5 that they are bringing, is it possible that the 5 are not all men? Even if it is to start with 1, let's have 1 paramount queen mother. Because if you are telling us in 277 that a chief includes a queen mother, why is it that when you are selecting 5 from each region to go to the National House of Chiefs, you can't include 1 woman?
No, but they haven't said, and that's the problem, right? So 271 is in gender neutral language.
Good,
right?
But in practice.
So that's the problem, right? So there is 271. If you build up on 277, which includes the queen mother, 271 itself is not. It doesn't say male or man or whatever. It just says paramount.
271 to have should make it gender sensitive, whereby it captures that in amongst the 5 there should be at least. Like, it should be gender sensitive. That will compel them at the local level to ensure a woman is part. But if it is left loose, they will come back to tell you that, oh, okay, in our region we don't have a queen mother. It's only chiefs we have. But if it captures it, okay, 271 should, Oliver, just a minute. If 271 should capture it, then they'll be compelled to ensure that at least 1 woman.
So 277 says a chief includes a queen mother.
Yes.
Then we come to 271, which says paramount chiefs. Which chief includes a woman.
A woman.
Then you're saying, but we should be, when we come to 271(2) again,
yes,
we should say 5 paramount chiefs, at least 1 of whom shall be a woman.
Yes. I think we should try to capture it like that.
Is that why?
Yeah. At least, yes. Thank you, Auntie Sheila. Thank you.
Because I want...
Auntie Sheila, you are saying 2. Let's start with 1.
Prof.
Okay, let's start with 2. For me, my point is that
1 is okay for now.
Gender sensitive.
Wait.
It should be 2. Okay.
No. You are 0. You haven't even gotten the thing you are saying 2.
One will have been just. One will have been better for us. This will have been a beautiful step.
Because I wasn't sure where you wanted this solution to come.
Yes, that's what I'm saying. So I agree with lawyer very well. So at least the 271B or 2, the 2, you understand? Should at least says at least the 5 nominees from the regional House of Chiefs, at least 1 should be a woman. We are not asking for much. 2, they will beat us. Please.
If we go with 2 immediately,
they'll beat us. 1.
So
I thought your problem was.
Let's try with 1.
But I thought that the problem was. I mean, when you said you don't care about being there, I thought that the bigger problem that you were, your bigger grievance was about certain local, not regional or national, certain local customary privileges and rights that you would normally enjoy, but which somehow are beginning to you're beginning to lose them, right? Because the state has come into this. So there's a vacancy, for example, on the traditional council. And the only person that can act is the principal, whoever. And that is not part of your tradition.
In the old days, it has always been, as I said earlier on, when you're talking about customary law, then I think that was it had prevailed long time ago. Okay. But what lawyer is saying, it will be a step in the right direction, because at least if 1 paramount queen mother goes to join or is nominated from the region to the national house, it will be a step in the right direction. Because then, when 1 gets there, it means we're going to have 16 more women in the house. Then we can at least, when we get there, advocate that, since now that we are members of the National House of Chiefs, if a male stool is vacant, maybe the female occupant can't be, because that one is by convention, by customary law. I don't think there's anywhere in the Act that says, I'm a paramount queen mother, I'm not a principal member. The Act says it's very right that I'm a principal member because I've been gazetted. So long as I've been gazetted, I'm a member of the Traditional Council, I'm also a principal member. But at least if this thing is able to go through with just one paramount queen mother from the region goes, at least then we'll have 16. Then at least it will be a step in the right direction.
No, but would that be creative? By saying that queen mothers don't exist, right?
No. For now, all the regions, all the 16 regions have queen mothers.
Oh, really?
It's just that some of them are ceremonial queen mothers. But that is not that. For now, as far as what we are doing here, every paramount queen mother is a paramount queen mother because we are all gazetted on the same note. So if at least we have 16 paramount queen mothers joining the National House of Chiefs, it will be a nice, good step in the right direction. Then we can also fight for other things because all other things are customary law. Because I checked with the administrator of stool lands, and they are saying it's by convention. That's the reason why they don't give your royalties to the queen mother. So there's no law in the administrator of stool lands. There's no law or LI that says if you're a queen mother, you can't take it, unless somebody decides to take that matter up. But I think, or I believe that if one queen mother is able to go from the Regional House of Chiefs to the national, it will be a step in the right direction. Then other nicer things can follow. I might not be able to sign the lease anyway, but at least when my stool is vacant, maybe I can take that level and sell as much as I can till the new chief comes. Thank you. Yes, that's where the money is.
I think there's one basic thing. Please.
Three different aspects. That first, 277 creates a very unhelpful definitional problem. Because when you continue to, a man means a woman, it has created this idea that the chief we know predominantly and in thought, it's a man.
It's sex.
So that's why we were saying that let's blow 277 and say national houses of chiefs and queen mothers. So wherever chiefs appear, queen mothers appears, and that settles the question of what affirms the place of queen mothers within the house. What we didn't want to tap is the question of the eligibility about paramountcy. Because then, that question, we didn't address the question that if the eligibility criteria is paramountcy, then there are regions where there are female paramounts or queen mothers who are paramount. Then they are automatically, by the affirming language of national houses of chiefs and queen mothers, directly represented in there. If we want to go further based on what you were saying, that it's a creature of state anyway, so we can go wherever we want to go with this, then that's a different, more intervention, I think, approach. But as it stands now, if the paramountcy is the criteria, let's maintain that and change the name, which has created this poverty of thinking around who is qualified to sit in there. Now, if you deal with the problem at the regional level, yes, the definition. You just have chiefs and you just have queen mothers. So that the question of who is a chief and who is a queen mother is defined in the way in which it exists, that the person who hails from the appropriate lineage and things like that. But you don't say a chief includes a queen mother. Both chiefs and queen mothers are recognized in their own right as they exist.
Or you could say
a chief or queen mother, yes, exactly. Then when you come to the representation of the National House of Chiefs issue, it would be defeatist if the thinking is that there's an affirmative wave that is blowing across the entirety of the Constitution, and we are capturing it in a particular language, say not more than 2/3 or whatever variation, to come to the chieftaincy institution and say at least one. It then detracts from where you were going with other things and begs the question, why are we treating the gender issue regarding chieftaincy differently from entirety of leadership across board? So either we leave it, that is a 5 thing, but we have affirmed the participation of paramount queen mothers within the House and 5 are elected, or we use the same formulation and say that the representation where practical shall not be less than or more than 2/3 of one gender, or the same ethic that flies across all the other elective and appointive positions for gender affirming language would then apply. Rather than making it seem that you are then imposing particular appointments criteria or quota on the house. So that's kind of how we were looking at it. But if we do think that there's going to be more pushback. If the thinking is that, okay, let's blow up the paramountcy requirements as it exists now, and then now say that we're going to create that if they are not paramount, we should then find a way to create them in there. Then you're going to have a challenge. What already exists is that queen mothers are chiefs. We're just changing the language of how it is phrased. That has created this problem where we have allowed the state to be exclusionary vis-a-vis queen mothers. That's all. Thank you.
I've never seen a paramount male stool that is occupied by a female. For now, I've never seen a paramount chief who is a queen mother or who's a woman.
I thought that the Fantis, there were some.
There are divisional chiefs. There are divisional chief stools which is occupied by females. That's one I know. But paramountcy, no. That is for my research. If there's the lady in Western region is a chief, but he's a divisional. He's not a paramountcy. Yes. So if we go that line, we'll lose. So I like your line.
So okay, our in terms of those who were focused on traditionalism that were advising the committee on this, suggested to her that there are paramouncies which are queen mothers. I don't know how many there are, and of course it's more limited than the male, but the trend from understanding what you were saying in the beginning was that where there's a paramount chief, the queen mother is a paramount queen mother. That was what I understood it to mean. So if that is expanded in that regard, then the problem is solved. You know, but then if you work it back and say they are not paramouncies, but they are divisional, then we create another problem, where is that there is no, in fact, divisional, and we have created a gender neutral language where we know that there's no queen mother who is the paramount. Then we haven't solved anything at all.
Yeah.
There are women who are chiefs. I'm not denying that fact. But for 25 years, I've never seen a paramount seat occupied by a woman, unless the person is a queen mother. But a chief paramount, how should I even put it? A paramount chief woman, I've never seen that.
Is there a paramount queen mother?
Every paramountcy has a queen mother.
So that's the problem. As long as it's a paramount queen mother, that's what the constitution will create. That is a house that belongs to paramount chiefs and paramount queen mothers.
Yes.
Yeah.
So for now, that is the convention. Every paramount seat has a queen mother.
Okay.
And the queen mother is a paramount queen mother.
Okay.
And what we are saying is the act only says queen mother at only one time. Even category of chiefs is saying paramount chief. Yeah. It doesn't say paramount chief. All we are looking for is wherever there's a paramount chief's name, let it be through queen mother. That's all we are looking for. Yeah. I think that will solve the problem. Then the convention follows by within land annihilation, by within whatever. That won't be a problem. But so long as the 33 page of the Act 759 only says queen mother is mentioned only once, we have a problem.
Okay. Go ahead.
Nana, somewhere along the line, you outlined a number of, let me say, privileges that as a queen mother, you've been denied, even though traditionally you are supposed to have access to them. Now, for instance, you make this comment about not being able to sign a lease. What you are proposing, will it cure that problem? The substantive problem of you exercising your rights of access to certain facilities and privileges? Will the change in the law, what we are discussing now, cure that problem?
It might not cure all of it at one particular time, but at least it will be a step in the right direction. Because if we're able to, put all these small things inside the Act for us, it will be a step in the right direction because For example, as I said earlier on, I don't need to assign my signature to a lease for me to be, to validate me as a queen mother. But all I'm saying is, in case the male stool is vacant, I should be able to take over because I am from the royal family. Whoever they are bringing to take over as whether the acting president, it's not family, it's not related by blood. And it causes a lot of problems for us. Because if a queen mother, as it says in the article that a chief is also a queen mother, what stops a queen mother from taking over when the male stool is vacant? That's all we are saying. So it might not cure everything. It might not.
I think that is where I get lost. I'm not sure. This part of it, when you say, you are not trying to say that when the Mamponghini's stool is vacant, you should take over that
temporarily
stool.
till a new chief is installed.
But isn't that regulated? Isn't that a matter of customary law? That one, the state didn't create that problem.
The state didn't create that problem, but it's in the act. That says, the act says whoever is the acting president of the house is a principal member. That is what the act is saying. But customary law is saying that the act is also saying the most senior principal member of the traditional council takes over as the acting president. That is what the law is saying. It's not me. But in the olden days, it was still the same. But whereas before the constitution, other things were different. I don't need to be bothered because in the olden days, although in a Akan system we didn't have a proper line of succession, nobody needs to be argued about who becomes the next chief. And there were no litigations like this. You understand? But for whatever reason, we're in the 21st century. We are faced with litigation. Everybody wants your stool. There's no proper line of succession. And now there's the intervention of the acting president of the house. In the olden days, there was nothing like acting president. There was no traditional council regulated by government or supported by an act of parliament. So that is the difference. So although we are saying the act is good, it helps us define who a traditional ruler is there to guide us. Modernity has also, tried to diminish some of our roles. In the olden days, if the stool is vacant, it's the paramount queen mother. He doesn't take control because we don't go to war. Women don't go to war in the olden days. But it's our children who goes to war. Either our children, our uncle, or our brothers who go to war. So women are mostly relegated to the background to be singing and waiting for the men to come back. Although for us in the matrilineal system of inheritance, it's the queen mother who owns the land. But we own the land by virtue of just being a traditional ruler. But in practice, it's not like that. But in the olden days, it wasn't like that. So long as modernity is coming and things are evolving, we also have to change. We are not looking for extra powers. We are only making sure or trying to solidify what our position is.
Yeah. So I think what we are also trying to understand is that if the problem that you are inviting us to help cure was not a problem caused by the state, the republic, through its intervention in chieftaincy matters by way of statute or the constitution, then it's difficult for us to step into that role. But if you're saying that, but for the state, we would be okay. But the state came in and then now it has used the law to mess up everything, so solve the problem you have created. That's different from if your own custom regulates certain things within your family and within your traditional council and all of that. And it's going some way that modernity has, caused it to move in some direction. That one is going to be difficult for us to cure. But if you can say that the state institution that it has created in chieftaincy has excluded us.
Yes. The state institution has excluded us by bringing in an acting president who is not a woman. It's the same thing we are talking about, but let me also go back to, in the olden days, I understand where you're also coming from, that you wanted to find out if it's customary law that has really diminished or has really put in our position aside, or is the constitution. I would say it's the constitution. In the olden days, there were no traditional councils. There were no traditional council. We had our own system. It wasn't called traditional council, backed by an act of parliament. But now that is being backed by an act of parliament that says the principal member or the acting president is supposed to be a principal member. That is left like that. A principal member, he didn't say a queen mother. So all we are trying to say is, even if we won't get that side. If one queen mother or whatever queen mother is being represented, it will take up certain issues that we are concerned about. It's a step in the right direction. We might not get everything that we want in one particular constitutional review, but we want just a step in. That's it.
So, in other words,
no, but are you the only advocate for this position? Because I was expecting you to come with your entourage. Because you have to have, you have to have force.
Force, but
on this issue.
No, this, of course. I told you we'll come back big time. Unfortunately, the memo didn't get as well. I got the email here last night, and I really wanted to come with my team because we've done a couple of research with the help of some few lawyers. So we'll have come back in a more. But the lady has promised us you let us come back with maybe a good paper. But now that I've met Auntie Sheila and it's my beautiful lady, I think they will all help us to make sure we put in our grievances across in a better way. But all we are saying is we just want one step up. We want the act to be gender sensitive, to include queen mothers. That's all we are asking for. How can you write a 33-page with one word saying queen mother, and you're talking about gender equality?
So you are talking about the act?
Yes, it's the act I'm talking about, nothing else.
Does it define the principal member?
Yes, everything is about man. There's no woman. There's no queen mother. So all we are saying is if the act is saying queen mother, chief, stroke, queen mother, QM, if they don't bother to put all the lines, just put QM for me, we'll be fine. That's all we're looking for. If you are talking, now we are privileged enough to have the affirmative action bill passed in our era in 2024. So as a queen mother, if I'm not able to push this agenda to make sure at least our voices are heard, I mean, what are we here for? So all we are saying is, so long as the affirmative action is being passed within our era, we need our voices to be heard. That push, if it's gender equality you're looking for, everybody's talking about parliament. We're also talking about chiefs, stroke, queen mothers. That's what we are looking for. Let us be inclusive. If you won't give us gender equality, we understand. Give us gender participation. Let us participate. Small. But I don't know, because of this mouth, they won't invite us here. Too bad.
So maybe it's the mouth. So 276 prohibits chiefs from taking part in active party politics. Yes. It applies to queen mothers.
I don't know. I am not a lawyer. Maybe we'll start doing active politics. And somebody will, then it needs an interpretation.
It's an interesting point.
Yes,
right?
It's a very interesting point.
Because
it says
you
chiefs.
are prohibited from doing party politics.
That is chiefs. They didn't say queen mothers. But thank you. I've never thought about that. If it says chiefs, then it doesn't include queen mothers. Because category of chiefs, I am not in it. But they take my money to give me a CD form to fill. And I have to be gazetted to be recognized by government. So I also want to find out the money that government is taking from us to be gazetted. What are they using the money for? That is one. Why do I need to be gazetted to be recognized? What am I recognizing for? If all the privileges my male counterpart needs the recognition to, exercise, I'm not exercising. I'm not going to enjoy any of the exercise. What is the essence of a queen mother being gazetted? Then they should give us our refund and give us our money back.
Thank you very much.
Hello. Yes, I remember we had an opportunity to look at this acting position of chiefs. One happened in Jamestown. The members met and elected somebody. I took the matter to court that they cannot elect, they should appoint, because they said the next chief in line in seniority, that is section 15. What she's talking about, the Queen Mother is talking about, is section 15. Section 15.3 of the Act. The president of a traditional council shall preside at meetings of the council, and where the president is unable to attend a meeting, the chief next to the president in seniority on the council shall preside at the meeting. Now, in the course of the litigation, although we want that nobody should be elected, if anything at all, it could be appointed, The matter got to the Chieftaincy Secretariat. I mean, what do they call it? The former Ministry of Chieftaincy and Religious Affairs. And they came in to explain that there is nothing like an acting chief. They don't want any acting chief. The section is talking about meetings of traditional council. So you just appoint somebody to preside for the meeting. And that there's nothing in the Chieftaincy Act called acting chief. And that is a new thing that they have imposed upon themselves, which is creating difficulty for everybody. So now there are people who say, I'm the next in line, so if the chief is not there, I am the paramount chief. And then they prevent the kingmakers from appointing a new chief because they take over. So if you read it well, it is only for presiding over meetings. It's got nothing to do. So at every meeting, you can appoint one of you. If there's no, or whoever is the next chief in seniority. Well, that's another matter. You know, so this thing you people are talking about acting chiefs does not exist. They should just appoint one to preside over their meetings. That is all.
On that note, I think we'll take a break for lunch. We should aim to be back here, if we are efficient with lunch, by 3. lunch. So for the balance of the day, we'll have a presentation we'll have two presentations, well, three. The first from Mrs. Comfort Okran, Executive Director of Springboard Foundation. Then we'll hear from the Youth Manifesto, and Oliver Baker Vomawo will close us off with a presentation that closes everything. Okay, so we'll give the floor to the Springboard Foundation, and then after that, the Youth Manifesto. So that we can manage this in an efficient manner. If each of you can take 15 minutes, no more, then it would be good.
We are from the Springboard Roadshow Foundation, and it's really a privilege to be here today. If you could kindly give me just a minute, I'll get my presentation loaded, and we'll be right on our way. Thank you so much. Pardon? Thank you very much. And at Springboard, we've had the privilege to work with young people over the years. And since we're talking about young people, I thought we could start with a conversation with a message from a young person. And this is what she has to say.
Some things that I could not afford myself, I'm able to take care of myself. At first, there are some things that I could not afford myself. I need to ask someone for support before I could do those things. But today, through the Empower 360 training, I've become comfortable. And after the Empower 360, the training we had, everything that they taught us has built me. And when I'm on the road now, or when I'm going to a church or a school or people's home to market my product, I have another level of confidence that I used to talk to people on that. So the Empower 360 training has really helped me. It's something that I'll say the money there, it's coming.
What we call it has albinism. And so she wasn't really welcome in society. But based on empowerment, based on training, based on capacity being built, she is now confident when she's going to places to market her product. And that is what opportunity can create for people. The Springboard Roadshow Foundation has been in the business of working with young people for the past 15 years. Our vision is to empower the next generation of African leaders and entrepreneurs. And basically, we continue empowering them through excellence and holistic development in every aspect of their lives. And over the past 18 years, we have done this across the nation and even beyond the shores of Ghana. We've had a database of over 500,000 people. And in this quest, we do not just use traditional media. We do in-person interactions. We do social media. We also, as well, do online interactions with young people. And in all, the key thing there is to say, what kind of entrepreneurship programs can we draw up for young people? How do we mentor them? How do we provide a psychosocial space for them to enable them look at what capacities they have? How can they tap into those capacities? How do we provide a safe net for them in order for them to thrive and to realize their Springboard Roadshow Foundation? Because we operate mainly in Ghana, we look at our constitution, and according to, to the constitution for what we have to do, and we looked at the national census that we had in 2021. Approximately, we have 30 million people, 31 million people. Since time have passed, I think we could safely say that we are about 33 million now. But we, the females, constitute about 50.7%, approximately 51%. Interestingly, the young ones constitute about 34%. Last time we did the constitutional count, but now we are about 38.2%. If we have 38.2%, that is 1 in 3 Ghanaians are young people. We can't afford not to have a constitution that does not speak to things that concern young people. And that is why I'm very grateful that we have the opportunity to be here at this table to talk about how we can provision for young persons so that their rights, the way they can express themselves, and so on and so forth, is seen to. That way, we are able to be ahead of the curve to avoid any potential economic instability. Because you and I know that when you are hungry, whether you like it or not, you can't think, and if you can't think, you will do anything you can to eat. No social unrest and reduce political instability. So we want to look at that opportunity that we have to do that. So therefore, I'll now ask my colleague, Mr. Akpanya, who is with our STARTs, our monitoring, evaluation, and learning, to take up from here.
Hello, good afternoon, everyone. So basically, I want to share with you our reach. We are here as ambassadors for young people, and we have engaged young people from every corner of Ghana, and today we bring you their voices. What young people in Ghana are saying. In the last 2 years alone, Springboard Roadshow Foundation, we've engaged 409,941 young people across all 16 regions of Ghana, in nearly almost all districts. As you can see, every green place, every green marked district, we have been there. We've engaged with every demography you can think about in Ghana. in a rural location, in an urban location, somebody with disability, a young lady, a young mother, every single persona of a young person you can think about, we've engaged. And mind you, so example, our mode of interaction, 200, we've been to schools, 128. We've done youth-led focus group discussions, social media. We've held community youth debates. We've had X-space discussions. We've had 4 youth surveys. 75% of the people we've engaged are young women, and 5,000 of them are persons with disability. Again, one might ask, why am I telling you all these statistics? I wanted to let you understand that we have engaged young people, and that's what the young people of Ghana are saying. And my boss here will speak more on exactly what the youth voices are. But if you take a look at our statistics here, these are people we have on our database, categorized by gender, age group. If you look at the age group alone, we're looking at those between age 18 or all the way from below 15 years up to age 35 in all 16 regions. If you look here on down below the gender, which is 75%, you can see employment status. Again, more than 2/3 are unemployed or are still in school. That means that the number of people who are about to graduate is more, and we have less than 1/3 in employment right now, as you can see from our statistics. Again, when you take persons with disability, every single disability, we work with the Ghana Federation of Disability Associations, and they categorize every one of them for us. So I'll hand over to my boss, who will then bring you youth voices from every corner of Ghana. Thank you.
Thank you very much. So I would walk us through about 5 things that are important, Mr. Chair. And these.
So just a second, let's show us. We just want to show you a video.
As a person with disability, I'm a programmer. I'm a camera. I'm a program. A month ago, I attended Empower 360 mushroom farming training by Ghana Brews. Today, I harvested and sold my first mushroom. I feel so happy to be part of the Empower 360 program. A big thank to MasterCard Foundation and Springboard Foundation. I said thank you very much.
Let me add one thing before I hand over. That it's clear, if you provide the young people of Ghana with support, even at the high level, at the constitutional level, they will thrive. The young people we've engaged, they don't feel there's enough support for them. We have enough evidence to show that if they are supported, they will thrive. Thank you.
Thank you, Mr. Chair. So I would walk us through just about 5 issues that we feel have been important so far as our interactions are concerned. So the first is grounded on the concept of regional balance. Now, in our conversation with a lot of the young people, the question is it time to move from regional balance to an inclusive balance? An inclusive balance. Because as a country, we seem to be very concerned about regional representation or regional balance. But how do we ensure that we are creating a very clear, concerted effort to ensure that persons living with disability are not at the charity end of our discussions? Women's issues are not at the charity end of the conversation. And the coinage of inclusive balance is a term we've put together to see whether we can front and center the conversation on balance. The whole day today, we've been having a conversation on the paramountcy and ensuring that at the chieftaincy level actually happens. And therefore, how do we ensure that women's issues, persons living with disability, are not at the end of charity, but they are front and center? The second thing is away from district favors to deciding together. Moving away from district favors to deciding together. Now, we in our research chanced on Article 240 which establishes that Ghana shall have a system of local government and administration which shall, and as much as practicable, be decentralized. Our suggestion is that each district assembly shall establish a statutory youth and disability advisory council to promote participatory planning and ensure that representation of the marginalized groups are dealt with. Again, we will bring these issues up. I mean, the committee, you are the lawyers, you know better, but how do we ensure that we're not, the disbursements from the district assembly to persons living with disability is not done again from a charity perspective, but it's properly grounded, that they feel they are part of the process. So moving away from district favors to deciding together, how do we encourage the setting up of a statutory youth and disability advisory council at the district level? The third one, Mr. Chair, is let's help in making decisions on who leads. Now, district chief executives are, maybe we could be wrong, but they are elected. And in deciding who becomes a DCE, the whole day today we've been speaking about inclusivity. And the question is that those who make the decision on who leads at the district level, should we be intentional about representation of persons living with disability and women within that particular mix? Again, we might not be clear in our minds as to how we get to achieve this, but if we listen to the debates we've had so far, it's clear that where there's a will, there could be a way. The only way we can front and center some of these requests is to ensure that those who make the decision in deciding who becomes a district chief executive includes those who must be beneficiaries of their actions. Mr. Chair, I move on to the next one. The next one we've couched a bit differently. Again, the language we're using is very everyday language. So it says, we respect the leadership of our traditional authorities. We want to help. So again, let's explain that. So traditional authorities, so there shall be the establishment of the Office of Administrator of Stool Land. So I was very happy when Nana Hema here made a point about the split of the revenues, indicating that 10% goes to A, 55% goes to FO. Now, the question is, Mr. Chair, how do we ensure that the traditional authorities include youth, women, persons with disability in the decision-making processes on the administration of the funds that come through? I know that we are already struggling now to make a decision as to whether or not women who are not chiefs can have an influence in how the money is spent or allocated. But if you are not at the table as a person living with disability, it becomes a bit more complicated. And therefore, how do we, and again, Mr. Chair, the request on this point is, how can we help? Because the revenue split is clear. It says, as an example, like she said, 25% goes to the traditional leader. 20% goes for development, 55% goes to the district for development. But the question is, can they play a role in there? The next one, Mr. Chair, is how can we help in managing the approval and exploitation of Ghana's mineral resources? Now, this should not be surprising to all of us. We've always said that the Ghana's mineral resource is for those who are dead, those who are alive, and those who come after us. But in truth, we live in a very complicated world a bit. And those who suffer the most, Mr. Chair, are not you and me, but the persons who are living with disability who now need to live with a double compounded issue. So the question is, how do we get young people involved? The manner and shape of the request, we don't know. But to the extent that they can participate in processes, then they can influence the processes. Mr. Chair, from there, I move to 3 more, and then we're done. Mr. Chair, I think we could be wrong, sorry. But the economic objectives of the country, we will quote that the state must promote economic development, reduce income inequalities, and ensure equitable access to production and employment. And I think I'm referring to Article 36, if my research is correct. Now, we want a bit of a tweak there. Explicitly integrate youth employment, entrepreneurship, and digital inclusion in national development obligations. And Mr. Chair, I think that where we are now, there are some things that ought to be front and center and not to be heading of a sort. I was happy when yes, you made a point about the influence of digital on the youth today. So how do we ingrain digital entrepreneurship from a constitutional point of view without having it just only live from a policy point of view? Because, Mr. Chair, anything which is living in policy goes out when government goes out. But how do we ingrain entrepreneurship properly, digital properly, innovation, and ingrain it that it lives beyond political or government rhetoric? Mr. Chair, I move on to the next one, which is a bit tricky. And this is a problem of reflecting the time in which we live. We say that the state shall provide educational facilities at all levels and promote moral and civic education. Now, our view is that there's a lot of language around today, particularly led by young people. So we are advocating for an inclusion of a clause mandating, 1, integration of leadership, 2, civic participation, 3, climate action, 4, assistive and gender equality education into national curriculum. And Mr. Chair, there are some decisions, if not taken now, as the poverty gap widens, we create a much more deeper hole for persons living with disability and those who are in the minority and vulnerable. Now, so when the economic objective it seems very general or very generic, we are at a time where we feel that there are specific conversations in the country that ought to be mainstreamed. And a typical example, Mr. Chair, is the plight of persons living with disability, and therefore assistive and gender equality is very key. My colleague, when he was speaking, this very month, we're doing education in schools, special schools. And Mr. Chair, where these schools are, if you follow the team to the schools, first of all, the schools are not in Dansoman or they are not in Achimota or anywhere else. They are in very, very already deplorable areas. So first, you are in a school that doesn't have the right resources. And again, the school is also in a place which is also a bit remote. And therefore, how do we ensure that this whole teaching of assistive learning is ingrained in mainstream education, that if they don't have to be heading to be educated, but as part of the main curricula, from Achimota to Accra Academy to everywhere else, the teachers and everybody else, they have a fair understanding of some basics. Yes, they have a fair understanding of some basics. So how do we ensure that these issues are mainstreamed and again, are not just frails that die over time? Again, the last two, Mr. Chair. What does cultural values mean? Earlier today, I think we've had a conversation about there's a need to promote cultural values and community cohesion. And it's come up a lot because every region you go to, every young person you speak to, they have a view of Ghana's culture today. And they ask us, how do we encourage for a constitutional protection of youth creativity, digital culture, and innovation spaces under culture and economic development? Mr. Chair, where the world is today, culture is not just you visiting some site in Timbuktu to have a conversation. There are digital properties being created, being monetized, but it looks as if, as a country, we haven't really come to terms with where we're going now in terms of what the real definition of culture is. And a lot is changing around the world. So how do we maybe provide a framework that protects youth creativity, digital culture, and innovation? Mr. Chair, the next one is, which is one of my favorites, is National Commission for Civic Education. Mr. Chair, and the charge for that is this: how do we empower or make an amendment to the Constitution that leads the NCCE to establish a Youth Civic Leadership Center? and conduct annual youth constitutional literacy programs. And one of the things that came up in our discussion before we came was that why shouldn't the NCCE be led by a young person? And it's something that I agree with, because at the end of the day, they are, in the greater majority, they are the framers of tomorrow. So can we as an example, in our attempt to ensure that we are providing some restrictive help for minority groups, how do we ensure that, as an example, an institution like the NCCE is youth-led? And how do we mandate the NCCE to set up the proper civic leadership centers across the country? Again, we've had a conversation about budget and whether or not within the current framework some things are possible. But we are only hopeful that when we bring this matter to the fore, it will be key in helping us make the changes that we need to make. And Mr. Chair, the last one is on quota and appointments, Article 70, 71. And Mr. Chair, that point we've gone through already. And how do we intentionally create quotas for young people to do specific things? And if the committee is looking for an example, I've just mentioned the NCCE, and we feel that there's a language of young people today, and it's important to consider that. Mr. Chair, the last bit for us is, one of the things that came up a lot is whether there should be taxes skewed towards young people. Mr. Chair, we know that in some countries they have a startup act. And when you have a startup act, the young person by default gets access to the benefits within the act. So would it be possible that in this constitutional review process we're going through now, can we find a provision in the Constitution that mandates the need for us to have a Startup Act? And then out of that, we can then have a statute that governs startups. Otherwise, we are locked on maybe an NEIP program, a YEA program, and we don't have a properly, clearly defined roadmap for how we support young people. So, Mr. Chair, these views that we've expressed today are views that we've gathered from young people in our 48 districts across the country. And we have a dedicated call center at the foundation where we're receiving calls every day with specific requests. So these are at the top thematic levels how we've synthesized the issues that have been raised. And I'll just read one last thing. Yes, and Mr. Chair, apologies, the last one. The last one is just a concern on issues related to land tenure system, galamsey, among others, and how do we ensure that young people have the right access to things. We believe that some things may be dealt with by existing statutes, but some of the things that we are also asking for are, once we ingrain some of the things in the Constitution, it lives beyond policy, it lives beyond government. And with that, we thank you very much.
Thank you very much for laying out your agenda very clearly. We will take, I think, let's take this together with the Youth Manifesto Coalition's presentation, and then we can take on board the two before we...
Right, thank you so much, Mr. Chair.
Please introduce yourself.
Right, my name is Christopher Wisdomfanu from the Ghana Youth Manifesto Coalition. The coalition is made up of young people from the 16 regions of Ghana, including youth leaders, organizational leaders from the civil society organization, as well as student bodies. I think the makeup of the population of the country, over 73% of the population are below the ages of 35. And then rightly, as Madam Comfort said, 38.2% are youth between the ages of 15 to 35. But unfortunately, when it comes to their inclusion in terms of decision-making process, in terms of our democratic governance, they seems to be marginalized. They seems not to be included. So 2023, we began another journey with respect to influencing political parties' manifesto. So we went around, did a survey with the support from our partner organization, Foundation for Security and Development in Africa, as well as Oxfam in Ghana and a couple of other youth-centered and youth-focused organizations. Now, what we came out with, we went around influencing the political parties' manifesto with the Ghana Youth Manifesto. We have the document available as well as the report. And one of the main recommendations from young people is a review of the 1992 Constitution. Why? Because they said that it is not youth sensitive and it is not youth relevant. So this presentation, basically the objective is to make sure that at the end of this entire process, the 1992 Constitution becomes youth sensitive and youth relevant, in essence, become youth inclusive. So we'll identify some key articles that are youth relevant, but not explicit. So we have Article 25, which of course, right to education to everybody. Article 29, which directly refers to right for persons with disability. I think most times PWDs refers themselves as persons with disability and not persons living with disability. So that when we are using the phrase, that should be well corrected. So persons with disability and not persons living with disability. And then of course we have other articles as well, which have to do with Article 37, Article 38 and on. So those are some of the current provisions that deals, as well as Chapter 6, the direct principle of state policy and on. Then we come to 94, qualification and disqualification of members of parliament. Of course, which we see the tone of that, the qualification have to be the age of 21, but in terms of voting, 18. So you are qualified to vote at the age of 18, but you are qualified to be a representative of the youth class at the age of 21. We see that there is a bit of gap over there, which will come to later. And we also, in terms of Article 62 as well, qualification for presidency at the age of 40, which, of course, according to the NYA Act, which defines youth, it means youth are not included at all when it comes to the presidency. So youth are not seen there, and they are not, excuse me to use this way, it seems like the Constitution don't regard you to hold such a position, which I think that is the highest level of discrimination. Of course, so now we are coming, so those are some of the articles are kind of relevant to youth. But now the next action have to do with the areas for improvement and the gaps. Number one have to be a lack of explicit recognition of youth in the 1992 Constitution. We don't have explicit recognition. But like I already alluded to, we have over 73%, as in below the ages of 35. But majority, 38.2%. So if indeed we are going by the definition of democracy, of which we are practicing, which is government of the people, by the people, and for the people, then I think it is more appropriate for us to make sure that this group of people, which form the majority, and I think 2020, according to EC's data, over 55% of the voters were between the ages of 18 to 35. That's 2020 data. 18 to 25. Again, majority who decide who becomes the president, who becomes their representative. But of course, they are not regarded when it comes to the constitutional representation. So based on that, we want that to be rectified in terms of that gap, that explicit. So in terms of recognition of that, we are proposing that. Okay, I'll come to the proposal later. Let me just read some of the gaps. So again, another gap or areas for improvement have to be the aspect of youth empowerment and participation, which of course, we are looking at education, skill development, and entrepreneurship, rightly mentioned by Springboard. Also, inadequate attention to youth-specific challenges. We are in the 21st century, which, of course, there is a lot of involvement, right? Things are evolving so fast in terms of the digital space. So how do we now fashion solutions to solve youth issues when it comes to this arena? Including, of course, in the morning, we did hear about the mental health issue. When you are browsing across the digital space, you come across a lot of abuse, digital abuse, cyber abuse. How do we create systems, enabling systems to make sure that young people are well catered for in such a space? We also have age discrepancies when it comes to political parties representation. Like already alluded, it seems like the Constitution is more interested in age-matured leadership and not necessarily when it comes to the competence. And because we believe that leadership got nothing to do with age necessarily. It got everything to do with capacity. It got everything to do with competence, and it got everything to do with collaboration, not necessarily the age of the individual. Now, our main areas for recommendation or constitutional provision recommendation have to be amendment to the preamble. That because one of the gaps we identify have to be non-explicit mentioning of young people, which form the majority. We want the preamble to be amended to include young people. Sorry, my phone is off. I think the final portion of the Constitution did mention an aspect of the people. So we are suggesting that we can just amend that and by adding youth and the people of our nation. So in that perspective, we know that the majority that forms the population of this country are well noted when it comes to our democratic governance. Number two thing we are searching for or requesting for is the direct principle of state policy by adding a new clause within the chapter 6 of the Constitution, which is the direct principle of state policy, to address these specific issues, promote youth development and empowerment in all spheres of national life, including education, skills development, employment, entrepreneurship, health, civic engagement, and political participation. Then second under that is to ensure the protection of youth rights and create opportunities for their full and meaningful participation. Then again, the chapter 5 of the Constitution, which largely speak on the fundamental human right aspect. Again, there is an aspect which mentions the right for women, the right for persons with disability, but again, the majority of the population, which is the youth class or demographic, are not mentioned. And they are the most marginalized as well. So we are proposing that it will be more appropriate, since they are the most marginalized, for them to be explicitly mentioned in there. And in terms of the mentioning, we have to tackle the issue of what's the name, right to specific youth health care. So we spoke about the issue of mental health, which predominantly young people are mostly affected. I think recently the government of Ghana, through the Ministry of Youth Empowerment and Development, launched a program which is Stop Red, which I think is a laudable initiative, but we think that if we have a constitutional provision which largely address that, that will be, sorry, my machine just went off. Sorry, just a moment, my machine just went. Okay. So our next point under that, again, as I said, with respect to that have to do with the mental health perspective, so that young people who are largely affected in this ecosystem can be well catered for when it comes to the health implication, when the health implication they face under the mental health issues. Okay, sorry. Okay, good. Right. So, sorry for the inconvenience. Our next recommendation falls under the fundamental human right. So we are asking that the committee consider adding a clause to the chapter 5, like I said, which also deals with right to skills development and vocational training. The world is moving very fast, so when it comes to our educational system, we have to make a deliberate attempt to make sure that young people have the skills relevant to the 21st century. So why don't you bring into perspective technical and vocational training, and of course, science and technology, which is, and mathematics and engineering, which is STEM. Then the next one have to do with the lowering the age for the presidency. In this case, agreeing with Democracy Hub, we want it to be open, in essence, from the age of 18, as far as you are qualified to vote, you should be qualified to stand for any position at all. But in as much as that, if that is not going to be possible, we are requesting that then we should cap that at the age of 30, right? For young people to also have a representation when it comes to the presidency. Our next request have to be youth representation in governance structures. We are requesting that we explore constitutional mechanism to promote youth representation in parliament and other governance structures. This could be done through co-test system. For example, we have the affirmative action law, which dedicates about 30% minimum to women. We are requesting as well, young people being the majority and the most marginalized. We also have to have a seat, at least a minimum, at least or minimum of 30% wouldn't be too much to request for or ask for. Then our next request, and that has to do with the establishment of Youth Development and Empowerment Ministry, of which we already have. But we believe that if this is a constitutional instrument, it will be more laudable. Under that, there is a proposal for the Ghana Youth Federation, which we believe, of course, with respect to what Springboard also noted, Ghana Youth Federation is an instrument of the National Youth Authority Act. So we believe that instead of having another name, let's maintain the Ghana Youth Federation, but this should be sponsored by the state to make sure that its essence and true integrity is held to, so that in terms of holding government accountable, in terms of promoting youth activism and advocacy, it can be truly manifested. I think basically these are our main, our surveys are still ongoing, but these are our main input that we want to share with the committee, aside some other decisions that contains in the document we sent to the committee. Thank you.
Thank you very much. Any questions from the committee members? You can start.
Thank you very much, Mr. Chair, and thank you for your presentations. Just want to ask a question from the Youth Manifesto. You mentioned 30% of political representation, minimum. So what's your maximum? So you want maybe a parliament made up of only young people?
Since they are more marginalized, but they form the majority. And as defined by Abraham Lincoln, government of the people, by the people, for the people. And the majority of these people are young people, yet they are the most marginalized. And it seems like the Constitution seems to be promoting age-matured people into these spaces. So, for example, when it comes to the age for the presidency, you have to be 40 years. The National Youth Authority Act defines young people between the ages of 15 to 35. So that is what defines. So at the age of 36, you are not a young person. And young people, which form the majority of course, that's why I did mention about the EC on data 2020, which of course proved that 55% of the voting population, which of course this demographic decide who becomes the next president, becomes the next representative, are young people, 18 to 35. But yet, they don't really seem to be having representation, and the Constitution is barring them from the presidency.
Hold up. So if your argument is based on demographics, and those things change over time, so let's say in 10, 20 years, if it turns out that we have a majority of Ghanaians being above 40, should we change the Constitution to make it more representative again? Because your whole argument seems to be based on the fact that the youth, in terms of current demographics, are in the majority. And so for that, we should amend the Constitution to give them 30% minimum. So if the demographics change, because you see, constitutions, when you're drafting a constitution, when you're crafting one, you need to think through all the possible scenarios, which none of us can really see at this point. So if in 20 years, it turns out that Ghanaians are not having babies, so majority of the population is in the 60 to 75 age group, should we amend the Constitution and give those people minimum 30% opportunities?
Okay, I can help my colleague. My name is Theodora Anti. We are part of the conveners of the Youth Manifesto. So the argument of the demographics is just one out of the many issues why young people need to be at the table. And so we have the demographics, we have their basic needs, just like we have the group of women, the group of people with persons with disability and all of that. Young people are also a very peculiar group with their own very needs. And we also understand that a lot of the systems we have, be it education, be it health, be it this, be it that, also serve young people with very, very peculiar needs. But when you get to the table, traditionally we say young people, are not wise enough, or young people don't have they don't have experience, the relevant experience to be at the table. And there is a whole lot of things that marginalize young people, and young people are not at the table. You take the Ministry of Education, for instance. Education is about young people, but when you come to the high level of decision-making concerning education, young people are not consulted at all. We have the Education Week or the National Education Forum that goes on. Young people are not invited. Where they will tell you, oh, the students are fighting among themselves, and so they are not invited. Currently in Parliament, you have only one person who is, I think he's 34 years. That is Agbana. He will be 35 soon. And then it means that per the age of, as constituted in the national policy, young people are not represented, but they should have a voice at the decision-making table because they have peculiar needs, because they have peculiar issues. And so young people should also be at the table. So it's not just about, so the 30% we are talking about is minimum, just like we say for gender or women representation and other issues. There is no maximum to, if we can have all young people contest elections and win and be in parliament, why not? But at least there should be a minimum provision that will make sure that young people's voices are at the table. And that's what we're asking for.
And I really support the arguments for inclusivity. That's important. But my challenge with what I'm hearing is this. You are citing a policy that defines who a youth is. The Constitution has not told us who a youth is. So if the policy was changed tomorrow and it said that a youth is anybody between the age of 18 and 50, all your arguments on a constitutional basis will fall flat. So I'm trying to figure, because you're citing policy and we're dealing with constitutional amendments. So we could easily change the policy tomorrow and say, which would now include more people in parliament than the one person you've cited, because we've increased the age and we get to decide policy and say that anybody below 50 is part of the youth. That would solve a lot of your problems immediately, because so many more people are included in that demographic. But it doesn't deal with the inclusivity issue you're talking about. So, and then you're citing a lot of things that are not constitutional or legal. I have never been anywhere where they said young people don't have wisdom. I don't know where you're getting that from. I've also never been, and it's not legislated. No, it's not legislated. So we must be very clear we can't just take statements out of the air and elevate them and use that as the basis for constitutional amendment. Inclusivity, yes, and it's not just youth, people with disabilities, women. Nana Hima has made a very strong case today for females in traditional leadership, female chiefs and queen mothers. And even within that demographic, guess what? When you get in there, there's probably age discrimination. But am I supposed to go and tell a traditional area that you should nominate a young person as chief or queen mother because we want to balance the inclusivity? We also know the remit of what we're doing. So I think your arguments for inclusivity, yes. But the framing, I think, is where I'm having some challenges with it. Because if you're basing it on policy and on sentiment, it's not helpful. Okay. All right, so.
Yes.
Okay.
Okay.
All right.
So just note the question. Note.
Go ahead.
So the other question I wanted to find out from you has to do with the 30% representation. Is it in Parliament? Oh, sorry. Is it in Parliament or the district assemblies, traditional houses of chiefs? Where exactly do you want to play? Everywhere, yeah. Is it board representation? So everywhere. Okay. Now, shouldn't you put yourself up for election? Or you want special provisions to be made for you, if I understand you? For example, let's say that we carve out a seat for the youth for election. Is that what you are looking at?
That's not what we're asking.
No, I'm not referring to what they said. That's my own suggestion to them. Is that what you are looking at? That we should carve a seat for you in Parliament, for example?
So the quota system have to do with the issue of the marginalization. And because of the society we've created, which makes the youth more marginalized. So for example, we have a couple of friends over here. One of them I know for sure, who went in for the Council of State election. He couldn't make it, but an age-matured person ended up making it. Now, and a lot of that has happened throughout the system. So the point we are creating is because of the marginalization, the system we've created, which have marginalized young people, it is better to solve this by allocating a quota, a 30% quota for young people, just like in the issue of the marginalization of women.
Okay.
That's
Doc,
why I
please,
asked you. Okay.
Doc, please, can I come in briefly? Okay.
Okay. So that's what I'm asking you. The quota system, how do you want it to be done? Is it by election? Should we reserve some seats for the youth, the disabled, or persons with special needs? Is that what you're asking for? Just, I want you to be clear, that's all.
So, yes, but it's not just persons with disability. I mean, youth in category. Either the person is person with disability or not, as far as that person falls within the category of youth, it's a youth. So the 30% quota is 70 from the local level to the national level.
So we could create, let's say, 3 different seats, one for the youth, disabled, and let's say women. Okay, so that the people who contest, for example, for the disabled will be persons with special needs, and the youth will also contest. Or do you want them to be nominated?
No, I don't truly get the question, but for the positions that are elected, of course, that seat will be, in terms of the election, may be contested by young people only. For the position that demands an appointment, of course, the appointing authority must make sure that 30% of the appointment goes for young people. That's our call.
Okay, so whether they're elected or not, all you want is 30% representation.
A minimum.
But my question, which remains unanswered, is do you want a seat to be created for the youth in Parliament?
Yes, that's the main call. And I'm saying that it's not just in Parliament. So I'm just laying emphasis on the fact that it's not just in Parliament, but all around, from the local level to the national level.
Okay. All right, thank you
Thank
very
you so much, Doc.
All right, so thank you all for your presentations. I think there are a couple of things I think I'm hearing, and there are a couple of things I'd like to clarify. It would be clear if perhaps what we're hearing is, if you look in the Constitution, Article 27 specifies women's rights. Article 28 talks about children's rights. 29, rights of PWDs, and 30 is rights of the sick. So if you're making an argument that youth are actually invisible in here, because we presume once you hit 18, you're an adult. That's where we classify you. But then we also have this demographic that is growing, etc. And so is the argument that, number one, let's start by even recognizing that there's a category of people whose needs may be different, who need some provisions made to secure them. Hence, the need to, first of all, acknowledge that particular group in the Constitution. Then from there, we can now look at, okay, what are some of the things, provisions that can be made? A lot of what I've heard so far are programmatic as opposed to constitutional. Things that would fit in the programs of, I wrote down 3 categories: local government. And I think one of the things I'm hearing from my colleagues, there's nothing that, not mandates, there's nothing that restricts young people from getting into, district level, district assembly engagement, et cetera, And so if it's not happening, then how can we make that happen? You mentioned the NCCE. And then there's local government, there's NCC, there are manifestos, political parties being encouraged, being pushed to actually have space for including underrepresented groups, youth, one, women, PWDs, etc. So I think we have to separate programmatic needs and, provisions from constitutional provisions, because at this level, if you advocate for youth being recognized in this document, then all the programmatic advocacy, etc., can stem from there. But if we're invisible in here, I'm using we, because I'm youth. If we're invisible here, then perhaps even at the programmatic level, there's little that we can do. So I think we have to look at what fits in a conversation on the Constitution and what fits in a conversation at the program level within the various agencies, political parties, etc., so that we can actually elevate and include younger voices, etc. I thought you were going to, on the presidential age, I thought there would be an argument for let's cap it. And also in terms of, I think you mentioned 18. And one thing comes to mind. We have, I don't want to overgeneralize. I know of young people who are solid breadwinners for the entire family. They take care of their older parents, their siblings, etc. And I also know young people who spend all their time on TikTok, right? It's the whole range. And we all fit in there somewhere. But how do we get, I think there's a case to be made that you can take up as part of your advocacy that actually begins to look at working with an agency like the NCCE to even bring awareness of the Constitution and what's in it. I think that's the first part. A lot of times the resistance you find to young people being involved in the political process is because there's a lot of, ignorance sounds like a strong word, but it's, ignorance of what the Constitution says. And so if you say a young person should stand for office, etc., the first question is, do people even understand the politics? Or is it a desire to mimic what they've seen some of the adults do? Get in there, make some money, move on with your life. And so I think there's value in going back to what fits into the Constitution, what fits into programs, and then starting from there and saying, first, recognize us. And then we can actually look at encouraging and where mandating is possible, yes, mandating local authorities. So if you say district assembly, there should be not a quota system, but political parties, when they present their manifestos, etc., we create an environment where they are compelled. We won't vote for you until we see that you've captured the youth voice, PWDs, etc. And I think that's a programs level conversation that may not necessarily, fit in here. All right, so my question is really seeking to clarify or to make that distinction. And I'm sure there are other more direct questions. Chairman always has a nice long list of questions.
So. No, just to build on Dr. this line of question or a contribution. So when you take let's take one constitution. Let's take the Kenyan constitution, right? Unlike Ghana's, which has no, the section on the Bill of Rights, the Kenyans make a distinction. For example, there are sections on children, and then there's a section on youth, then sections on persons with disabilities, minorities and marginalized groups, older members of society, right? So the Kenyan Constitution separates these various categories in the demographic categories and provides for them specially, provides what kinds of rights must be tailored to that particular category. So I understand your point about youth being missing from the Ghanaian Constitution. So unlike the Kenyans, we don't have anything about youth. There's something on children, which is different from youth. So that's the point she's making. If you want to be present in the Constitution, that's the first, the first way you get in the door. Then you're saying, okay, the youth category as defined by a statute is 18 to 35. And yet, to be member of parliament, which is the first body, you have to be 21, right? So maybe you're saying, okay, if the proposal is, why don't we just drop it to 18? The moment you are entitled to vote, you are entitled to be elected to office. Fine, so that one I can understand. And then you say, well, the presidency also starts at 40. So if you want the youth to also have a shot at that. Maybe you drop it to 30 or 35, right? It gives you 35 gives you only one term. You may not even finish. I mean, just one term. Then you are, or something like that. No, sorry. So you drop it to 35 or 30. In that case, all the offices that we vote for, the youth can actually compete for. So from 18 to 35, you are eligible to vote, eligible to be elected to office. Fine. Now, the issue that I think is the interesting one is about special representation or special quotas and all of that. The youth is not, you are not a minority, demographically speaking. You're not a minority in the population. You're not a minority in the voting population either, right? And the case for getting special representation when it comes to women, for example, who are also not a minority, numerical minority, is that there are certain structural things in the society, in tradition, in history, in whatever, that excludes them from the way we do when we do our politics the normal way. It just doesn't favor them. Now, are you able to make the same argument for youth, right? Say Ghanaian youth. Let's take Ghanaian youth, right? If there are certain structural things in our politics that's excluding the youth, then maybe you could say, well, let's attack those ones. For example, money in politics, big time, right? Our politics is structured in such a way that you have to have plenty of money to win a seat. And that structurally disadvantages women and youth, actually. You have to have, if the minimum you need to win an election is $100,000, I mean, where are you going to get it at 18 or even at 35, right? So then you target those structural features and say, okay, how do we regulate politics to take money out, or how do we regulate campaigns so that they are cheap? Maybe public funding, maybe some of those proposals. We can work at those ones. It doesn't mean that they will eliminate all the problems, but I think the case for, because when I look, I mean, youth is a transient stage, so we all used to be there. We've moved on. But I see, when I look at our politics and it's playing out, I see a lot of youth participation in the politics, right? The parties direct a lot of appeals to the youth. It's almost like their whole manifesto is directed at the youth. Sometimes they are even at the risk of bankrupting the country. Everything they want to do is for the youth, right? So you would notice, a lot of manifesto promises are directed at the youth, because that's the key voting population. Very little is directed at women, right? Everybody wants to do, free stuff, free days, a lot of it, paid for, not by the youth, but most of the appeals are directed at the youth. So you get a lot of attention from the politics. I look at the number of, party communicators, government communicators, a lot of young people. They are all, playing these roles in the parties. You have a lot of say in these parties. The people following the presidential candidates are all young people. So what's the structural exclusion that you are suffering from the politics, right? The politics seems to be actually playing to you. They are playing the politics to your side, right? And if the exclusion is the money, then that's something that can be dealt with by law. You can regulate politics in such a way that it takes the money out. Public funding, state funding, regulating how much parties spend, how, removing barriers to entry for young people, all of those things. But to say that because, I don't think your situation is like women. That's what I'm trying to say. That in the society in which we are, there's a lot, of course, there are intersectionality issues around, young women. That's different. But the youth as a category in our politics, I don't think, and I'm being provocative, I don't think by analogy you can just say, okay, because we have accepted in principle that women, in order to get adequate representation in our politics, deserve affirmative action in the form of a quota or whatever, that the same argument applies as easily to the youth as a category. And I'm yet to be persuaded by you that that is indeed the case, right? Because I think I see, and maybe it's just, I'm just seeing, I wear glasses, so maybe I'm not seeing right. But I see a lot of our politics being geared towards young people. A lot of young people's issues are taken up by the politics. Everybody wants to do youth in agriculture, youth in Galamsey, youth in all of these things. Everybody is trying to do something for the youth, right? All these youth programs that are proliferating, free tertiary, education, entrance education, free this, free that, all geared toward the youth. So why are you feeling excluded and marginal? Why are you calling yourself marginalized? Right? So it's not that you don't have a point, but the way in which you want the issue remedied is what we are talking about. That maybe the quota is not your kind of remedy. Your remedy may be other barriers to entry into politics that can be removed, actually, and may not be that easy to remove for women. So it's the same solution that might work actually for representing women may not actually work for representing youth in this situation. And that's the kind of stuff I want you, in addition to what Dr. Isiasa said, I want you to think through in terms of concrete proposals. I'm happy that a lot of the proposals or things you have talked about actually are not strictly youth things. And I like the distinction you made between youth sensitive and then youth relevant. There are a lot of things that don't look like they affect youth, because you don't see youth written on the face of it. But when you go very close or deep, it does have a lot of impact on youth. And the way we do our politics is one of them. So I have to concede, absolutely. The way we do our politics, we can't elect young people. It's just not going to happen because as money has taken over the thing. But it also applies to women. The way we do our politics is also very muscular. Maybe that helps the young men, but not necessarily the young women. So there are all kinds of things that, if you focus on it that way, it might help us more. Maybe too much corruption doesn't help young people get into politics or jobs. If there's too much corruption in the administrative sector, to get a job, you have to pay a bribe, 50,000 cedis to get into a public job. How are young people going to get it? Maybe the retirement age. People have talked about it here. Is it? But some people are saying we should raise it. You have a position on the retirement age. Does it affect, young people's prospects? So look into these various ways, and not just get bogged down on the quota, because it might work for some, but not for you. So.
Chairman, let me throw in this one before he comes to answer. I have just looked at the National Youth Authority Act of 2016. All the things he's saying are captured under either objects or functions. They are all there. Is it his case that we should elevate them into constitutional? Everything is there. So use training, skills, leadership, conferencing, whatever he wants, what he has just spoken. I believe he took them all from here. Is it his case that these things should be elevated into constitutional provisions? Otherwise, I do not really see, apart from 40 years presidency and the rest, nothing. Is there anything you have said which is not here under the functions of the authority and the objects?
Okay.
Question from our member online, Aladi Tanko, and then we can come to the. Okay. So after Tanko, we'll get to you.
All right, thank you very much,
Sure.
Mr. Chair. Hello, can you hear me? Hello, can you hear me? Okay, all right. So just to add to the last point you made, Mr. Chairman, I think, when we talk about the youth, as a very broad category, is not very helpful, particularly in looking at what needs to be done, because the youth is not a homogeneous group. Yes, we know that they are defined by the age group and etc. But you have young women, you have young people with disabilities, you have young persons without education, I mean, etc., etc. And therefore, if we don't look to disaggregate these things and then we talk about the youth, there should be a quota for youth. Are we looking at young men, always saying that this should be further disaggregated? And I think it would have helped the submission if they had maybe looked at sections of the Constitution where they think that, amendments or revisions would make a case for, the different categories of youth to make them participate more effectively in national life, etc. And I also agree with Dr. Isi's points that a lot of what they are proposing can actually be dealt with through policies, programs, legislation, rather than finding expression through the Constitution. I think those in the Constitution, and we had a discussion within members of the committee, that, for some of the issues to address them, you need to look at the broader context. So if we're looking at youth exclusion from decision making, for example, as Chair rightly said, maybe it's not a quota, but to look at what disadvantages young people when it comes to participation in decision making, the cost of doing politics, maybe the socio-cultural context, and etc. And those are things that can be addressed, particularly the cost of campaigning, etc., through the Constitution, but not going directly to say the youth have to have this, the youth have to have that. Over.
Make a couple of comments on the subject of disability. The section of the Constitution on rights of disabled persons, that's Article 29. For the presentation that we just heard, you made a proposal, the establishment of district advisory centers. I didn't get the full name properly, but the idea is a district advisory center. It would be useful to hear some elaboration on the role and function of such a center. Why? Because the Constitution has some beautiful things to protect people with disability, but we still continue in our society to see how discriminated this section of the population are subjected to. Look, for instance, Article 29(1). Disabled persons have the right to live with their families or with foster parents and to participate in social, creative, or recreational activities. And yet, look on our streets, in the villages, everywhere. People with all kinds of disability are neglected, thrown onto the streets to be on their own, and are abused left and right by people in the streets and so on. So the presentation, what must be done? Are there things that the Constitution can do? Some of these things seem to me to be problems of implementation, execution by state authorities for all of this. I mean, the things said here are very fine. That's why I'm asking about the district advisory centers. The social welfare department of old could not do everything, but it seems to me that it was more effective in doing certain things than whatever system we have today. So Is there something the Constitution can do to improve the situation? These advisory centers you are talking about, and is it something you would want inserted in the Constitution as a part of local government system, or what? And again, there's so many things here that should protect these people, and yet nothing goes on. So what do you say to that? What can be done to improve the situation beyond, the Constitution and the institutions that are charged to do that? Coming back to the youth thing, there are some areas, and again, even before I come to the youth thing, on persons with disability, at the traditional level, there's also a problem there. At least I know that among the Akans, I'm an Achim, of course, not from the mafia, but objection. You cannot be a chief and stood as a chief if you have a disability. In fact, in the past, I don't know about today, in the past, for the Achims and the Asantes, even if a boy was circumcised, he was supposed to be disabled and he couldn't become a chief. So what do you say to that? Can this, since the Constitution or the state now takes over the whole question of chieftaincy, do you think it is something that ought to be fought here also? Because being, for instance, having been crippled by polio, maybe that's not the right word, doesn't mean you can't think. There are many, there was this famous scientist who had suffered from cerebral palsy, greatest scientist in our era, yes. So is that something that you think the whole question of disability must engage? Thank you.
Okay, so no, your colleague had some. Oh, I thought you were done, and she wanted to. Rachel had something to.
I think some questions have been posed, so I just want.
Okay, you want to respond.
So I think we enumerated about 5 key provisions that we were looking at, and the reserved or the quota is just the final one out of the 5. The first one that I said was, the first 3 actually is looking at the constitutional amendment, because one of the key things that I said from the very beginning is the missing of youth as a demographic in the Constitution. So the first recommendation was for the amendment of even the preamble to make sure that it's so that young people can own it. And number 2 under that is the direct principle of state policy, which is the chapter 6. Again, I quite remember I did mention that this should be reviewed, since we have demographic under that, which kind of was very explicit on persons with disability and then women. So the Constitution under the chapter 6 should recognize young people. Then when I came down on the chapter 5 of the Constitution, I did also mention that because we want this to be youth sensitive and inclusive, that chapter 5 can also go further to recognize the rights, the fundamental right of the youth. So these are the first three requests by the Ghana Youth Manifesto Coalition. And then the 4th one was actually dealing with the age for the presidency. Yeah, that's what we and then the quota system was just the final one to climate. So just to rehash our point. Thank you. So our proposal is that we should just take this thing off, but in case it cannot be taken off completely, then let's hang it at 30. Yes. So both the MPs and the...
No, the MPs is 21 already.
Yeah, MPs is 21.
You wanted to come to 18.
Exactly, so, yeah.
Okay. You know, we have one more, one last, before we go. So, you are on the border of the youth now. You are very soon. You will be tipping. You'll be tipping over, and if you are not already gone.
Mr. Chair, so should I attempt to answer the question? So, Mr. Chair, I would take some small time to try and push the answers through. So, Mr. Chair, if we go back a bit, the key word for us in our submission is on intentionality. And if you pick the kind of effort in quote and the intentionality we've attached to women's issues, the women's issue has become front and center of decision making. Our charge and ask for support for persons with disability is to require some intentionality. So I would now begin to answer your questions. So, Mr. Chair, if you referred me to Article 29. Mr. Chair, if you go through 29.1 to 29.8, it seems more protectionist than empowering economically and providing a platform for persons living with disability to be more than they want to be. One talks about they have the right to live, a disabled person shall not be subjected to the differential treatment. So all the key things listed in 29 are more of protection. But for how long are we going to protect persons living with disability? At some point, we need to make clear decisions and put protections in the Constitution that says that, as an example, and I quite remember there are portions that say that progressively education must be free. So at what point can we language in our Constitution that over a period of time, we must begin to move from this protectionist conversation in the Constitution into real tangible support for persons living with disability? And Mr. Chair, I'll give you an example. The current appointments of ministers today, how many of them are persons living with disability? But there was a lot of conversation in the country on how many women have been appointed. And we always embraced the fact that women have been appointed. Every time appointments are done in the country, we look for the gender balance of the appointment. Which is because we have made women's issues front and center. So if we sat here today to say that of the appointments that are happening today, coming up today, 20% of them are persons living, persons with a disability. Persons with disabilities. Then, Mr. Chair, then we know that we are moving beyond protectionism into making persons with disability front and center of our conversation. So hence, Mr. Chair, our humble submission is to say that the protection here is good, but beyond the protection, what next? Would we keep this language here for the next 50 years? It may not be enough. Number two, Mr. Chair, is at the district level, we can make the reference to 2676. And Mr. Chair, if my memory serves me right, 2676 is what the Queen Mother spoke about in terms of the allocation of resources. Mr. Chair, and may I refer to 26776? It says that, one second, Mr. Chair. Yes, I'm moving into, because that was the second part of Queen Mother's. I apologize, Mr. Chair.
No, this, and then the D is 30%. Is that the one you're talking about?
No, Mr. Chair. I want to go to the allocation of royalties.
Oh, allocation of royalties.
Yes, Mr. Chair. Yes, and the natural resources. Mr. Chair, 267, yes. 2 provides for the following. Sorry, 2676 says that 10% of the revenues accruing from stool lands shall be paid to the Office of the Administrator of Stool Lands to recover administrative expenses, and the remaining blah, blah, blah. 25% would go to the Stool through the traditional authority for the maintenance of the stool. Maintenance of the stool. 2, 20% to traditional authority. The what, I don't know. And then the last one says 55% goes to the district assembly within the area of authority of which the stool lands are situated. Mr. Chairman, we all know in this room that it takes a lot for even the disability share of the district assembly common fund to go to them. So our charge is this, that if this formula is even framed in this way, if the only way to attempt to take part of this to support the work of persons living with disability at the district level is to amend this provision here in the Constitution to say that at least even if 5% of the royalties goes to support activities of persons living with disability, Mr. Chair, it would be great. Then the third bit is that how do we ensure that we are properly administering this? And Mr. Chair, without a council which has representation of persons with disability, if the administration of this again goes back to the district assembly, goes back to the chiefs, the money won't go. So our ask for the advisory council being made, and again, I don't know whether it will be an independent body or a quasi-independent body. Again, I don't know the English for that. But we're saying that there is a structural change that must happen on ground. And solving this problem must start from the district's rural level. But that's where the problem is prevalent. At the national level, we'll speak all the nice English and drinks all our coffee. But like you yourself said, when you drive around, the problem is big. So our charge, and we take cognizance of anti-AC submissions, that some thinking should be policed more than constitutionally amended. And therefore, we side with that fully. However, giving part of this money to support persons with disability, Mr. Chair, requires an amendment to 2676. Number 2, if we take part of this money and give it to the existing structure of the chiefs and the district assembly, administering it won't work. And the last one is that we're pushing for this because we believe Ghana must begin to move from the protectionist thinking for persons with disability into a proper economic amplification of that which they are. And with that, I hope we've made some sense with our answers. Thank you very much.
Thank you. Oliver, I know you can do it in 5 minutes.
I understand that we have all been retained here the whole of the day. A lot of what we have put together we'll share with the committee by writing. I think it's a 29-pager in any event. But the vast majority of it spends time trying to frame it in terms of how it will look like, in terms of it as a constitutional language, and also some comparative examples of how it's done in other places as well to guide the committee. I think for us, first of all, I'm here. In the morning, I was here with Amnesty. In the afternoon, here with Democracy Hub. I want to acknowledge also my colleagues. Several have been here with us from the morning for us to be able to make our submission to the committee. So that in the time, I'll just say that Democracy Hub is interested in how we can find organic mechanisms for grounding democratic accountability within communities and connecting them with resources in that regard. One of the biggest things that we were thinking about in terms of our biggest value add to the process, and as many people know, that our consistent advocacy has been on the call for a new constitution for a new generation. So our engagement in the process, our understanding is the best framework for so many of the things that we are talking about. But there's still room to be able to engage and see ways in which we improve the process. The big thing that we're thinking about was around a number of questions, particularly what is it about the current provisions that have made them susceptible to being ignored, and what value add is adding more to what we see is already under enforced. What would that create, or what benefit would that procure us? And towards this conversation, we have a presentation is in 2 parts. First, many years ago, I had the privilege of being on the other side And we said we produced a document where we said we're moving it from a political document to a developmental document. All we did there was to ask for the plan developed by the National Development Planning Commission to be binding. And that's how far developmental we made the Constitution. We're asking that this process should be towards an enforcement-centered Constitution. Now, to be able to get into the proposals we are making, I was saying that the first part is about how we ensure constitutional compliance, and the second part is more about intergenerational equity and people-centered measures into the Constitution. First, let's set the stage as to how do we anticipate constitutional compliance now. The entire Constitution is backstopped by you go to court. At the ultimate and last resort, you have to end up in court. Professor Akil asked the question, what do we do when the courts fail us? So that has been one of the thinking that is driven through some of the thinking here. The second thing that we think about how we want to ensure constitutional compliance is institutions. That, okay, maybe institutions which have been created by, funded by, and supported by the state would be the frontline implementers of the Constitution. Politicians have figured out then that it is easier then that when you capture the institutions, you have then blocked a key mechanism for constitutional compliance. So how do you backstop that again? And the third mechanism within the constitutional framework is this question of administrative and judicial discretion, which the discretion problem is also one of the areas in which undercuts or perhaps is at the center of some of our compliance problems. So you might take something that we say it's let's say the right to personal liberty. So we say you have a right to personal liberty, then when you apply for bail, we say your bail is dependent on judicial discretion. How is it a right at the same time as one of discretion again? So those are the mechanisms that we are thinking about. Our proposal then is to introduce elements of direct democracy that allows you to circumvent sometimes the courts, sometimes the institutions, and bringing the people directly into the process of constitutional enforcement mechanisms in terms of how we think about it. So let's first take the first proposal around, well, if the courts are our last resort in terms of constitutional compliance, let's take the major constitutional cases that have happened in our democracy. Most of them have been led by political parties. It's the MPP versus Attorney General, MPP versus NDC, MPP versus... There's a reason why the political parties being better resourced, better organized, are the ones who are at the forefront of our constitutional litigation advocacy. What this creates then is that it is only those issues that they deem pertinent will then find themselves of being pushed forward. So now, for instance, if you look at it, a lot of the litigation is focused around elections and electoral processes. And the same kind of thinking also permeates, even in terms of the institution, the conversation is every year there will be a conversation about whether we should change the electoral commissioner. So because the competition is so heightened and led principally by political parties, why then are other actors not being involved in ensuring constitutional compliance through strategic constitutional litigation? If you look beyond the political parties, you might then find an odd lawyer, Martin Kpebu versus Attorney General, or Goni versus this, or Ampofu versus that. It's some few lawyers then who himself, as a part-time pet project, might then do this. So our suggestion is, in order to be able to expand the bracket, we have to identify what are the key constitutional barriers to ensuring that more people are more involved in direct constitutional enforcement. And we are saying that, one, about accessibility then around there, let's make constitutional and human rights enforcement cost-free. Because I'm, for instance, involved in a number of public interest litigation, and we are paying through our nose to ensure that this happens. Then that ultimately then doesn't make it very attractive for us to be engaged in the endeavor of pushing constitutional compliance. It also means then we have to think about cost waivers for public interest litigants in terms of enforcing of Article 2.1, 33, 42, and 130. So 2.1 obviously is about any actions being taken which is not constitutionally compliant. 33 is the human rights provisions. 42 is about right to vote representation, which technically is part of the fundamental rights, but we put it under chapter 7. And 130 is the loop where an issue arises which involves, well, both judicial review and also when an issue arises in any of the courts that requires a reference to the Supreme Court. So anything that concerns constitutional enforcement and human rights enforcement, we remove the costs. Then what about, there's a conversation around one of the problems we deal with, the perennial funding of the independent constitutional bodies is this democracy fund or the independent constitutional bodies fund thing that we're talking about. Can we incentivize public interest litigation then by ensuring that, one, for instance, even your legal costs, once you win a matter, the lawyers that you have engaged to the process, whether the state pays for that, as exists in other democracies, or even your administrative costs of mounting such challenges, can be a way in which we ensure that, okay, if there are democratic expectations that more citizens are involved in ensuring constitutional compliance, then let's make it easier for them to be involved in the process. The second thing that we're proposing is the local standard or the judicial standing restrictions for human rights violations. So now it says you have to show personal interest. Many places are moving away from that. And the effect of this is that only those who can pay for their constitutional violations to be remedied can afford it. NGOs can mobilize and take an action on behalf of a person, or sometimes even as I remember in the question of the Ghana Armed Forces and police services charging Ghanaian citizens for forms for recruitment. When we wanted to take this on and we're asking for those who were affected to come forward, everybody says, yes, take the action on my behalf, I hide my name because I am afraid of repercussion. So then if we then don't have that restriction, we can then be more adventurous in terms of some of the pushback we can have around that. Again, there we have proposed jurisdictions where this happens and also a proposed constitutional clause, how that might look like. The other mechanism that we're proposing is the recall elections as a tool for political accountability. Now, recall elections exist in many jurisdictions, even in Kenya, where we're proposing it now, even at a concept level, for members of parliament and any other elected public official except the president will be subject to this recall. And we have to the people who are elected into the People's Assembly, and even maybe at the district levels as well. We have a whole framework that we have proposed for the committee to look at. The fourth thing that we are asking for is, so we blow up Article 88 and recognize private prosecutions for constitutional accountability and protection of rights. So we used to have this, and it's been taken out of our law. In other jurisdictions still in the Commonwealth, and we have given several examples of this, where private prosecutions are allowed and can be mounted by individuals or NGOs. And if you take some of the data, for instance, in terms of coming from the police between reports and prosecutions, there are types of offenses which are historically under-prosecuted. Violence against women, for instance, is top of the list. So when you have situations like that, well, can women groups then organize and ensure that they can take on that prosecutions? And how do we create a constitutional framework for that? But if you have a language, for instance, which monopolizes prosecutorial power for the AG, then it's very difficult to think outside of the box about how private prosecutions might help enrich constitutional accountability. We can even include and expand that beyond to think about breaches of constitutional obligations, corruption, targeted violence or discrimination or hate crimes, or any actions or omissions that undermine effective enjoyment of fundamental rights. As the type of, so we are categorizing the type of offenses that private prosecutions can be allowed around. Again, as a mechanism then to, one, when the state is disinterested in going forward, persons will be allowed. And this is not far removed from when you take the Martin Amidu cases, where the Supreme Court says Martin Amidu can recover money owed to Waterville because the Attorney General was seemingly disinterested. Then private individuals, there are instances where persons, for instance, even though I have benefited from Nole Prosequi, I don't understand why folks involved in Saglima also benefit from Nole Prosequi. So then maybe we may be interested in taking up that on ourselves, and we can think about whether an incentive can be created for recovery of corruption loot that can be paid to those who are successful in this endeavor, that can cover expenses and also incentivize individual action. I mean, we already recognize some elements of this by citizens' arrest in terms of the criminal process. So it's not far-fetched to say that, okay, if you can arrest, you can also consider engaging processes to prosecute. The sixth one is time-bound mandates for constitutional implementation. So we all obviously love to complain about Parliament for 30 years hasn't done anything about property rights and things like that. Well, why not include 6 months that they have to be done within 6 months? But then begs the question, what happens after? Even if its constitution says within 6 months and nothing happens, then what? I have the experience, for instance, where several of our laws, the constitution says after Parliament is done has to be assented to within 7 days. Well, several of our laws weren't done within the period. Then what is the effect of them? Because there's a constitutional breach. So we have also kind of provided for automatic processes around that. For instance, even some interim measures, one example I will read. We say where Parliament or any public authority fails to enact required legislation within the prescribed time, any competent court may issue interim guidelines, directives, or remedies necessary to give temporary effect to the constitutional provision until legislation is enacted. So it saves you the 20 years that we fought for the right to information bill while we're still waiting for that, and we don't have to be caught into spending so much time trying to get them to do what is already required. The seventh one is we are supporting the recommendation for, first of all, for the Independent Constitutional Bodies Fund, but particularly for public funding for civil society organizations. Now, our biggest concern, obviously, is that the entirety of our civic space is, I don't know whether it's subsidized or entirely funded by the benevolence of Western taxpayers. So we are grant dependent, but if there's a constitutional interest in constitutional compliance and growing our constitutional democracy, then many democracies provide funding for civil society organizations. The question, obviously, is that you don't want it to become rentier, so that those who are serving the state then get paid. Then it means that our pension for ensuring that every body that manages a fund must be appointed by the president or people, we have to blow, it doesn't have to come from those quarters, right? So it can be representation from within the civic space itself that ensures that it's insulated from that. And however money then is disbursed to these processes has to be automatic. But this automatic problem is something that we must deal with across board, whether it's statutory disbursements to MMDAs, to even, if we think about an Independent Constitutional Bodies Fund, it must be tied into the same mechanism to deal with that. But supporting civil society organizations, we think, can better also enhance constitutional accountability. The eighth one around this is the popular initiative mechanisms. So the popular initiative, for instance, when you think about this debate about who can initiate constitutional amendment here, I remember Democracy Hub started mobilizing 1 million signatures for a new constitution. And people said, if at the end of the 1 million, you can collect the 1 million signatures, but it doesn't lead anywhere. And we are saying that, well, if 1 million citizens can petition for constitutional amendment, nothing happens to it, then is it really a democracy? So if other jurisdictions recognize ability to initiate constitutional review processes through collection of certain signatures or percentage signatures, that can be applied not only to constitutional amendment, but initiative for law reform. The only catch we have proposed, again, when we go through what we have done, is that there has to be certain guarantees against populism. So, for instance, maybe an initiative cannot abridge existing fundamental rights under Chapter 5. So then we don't wake up under a wave and say that, let's kill all the Jews. And so then somebody sponsors it. And then now that becomes a constitutional amendment. Like Switzerland woke up and decided that, you can't build mosque or whatever. And then it is affecting protected rights. So the way to deal with that is that there are certain untouchables that even the popular mandates cannot touch. And when you come by that. So again, we have proposed, a framework of how that might look like. Then we're thinking about constitutional sanctions for neglect of duty. There's so many things for which there's no sanction for. And this, we think the biggest value add of the committee would also be able to look at several of the provisions and say, where there's permissive language and there's lack of consequence for certain things, can we create consequences for that? We have given some examples here, more generally, and we've given some comparative examples on South Africa, Kenya, and India about how they've dealt with some of neglect of constitutional duty and what the consequences can be. I want to do a last one on that first part, which is the structural commitments. So there are certain, let's take an example about what are some of the things we can say underline our structure, or structurally underline our constitutional democracy. For instance, it's pluralism, party pluralism, one of them. And if it is so, then if you have a situation whereby we have just bipartisanship, does it meet the multi-party democracy that we call it, in effect? Then what duty does it impose on us then if we are not achieving that? Or on this question of separation of powers, like the conversation now is focused on whether we should not stop making MPs ministers, but they're dealing with the problem by appointing them to boards, because we already have a permissive constitutional culture that if we don't bind power, they will do it. So if we have perhaps those commitments becomes commitments to bind power, then we can say that the allowing MPs to be minister is a derogation from the separation of power. It's not a license to even include MPs as members of board. And as I've heard even today, there's some thinking that soon judges will also be appointed to board because our constitution doesn't prohibit it, so power allows it. You know, so these are the dangers which we can't sufficiently inoculate against, but we must be aware of our culture and what are the things that we can commit and say that as for these ones, you can't do things that go against them. In terms of direct proposals for constitutional reform, about some of the intergenerational equity things we're talking about, first of all, we align with many of the proposals for the proportional representation, but we have a different twist. You know, if there's no natural commitment to the first past the post system, why are we trying to force it through the door and say the only way we can correct its effects is a quota system? When we know that history and the practice for many jurisdictions have shown us that first past the post creates the system we have currently. So why don't we move away from that? And we are saying that there's the best member proportional representation system, where if we take the 276 we have now, let's say 138 of that is directly elected. We divide the country into constituencies where people elect them. Then the other 138 is based on the party-list system. So if you have, let's say that 40% gives you 110 MPs, of 40% of national votes. And you go through the direct first past the post and you get 80 ministers. But you made 40% at the polls, then the difference is that there's some 30 that we can then give to you to top up, which is what exists in New Zealand and other places as well. So you have a mixture of the both. So those who are saying that you need somebody to hold accountable at the constituency level will get that. And we can do a lot with that half. We can put into it all the trying to motivate them to be more inclusive with the youth, gender, all of those things within that party list system that will be created to then compensate. So for instance, it also cures against the danger we have now, which is we have a party which is of a 2/3 majority in parliament. So currently now, let's say the MPP got 40% at the polls. 40% roughly, I think, gives them about 113. So if they got 88 from elections, they are then topped up to 113. We remove the implicit danger of one party running away with the entirety of the seats situation. But it also then creates the avenue for other small parties then. If they got 5%, if 5% allows you 13, whether you got no MPs through the first past the post system, you can then get the 13 MPs. Again, we have fleshed that out and we have fleshed it out and shown how this can work, and even given a graph of how that might look like in terms of how the system works other places. We are aligned on the question on the age question, but not for demographic reasons. For us, principally, any age we choose, whether we move from 40 to 30 or 35, is still very arbitrary. On what basis are we choosing this? If we have defined the participation in the political process from 18 years of age, then if an 18-year-old can rally the country, win the nomination, get elected, then they are qualified to rule. So let's leave that to the normal political process to determine whether or not persons can get elected. I mean, after all, if you take parliament now, the age limit is set at 21. There are only 3 years between 18 and 21. But how many people are getting elected anyway? It doesn't fix the problem, and I don't know what we are creating by the arbitrary age that we are putting in there. In fact, there are so many ages in the Constitution that if there's any constitutional indication as to when you need to leave public service, it's 60, but we are not applying that to those who are getting elected. So why that? One of the things that we have been campaigning for is also, well, this is controversial, obviously, reduction of the voting age from 18 to 16. But if we can try that at the district level, maybe, over time that appetite will be great. But in terms of our written proposals, we haven't included the age one on the 16 years old, because we know the temperature of the country as it is on that issue. But we have also given comparative examples that show so many places where it is 18 to participate in the process. And ours for 40 years is among the highest in the world. The next one is what we call ecological sovereignty and natural resource democratization. So it could only be constitutional semantics, but that natural resources should be vested in the people and not the president. Now, this is also kind of important because there has been litigation around this idea that the president has a trust and that we are beneficiaries, but the courts have refused to allow the language of the trust to be used to ensure accountability. So perhaps we need to think about that. It's not doing anything effective because it doesn't mean anything even in terms of when we want to enforce the trust. And so we are proposing some change around there. We're also asking for community equity natural resource concessions. The truth is, there's some level of pushback with the idea that people within catchment areas of resources being exploited should be written into the benefit system. But it already exists with the royalty systems, which is targeted at chiefs. We're asking for some mandatory equity stake. For instance, let's say in mining, if it's happening in Obuasi, then the districts within Obuasi get 25% equity in whatever is going to be done, and that then can deal with the exclusion problems at those levels. Because the truth is, if you look at where all the problems have happened, even as much as we're trying to aggregate it at the national level, the problems arise within the communities which are nearer to the resource exploitation area, that they present specific challenges. And we do recognize that somewhat in terms of our local content legislations that are coming up. So then, the way in which we must secure better community interests in terms of resources that are happening in their backyard will be important. We're also asking for free, prior, and informed consent to be elevated into a constitutional principle in terms of exploitation of natural resources that require that communities, the free, prior, and informed consent of the affected communities must be taken as part of the process. We've also asked for, and again, I'll leave this in there, about some environmental protections that must be made justiciable so that we can then demand, whether it is the expanding rights around climate change activism or climate change protections, that we can be creating some enforceable rights around, not only against the state, but against private companies around here. Then we're also asking for limitations on the power of eminent domain. So the state's power to then compulsorily acquire, well, I say it's more of a restriction on the right to property, and it's not the right to acquire, compulsorily acquire property. That the big thing here is, what we are seeing more of is, because certain private interests want to circumvent the willing buyer, willing seller arrangements, they go to the state, and the state then uses compulsory acquisition to acquire for them for private endeavors, whether it's in the mining sector or whatever. So we are saying that we should restrict it such that when it comes to the state being involved in commercial, even if the state itself or the public-private partnerships and things like that, that compulsory acquisition cannot be used for those ends. It should be used for road constructions, core things, rather than when you want to engage. If you want to enter the market as a participant in the market, then you must play by the rules of the market, rather than use this as a thump against citizens' property rights on that. One of the last one, we are joining Amnesty here on, and this is specific around the right to adequate food. And this is targeted at persons who are deprived of their liberty. As many of you know, if you're in police cells, you don't get fed. And since we are going to, many of our members here are going to be there for a while, it seems fair that we are asked that there has to be a constitutional requirement, whether that expands the provisions on the right to dignity and protection from cruel treatment, or it is recognized separately that persons who have been deprived of their liberty by the state cannot be, we can't create a state-sanctioned starvation program. So that they must be entitled to a right to food, and that the nature of the food that is served also must be looked at. We've talked about adequate and nutritious, some as exist in other countries. But at the very least, we can, if we can't say that the entire population, when they're hungry, can go and knock on somebody's door, at least those who are in the custody of the state should have the right to food.
Okay. We have to leave us time to follow up with some questions, because if you take up,
I have just the last two left. I mean,
last one.
Last one. They are all the last ones now are money related. So the big one is about, well, we're asking for the debt thresholds that the state can commit to, and that there has to be some people's approval process that is ingrained in the process. Now, the big thing, as we know, is the levels of debt which the state can commit us to. And then we carry the burden of paying that forever. If there can be some thresholds by which, whether it is benchmark against the GDP or whatever, where the state, if the state wants to borrow beyond, then they must take the issue to a referendum, then that's something that protects the people's right to be consulted in terms of being indebted. A lot of people are talking about that being a new form of neocolonialism. So if you're going to get into some of this free money in the bond market that are going to enslave us, then the people should have a right to that. And obviously the final one, fiscal decentralization. We don't want to wedge into the conversation yet about, we know that there's a groundswell in favor of voting for MMDCs and all of that. But we say that to make sense of it, we have to have proper fiscal decentralization. That goes beyond the, well, we are asking for 30% here of resources at the national level to be committed. And here we have provided some language that shows that what you can't do is you can't go and collateralize the entirety of the consolidated fund, and then there's no money, you use all to pay debt, and then they can't make statutory disbursements from the consolidated fund. We have to think around those. Thank you very much.
Thank you. Thank you very, very much. Many of the things that you put on the plate for us to chew on have actually also come before us in the various, in the previous forums. So for example, this vested all land and natural resources of the country being vested in the president. That was the very first stakeholder engagement we had on land and natural resources. That issue came up. I think there is some evolving consensus around that issue, that naming the president specifically as the person in whom these resources must be vested is not the proper formulation, and that we should either vest it in the Republic on behalf of the, and then when we do so, or if we do so, to delineate the fiduciary obligations and responsibilities that flow out of that status of being a trustee. So that issue has been mentioned. Just yesterday, we talked about the issue of the debt ceiling, which is also part of the conversation, fiscal decentralization. The eminent domain question, I think if Aikoto was here, there's been quite a bit of conversation around that, and the loophole there being, I think the language is, government may acquire, property for a public purpose, public use, or in the public interest. And that catch-all public interest has become the loophole that is used to do the kinds of stuff we were talking about. So there are proposals around closing that loophole. As well, of course, we've talked about proportional representation. Your take on it is different. I think the first proposal we had from your friends from Economic Fighters League is just a straightforward South Africa style party list. You have a twist on it, of course. Proportional representation comes in all kinds of permutations and combinations. So we would be very interested to see how you plan to operationalize yours. I mean, specifically the mechanism, how you described it, because I think the idea is beginning to gain some currency. People are beginning to catch on to it and like it, but how to operationalize it and also make it simple for the kind of electorate that people think we have. Sometimes you see the ballot designs on these things are a bit complicated, like you have to do multiple ballots and people may not understand exactly what it is that you're asking them to vote for. So we're very grateful for just the number of issues that you have put before us. The Popular Initiative is of course something that the Kenyans have, where by getting a number of signatures you can get citizens also have an alternative way of going around the political class to trigger a constitutional amendment process. So I think that's, I just have two questions. One is and then I think I've seen one memorandum already just on the issue you talked about, changing the local standing rule on Article 33, which currently requires you to be, basically the victim. Only the victim of the human rights abuse can go to the High Court. But I think there's a proposal, and I think it makes sense. I mean, there's one Supreme Court, there's one High Court, of course, but there are so many High Court branches all over the country. And if one has to go to the Supreme Court, if one cannot go to the High Court on behalf of somebody else, who has suffered an injury or who has suffered a threatened injury or whose rights are being abused, but you have to be the person who goes there. Otherwise, you only have Article 2 to go to the Supreme Court. I don't think it vindicates the policy rationale behind lowering actually the bar in Article 2 itself. Right? So I think it makes sense to allow public interest litigation and public interest litigants to stand in for victims of human rights abuses in the High Court and go to the High Court to do that. There's no point really forcing them to find an Article 2 case before they can go to the Supreme Court. So I think it makes, the loser pays principle. So your loser pays idea is interesting, right? So if you bring a constitutional or Article 33 case against the state and you win, then the state takes up it pays your fee. It sounds fine, but don't you think that that could also create, that it could backfire, right? If the court is aware or is conscious that the state is going to pay your bill, isn't it also likely sometimes to create an incentive for the court to actually make you lose the matter, right? I mean, so, yeah, this guy is just annoying, how is he going to get his bill paid? No. So the loser, I just want you to think through it a bit. That would, can you have some data on how it's worked? I mean, I know it works. It works in the US, it works in other places, but is there data on whether or not it's created a perverse effect in terms of, making otherwise successful plaintiffs lose cases just because the judicial system is unwilling to let the state bear the burden of your court fees? I like the idea of private prosecutions. I think that is an important enough issue, especially if you think beyond the criminal context in terms of constitutional enforcement, because we have a system now that basically the Attorney General is the only gatekeeper. If the Attorney General doesn't want to prosecute a matter, nobody can. Even though it's a big, public interest issue, corruption is something that affects all of us. If there's a murder, why should the family of the, of the deceased, if they think they have the evidence to go to court and the AG doesn't want to prosecute, the state doesn't want to prosecute, why shouldn't they have at least a shot at it? Right, so I think it's an interesting, of course, here it will be an interesting new idea, but it's not entirely novel. Other countries have it. One thing I'm surprised that I haven't heard from the youth community is about the right to protest, right? Because in the period in between elections, especially for the youth population, your voice is fine. You still can call, your social media is there these days, so everybody can talk. But the right to protest is one of those things that I think young people everywhere, basically it's like one of their fallbacks. If they don't like what's going on, one of the ways they actually very visibly express it is to get on the streets and protest. And there are a lot of roadblocks that have been thrown in the way of protesters or intending protesters, notwithstanding the constitutional guarantee we have. But so I haven't heard, from a prison graduate like you want a bed with a bed bug in it, but how about if we protected your right to protest so that you don't even get to the prison in the first place? I mean, do you guys have some concrete proposals on how we tighten this? Because, of course, there's a Supreme Court case that says that right is yours. It doesn't belong to the police. But our system somehow has developed a practice, notwithstanding that earlier Supreme Court decision, where they basically nullified, essentially overruled without telling us. The lower courts have essentially overruled the Supreme Court decision on that. Is there something concrete that you and the other youth groups or Democracy Hub has as a way of really reclaiming that right and safeguarding it and tightening it? I think Amnesty also probably has done some work recently on the right to protest, and I think it's an important right enough for young people especially, that if you would want to include it and give us some way of protecting it better than the Constitution currently, or than our constitutional law currently protects it. Thanks.
Thank you. Oliver, I just have a couple of questions for you, but let me say thank you for your presentation. You have so much to chew on. You spoke about constitutional matters in which the cost should be free. But I'm just thinking, have you thought about how to go about dealing with frivolous actions and abuse of court processes? Because we know that we don't have so much in terms of judicial time. So if people would just be mounting actions, there should be a way of dealing with such excesses. The second question is in relation to your mention of the nolle prosequi. And we know that traditionally the AG does not explain himself, although recently we had the AG explaining a couple of reasons why he had to enter the nolle prosequi. In the interest of transparency, is it your recommendation that the AG should explain the reasons for entering nolle prosequi on each occasion? Then thirdly, you mentioned that where we provide time-bound periods for certain constitutional tasks to be performed, if it's not done within the time frame, then a court of law can provide interim guidelines. And let me find out from you, can you be specific? Is it going to district court or you mean Supreme Court in that instance? If you can be clear on that point. Or will it also be a recommendation that you can go to court for a mandamus, for example, as a public right, to compel Parliament in that sense to do what the Constitution mandates it to do? Then the next question has to do with your suggestion of a threshold for debt, and in which case you mentioned that we should go to a referendum. I'm just thinking that will be a very cumbersome process, and I think the cost involved is not one that I think I really look favorably on. And I'm just thinking, is there any other way of getting the public involved apart from going for a referendum? So these are, in a nutshell, my questions to you.
Thank you very much, Chair and Committee, for these questions. On the question of the loser pays conversation and the disincentive it creates. The truth is that every time we appear before any court, we are we are arguing against the judge and the state on the same side. So the risk is that, then the risk seems cultural. And to be honest, I don't know how we deal with that, because it's essentially trying to use the Constitution to cure the people. And I don't know how we can cure something which the constitutional and democratic culture itself seems deficient at source. So the risk exists, and I concede that, I can see it as well happening. The right to protest, it's this question as to whether or not there's a constitutional issue problem, or it's an extra constitutional statute, practices, and others. And whether in some of the problems we're seeing, are there examples where the peculiar problems we have, the constitutional framework can be expanded to cure it? Now, even if we came out and detailed it out, I am certain they will still find ways for it going forward. So that's why, we are working, for instance, with Amnesty regarding, dealing with the Public Order Act question on the legislative level. But I still don't know, because short of blowing up entire Chapter 5 in terms of even structurally how it's organized needs a lot of work, and I don't know how we can do that, at the constitutional level to deal with some of the peculiar problems. So that's why we haven't raised it here, because we feel like there's enough constitutional protection on the issue, but that when Parliament intervenes, it waters it down, and then the courts themselves are even send the standards into the sand. So we can deal with it in the terms of why everybody here appears and asks for certain things that are already in statute to be in the Constitution, that perhaps that might incentivize more respect for it, and that can be it. But we don't know. Personally, I don't even know how we can cure the danger at the constitutional level, short of further anticipating some of the problems that we currently have and preventing it, for instance. The cost-free frivolous actions question. I feel like there's unless we think of the current cost system, money system, is it designed to stop people from coming to court? I don't think that, it has never been suggested that that's the rationale for why people pay, as to weed out frivolous applications. But even the judicial process deals with frivolous actions. You can throw it out, you can do all kinds of things with it. And I think the problem we have is there's so few of it that if we go to a place where a lot of frivolous actions were happening, then it's better. I'd put down something here where I was talking about, we want to create, the Constitution should create allies of constitutional busybodies. The more constitutional busybodies we have, the better for rights enforcement, rather than the current situation where there's a paucity of such actions that are going forward. And in the same way, for instance, if you think about some of the ones which, well, I don't know whether our politics get so many people to apply for, removal of whether judges or persons in independent constitutional bodies. Well, there's a prima facie requirement which is supposed to be a barrier of sorts. Then is there a judicial barrier that become created, which, it exists under the CI, where you can apply for frivolous actions to be struck out? Why wouldn't that be sufficient in that context? But I feel like we should err on the side of more rather than less, I would say.
So in the Kenyan Constitution, on the enforcement of the Bill of Rights, and in the Kenyan case, including public interest and class action enforcement, the Chief Justice is mandated to make rules providing for a number of things, including that there shall be no fee charged for commencing the proceedings, right? So, in Kenya, if it's a constitutional Bill of Rights enforcement action, at least, you don't have to, there's no barrier in terms of a fee on the front end. You pay your fee, you pay your legal fees, I suppose, but at least not a barrier to commencing the action. So it's doable.
On the nolle prosequi, so one of the accommodations we're having is that there's a real, and I talked about the discretion problem, that the Article 296 approach, which is kicking the ball down the road for other people to then spell it out, well, we do have the Code of Conduct for Public Officials that existed in the Constitution. Why can't we then expand on 296 in terms of the benchmarks for our discretion that deals with all those fall under 296, what we're expecting them to go and do later on, do it now. So then that takes care of the nolle prosequi conversation. That is not then focused on only whether the Attorney General should explain, but in fact, every person then who is exercising a discretionary power should be able to explain. The bigger question, for instance, even in terms of prosecutions, which we have considered before we even came to private prosecutions, and the gentleman here is, many of you know Machoka, the country activist was killed. This is the cousin. What's coming from Nigeria? Whether or not we can take the Attorney General on for refusing to prosecute. Can you litigate that? The courts are saying no. It's a discretion and he exercises it and it's not constitutionally impeachable when he fails to. But if it's a discretion, then it must be, there are certain benchmarks so that failure to prosecute itself can be litigated on. So if we can't get that, explanation can be, whether his explanation makes sense or not, he gets away with it. But then what do we do when the explanation does not make sense? The time-bound enforcement. You said which court? To be honest, I would have preferred a situation like the American situation where every court has the power to pronounce on the Constitution. And if it is wrong, we diffuse that power across the entirety of the judicial system. Then if it is wrong, you go through the normal appeal process. We don't reserve it then for one body, which for the most of time, let's be frank, it's not like they're getting it right all the time. So it then shares the burden across the entirety of the judicial system without a particular court. So that thinking then means that you can then go to any court and seek enforcement rights, and then we don't create specific courts that limit access on the debt threshold one. Well, what is more expensive? The current situation we have, where every debt goes, till we get to the point where we are locked out of the bond markets, meaning that the lender is deciding for us whether or not we can give you more, or we the citizens are put in the position to be able to stop the tap at that point. And I feel like it is more expensive. The current system we have now is more expensive. And if we want to be committed to it, the point is to disincentivize them going for the referendum even. So we have to manage debt sustainably, that you don't come and knock on the people's door to approve you acquiring more debt. It's the rationale behind, the debt threshold. Because if you put, for instance now, if you put the debt threshold in statute, you then amend the statute in terms of the cap, and then you go away with it.
You require a supermajority to approve it.
So a supermajority can be away, but then the supermajority then has to be constitutional.
Sure. I mean, if you have it in the Constitution, that it has to be by a supermajority.
If you have a supermajority arrangement, I think that could work as well.
Yeah.
As opposed to knocking on the people's door, yeah.
Okay, Mr. Chair, let me ask one more question and I'll be done. Oliver, you just made a point about going to any court to enforce any breach of the Constitution. We here have toyed with the idea of having a constitutional court within the Supreme Court structure. What is your take on this matter?
So that structure is a very French system. But the French system also is not only lawyers who are there. It's almost like the kind of composition we have apart for the Council of State, who are making those decisions in terms of constitutional court.
No, I think in this case, the formulation is like a bench, a constitutional bench on the Supreme Court.
Yeah.
So you have in the Supreme Court, you split it up into a constitutional division or an original jurisdiction division and an appellate division. And the constitutional division does all the original jurisdiction constitutional cases.
So I remember when we had the former Constitution Review Commission, that ultimately the decision was that empanel 9, as existed by practice, as a way of this idea, and then we were also thinking about that there could be divisions based on the requirement to empanel 5 for the different cases, then that could be created. But then that means that we have to significantly increase the number of people who are on the Supreme Court. It can't be in the current situation. And that's one of the proposals we had made then was, well, the bigger question is also, about the number, because we have an automatic right to the Supreme Court, then all interlocutory matters should end at the Court of Appeal, and that becomes the final court for interlocutory matters. And then the court then is insulated from or being inundated from the number of cases that any arrangement, because I mean, we have said when we put together the case for a new constitution, that the unanimous FC is also a function of an overworked court. That nobody wants to continuously be writing for several cases within the year. That breeds, I agree, and then limit your workload. So if we can itemize certain things that don't go to the Supreme Court, we already have an example, for instance, the parliamentary disputes that end at the Court of Appeal, then we can extend that thinking to other matters, then reduces the pressure and then allows the panel or bench idea also to go to full effect. Thank you.
We cannot deny the other participants the right to respond. If you have questions, comments you want to make before we call it a day, please, you are... is that Noah?
So just something along the line of what Oliver said earlier concerning the creating a right to food for people who are arrested or are detained by the state. So I think yesterday, myself and Victor, we were thinking along something of really entrenching the idea of pretrial rights of persons who are arrested. And so whether we will create it under Article 19, which is part of fair trial, so that, for instance, we constitutionalize Miranda rights properly under our Constitution. For example, I have seen situations where people are arrested and then their lawyers do not even have the chance to have private discussions with them. Okay, so this becomes a very huge problem and an infringement on their right to fair trial. So is there a way we can address these issues specifically within the right to fair hearing under the Constitution? And one other issue is currently there is a clear incentive to breach the rights of people in an attempt to gather evidence by our enforcement and the security agencies. A typical example is how the Supreme Court or the courts in Ghana have gone around the idea of excluding evidence illegally gotten by security agencies. Now, the court will tell you, well, all rights are not absolute, and we have to do a balancing test, and we look at your private interest and that of the public. And always the public interest will override your interest if it is a matter of criminal law. So then immediately you hear them saying, your rights are not absolute, then you know that it is definitely going against you. So there must be a way, like what the US has done. So in the US, they have created a system where they are balancing rights, but they tell you that there are specific factors the court will take into account. So for example, the good faith doctrine. They have itemized these things where if the state agency does not meet any of this, even though we are doing a balancing test, it will go against the state. And their policy rationale is that places a duty on the state to refrain from breaching the rights of people under the guise of we are gathering evidence. With the free reign that our police has now, they just come into your house with or without a search warrant, they beat you here and there, they take things. Sometimes they take your phone, they don't go even to the courts for any order. They delve into the phone, do whatever they want to do, and come out and say that we have evidence. The court says that, well, it's in the interest of the public for a criminal to be behind bars, and therefore we accept this evidence. So there's an incentive for our police force to breach rights just in claiming that they are doing so in the interest of the public. So maybe under our Constitution, we can find a way to create that philosophy for our enforcement agencies, where they do not say that, well, we can do whatever we want to, but there is now a duty on them that if they go ahead to do this, that evidence will be excluded. Then that prevents them from doing what they want to.
So you should take a look at Article 49 and 51 of the Kenyan Constitution, if it helps with the argument you're making. They have rights of persons detained, held in custody, or imprisoned. There is a particular, there are particular rights for those. and then rights of arrested persons, which includes all the Miranda rights you are talking about. Now, the philosophy question in terms of how the courts perceive these things, actually the speaking about the limitation clause. Article 21(4) in our Constitution, if you found it somewhere else, it will be called a limitation clause, right? The limitation clause is a response to this point about no right is absolute. Actually, what limitations clauses do is to tell the judge or to tell all of us that no limitation of a right is absolute. So actually, what we should be, the psychology, I mean, the philosophy that the modern constitutions and limitation clauses are trying to put out is that the scrutiny is really on the limitation that they are trying to place on your right. That is where the attention should be. The focus should be, are you restricting this right beyond what is necessary to achieve the goal? Because the right must come out intact. At any given time, when right, it's restricted only so far as it's necessary to achieve the limited goal for which you need to restrict it. But it must not eviscerate the right. That philosophy is, I don't know if it's because of the constitutional phrasing of the limitation clause, if it's a jurisprudential problem, if it's a legal education problem, I don't know. But I know that it's a pervasive view in the judiciary, that when they come to an issue like this, the first thing they'll say, my rights are not absolute. But restrictions are not absolute either. In fact, rights are more absolute than restrictions. And it's that kind of switch is what is a difficulty. And in that case, I think how we write it helps. The way that the South Africans have done it and the way the Kenyans have done it, leaves no doubt that the rights is primary and the restriction is secondary and cannot subvert the right. But unless you do it that way, we're going to end up with this, philosophy. You write it, the Constitution has been there since 92. Still, people think it's a clawback clause, and you just, and you give it with your left, you take it to the right. But that's not the idea. So maybe more elegant writing might help, but I don't know. I mean, the same way Oliver thinks you can write and write and write, and the philosophy is still like that. The approach to it. But I think it's something that needs to be, through different ways. Legal education is one of it. Civic education. Including, making sure they are. I don't know if that will cause more people to want to go to prison, because Charlie, the these days, So, I mean, the prisons people will tell you, some people, when it's time for them to leave, they are like crying. They don't want to go. You don't want to go home because there's nothing they are going home to. So if you turn it into a hotel and they are enjoying the food, into yeah. So, but
Prof, I just wanted to make some additional comments in relation to what Oliver said and what Noah contributed. And it's in relation to the issue of Article 23. And Article 23, and we submitted the memo on Article 23, how we want it to be restated. The issue of the traffic at the Supreme Court, which is one of the reasons why the issues having to do with how do we restructure the courts, because the courts has too much to deal with. I believe that when we work on Article 23 to deal with what Oliver is saying, because, I mean, people in Sisala West are not really going to litigate whether or not the president can appoint a certain person or whether the president can remove a certain person. They are more likely to litigate whether a road construction can pass through a certain community and whether a certain water body can remain sacred, or the state can convert it into something else. Now, those are administrative decisions that affects them at the local level, and those things will trigger constitutional litigation across board. And so that's one way we can decentralize constitutional litigation and take it down at the local level. And just one last idea on the issue of the traffic at the courts. Oliver hinted at this issue of the Court of Appeal becoming a terminal court. I mean, it's done elsewhere, right? So if you have right now we have a three-member panel at the Court of Appeal. Why can't we create what the Americans have, the embank panel? So if the three decide and you are not happy, we add 2 more judges. It's a 5-member panel. Then the case terminates.
These days, when we are discussing democracy, don't bring American please. We are way ahead of them.
Yes, but that is true. But there are ways in which we can. It's just a point about there's a way we can stem the traffic to the Supreme Court, and that's just one idea.
When you say decentralized constitutional adjudication, you want all the courts, you want the High Court to have general jurisdiction, including constitutional matters.
Once the question is about whether administrative decision is fair, reasonable, or violates rights, it triggers the questions generally. And
so in addition to the human rights jurisdiction, yes, you want to add administrative justice. Yes. I think it makes sense, right?
23 is under Chapter 5, but I mean, what he's suggesting is even expanding 23,
right.
more, making it more robust, because you're already there. The question is really the question of judicial review.
That's right.
You know.
So you are saying, let me understand you, beyond the Bill of Rights enforcement, you want High Court judges do much every.
Yes, to the extent that they come from emanate from administrative processes decisions, administrative rulemaking, administrative adjudicatory decisions, and regulation. All these are the things that actually affect people on a day-to-day basis, right? So road construction, for example, they can say they want to take a road through a certain forest that a community believes is sacred. Can that decision stand vis-a-vis the community interest? That is an issue that will require a judge in the High Court in that particular area to inquire into what the constitutional meaning of those rights are and what the authority of that particular administrative body is, and do that balancing act and come to a certain conclusion.
But I thought Oliver's response to that is that that's already, to the extent that it's caught in the Bill of Rights provisions, then it falls within the jurisdiction of the High Court judge anyway.
In the memo we submitted, the thing we were trying to draw attention to is that because of the way Article 23 is written, the focus is on you have to wait for your right to be violated first, and then you have a right to respond. But if you rewrite it to sort of make it like a due process clause, that before even the decision is made, whilst the decision is being made, you have to take into consideration a person's rights. Then the issue becomes the decision that you took, the process that you have brought about, or the regulations that you have made, even before they violate my rights. I think that they can potentially violate my rights and so on. So that's the way we know that Article 23 is still. The argument is to restate it, to bring the emphasis to rights before they are violated, instead of given a right to redress after they have been violated.
First presentation, I suppose you think that we have this obsession with regional balance. Well, not obsession, not your word, but that somehow we talk a lot about regional balance, but not about any other balance, right? And you coined the phrase inclusive balance. Were you talking about, so beyond looking for regional balance, and it goes back to the Youth Manifesto, is it like youth balance, gender balance, that we should balance things broadly across multiple demographics, is that the idea? And just fix just everything we tend.
Yes, I think the simple answer is yes.
Yeah.
The second point is, what should go into the consideration mix. So if it's men, default, women, persons living with disability, we can agree on 4 things that are now a bouquet of our balance.
Okay.
Because this regional issue has come up, there's some issue around this, for instance, the creation of regions and districts, which we have tied to almost that there's an ethnic justification for. Whereas if we should accept the constitutional premise of trying to create a melting pot, it should be invalidated if you're using ethnicity as a justification for creating a district, constituency, or region. And it doesn't appear that Article 17 allows us a window to be able to challenge decision makings which are justified on the basis of ethnicity. And I don't know where that would go in terms of to disincentivize the state for making ethnic-based decisions in terms of some of this, how we structure the administrative state. It doesn't, I mean, that Article 17 is talking about no person shall be discriminated against on the basis of. Now, if the state says I'm creating a region for another, are you discriminated against? In fact, the way in which they dealt with practically in terms of the last region, they just decided that only those who are affected by it are those ethnicities that are going to vote there. Nobody else is affected by it. And when this was some people attempted to litigate this, the court almost essentially said, it almost treated it as if it's a political question and refused to inquire into the reasoning behind it. So I don't know, in terms of going forward, whether it also helps solve this persistent ethnic-based clamor for districts, constituencies.
Article 17, I mean, the provision under Article, I think 17.3, that allows, notwithstanding 17.1, it allows government right, so for the purposes of 17.4, nothing in this article shall prevent for making different provisions for different communities having regard to their special circumstances. So, I mean, that provision is basically what allows affirmative action, notwithstanding 17, that you could use, right?
Yeah.
Well, Article 17.4 is the exception to Article 17.1 and 2, right?
So, one of it's in a region, is it that other ethnicities were given a region based on their own ethnicity? Yeah,
I see your point. This whole ethnic balkanization that, well, I created this base following the process in the Constitution, insisted with clarity, right? If you have something for us, you have an idea and you want us to take a look at it. But for this kind of exercise, a lot of the ideas we are putting out, we would not be able to sit in the committee and generate it. You know, a lot of things you put out are totally innovative, totally interesting. We would not have had the benefit of those ideas if you didn't bring them before us. So we thank you very much for making the time and the effort, and we appreciate it. Thank you. We will be back next week. We will take a break the rest of the week, and we will be talking anti-corruption hopefully on Monday, but we will communicate that publicly.